Good morning. The Senate will come to order. The senators will please take their seats. Those persons not entitled to the privilege of the floor will please retire to the gallery. The senators and all in attendance, please stand. We will be led in prayer by the Reverend Charles Phillips of Rosewood Presbyterian Church in Prince George. Following the prayer, everyone will please remain standing and be led in the Pledge of Allegiance to the flag of the United States of America by our Senate page, Taha Bhatti of Chesterfield.
As our country stands perhaps on the edge of war, or at least a war that's about to break out, I would urge you all today to pray for peace and not for war. Let us pray. Father in heaven, not at all sure that we all agree about who you are or even what to call you, but here we are again, acknowledging that we need a power and a wisdom higher than any of us possess in order to do this job. We are formally asking for your presence on this day in this place. We in this room also acknowledge that no one here is perfect, but we have been sent here by the people and by you to do some good. In this room, help all who are here to remember that they have been given great power and great privilege by you and the people who want good to be done. Father, you know better than any that sometimes, maybe oftentimes, there is disagreement in this room about what is good. We are asking you, our higher power, to help us work out these disagreements to your satisfaction and according to your will. We also ask you that in the midst of our disagreements, help us to remember that what we always have in common is that you love each of us, even when we are arrogant and even when we are wrong. So, Almighty and eternal God, as this session begins today, I ask for your powerful presence to guide these powerful people to discover your will for the people. I am asking you to give these senators a proper understanding of their role and significance in doing the good that they are here to do. Guide them to not take themselves too seriously, but to be serious about doing for you the good and for the people. Guide them to love one another as you love each of us. Bless this powerful group to carry your spirit of grace and humility toward each other, so that the division and hate in our state and nation can be healed. Give them a passion to be servants to the people who sent them here to serve. And by the end of this day, and every day, use each of us to do the good that you have intended for us to do. Can't do this important job without your help. That is why we have asked for your help. In Jesus' name, I make this request and prayer. Amen.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
clerk will call the roll. All those present, please vote aye. The clerk will close the roll.
You have a quorum, Madam President. Senate Journal for Monday, February 14, 2022.
The senator from Western Fairfax County, Senator Marsden, moves that the reading of the journal be waived. All in favor of waiving the reading of the journal will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 34, noes 6.
Ayes 34, no 6. The reading of the journal is waived. The clerk will report any communications from the House of Delegates. Chair recognizes the senior senator from Fairfax County, Senator Sasslaw.
Madam President, I move we waive the reading of the communications from the House.
The question is, shall the reading of the communication be waived? Those in favor of waiving the reading of the communication from the House of Delegates will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 32, noes 6.
Ayes 32, no 6. The reading of the communication from the House of Delegates is waived. The clerk will now report any communications from the governor.
We do not have any, Madam President.
Now comes the time in the morning hour when we get to hear from and hear about our wonderful guests in gallery. Thank you for coming to hear your Senate in action. And so with that, the chair now recognizes the junior senator from Richmond City, Senator Morrissey.
Good morning, Madam President, and thank you.
Good morning.
Madam President, on behalf of the senior senator from Richmond and myself, we would ask the entire body welcome Pastor Reverend Charles Phillips from the Rosewood Presbyterian Church in Prince George County. He pastors a church in Prince George County. He resides in Henrico County, and he delivered the very inspirational words this morning. Pastor Phillips earned his master's degree from Gordon Conwell Theological Seminary in Massachusetts. He has pastored several churches, including Overbrook Presbyterian Church in Henrico County and currently Rosewood in Prince George. He is a fourth-generation pastor, and his son is also following in his footsteps. With that, Madam President, I'd ask that the Senate give a warm Virginia State Senate welcome to Reverend Charles Phillips.
Reverend Phillips, please stand, and thank you again for that prayer. We all acknowledge the faults that are within ourselves, and so we thank you for that reminder. And senators, let us give him the warm welcome of the Senate. The chair now recognizes the senior senator from Virginia Beach, Senator DeStaff.
Madam President, I rise for an introduction.
Senator has the floor.
Madam President, I'm pleased to introduce to you the distinguished group of high school students from 11 Virginia Beach public schools. One young man, one young woman from each of our cities' senior class has been chosen by their school counselors as the outstanding seniors of the class of 2022. By reason of their demonstration of excellence in the following 5 attributes: character, community service, extracurricular activity, citizenship, scholastic achievement. These young men and women who will be our future leaders are sponsored by the Optimist Club of Virginia Beach. You may see them in a committee meeting later today, taking a guided tour of the Capitol and the Supreme Court. They're looking forward to a session with the delegates and senators with their respective districts. Madam President, they're also joined by Les Cox, who's an attorney and president of the Optimist Club, Carolyn Cox, who's an attorney and the vice president of the Optimist Club, Robert Dean, a libertarian and patriot, Robert Dadamoff, who's a retired aircraft pilot. So with that, Madam President, I hope we'd give him the warmest regard of the Senate.
Good morning to you all. And thank you for your service thus far. And we're looking for great things from you. You've already demonstrated that you have the leadership qualities that are necessary for our country to continue to thrive. And so thank you for getting involved, for your community service, for your service to others. And thank you, adults that are with you, for being part of helping them to become who they will be. And senators, let us give them the warm welcome of their Senate. The chair again recognizes the junior senator from Richmond City, Senator Morrissey.
Madam President, I mispressed the dial. I don't request to speak.
All righty. Is there any other business to come before the morning hour? Hearing none, the clerk will now proceed to call the calendar.
Senate calendar for Tuesday, February 15, 2002. Regular calendar, Senate bills on third reading. Senate Bill 457, dogs breeding dogs for certain research prohibited penalty, reported from the committee substitute, has been adopted by the Senate.
Chair recognizes the gentlewoman from Northwestern Fairfax County, Senator Boysko.
Thank you, Madam President. I move the bill pass and speak into the bill.
The senator has the floor.
Thank you, Madam President. SB 457 would prohibit any person from breeding a dog or a cat for the express purpose of producing offspring for use in research, experimentation, or testing, if triggered by a receipt of a citation for a direct and critical violation from the U.S. Department of Agriculture pursuant to enforcement of the Federal Animal Welfare Act or regulations adopted there under on or after July 23rd, and I hope the bill passes.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill passes.
Senate Bill 741, facial recognition technology authorized use. Committee substitute has been adopted by the Senate.
The senator from Eastern Fairfax County, Senator Surville.
Thank you, Madam President. Can I go by temporarily?
Without objection, the bill goes by temporarily.
Senate Bill 4, Emergency Services and Disaster Law, limitation on duration of executive orders.
The gentleman from Roanoke County, Senator Suderline.
Thank you, Madam President. I move that the Senate agree to Senate Bill 4. And speaking to that motion, Madam President.
The senator may continue.
Thank you, Madam President. Senate Bill 4 is an important bill to restore checks and balances here in the Commonwealth. The vast majority of our sister states and the District of Columbia require legislative approval of extended emergency orders, with the whole idea that an emergency is actually an emergency, that's something that's just happening immediately, not a serious thing that continues. This bill would require legislative approval for any emergency order to extend beyond 45 days. I hope it will be a pleasure of the Senate to pass the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 29, noes 11.
Ayes 29, noes 11. The bill passes.
Senate Bill 31, Virginia Land Conservation Foundation and Fund, appropriation for fund and budget bill, etc.
The gentleman from Western Fairfax County, Senator Marsden.
Thank you, Madam President. Speak to Senate Bill 31. I move that the bill pass.
The senator has the floor.
Thank you, Madam President. This bill makes several relatively small changes to what is fundamentally a successful program. The Virginia Land Conservation Foundation has provided grants for over 20 years protecting working and natural lands across the Commonwealth. What the bill does is several things. It allows for additional tribal participation and eligibility for grants by adding a tribal member to the board of the VLCF. It also adds flexibility. Currently, an easement acquired with VLCF dollars must be co-held by a public body, and any land acquired must be protected by a conservation easement held by a public body. This bill would allow accredited land trusts to hold easements without a co-holder and would allow VLCF to accept a reversionary interest rather than requiring a publicly held easement. The land trusts did not have this capability before, and now they do. The other thing that the bill does is it requires the board to do an annual report to include goals and funding needs for each type of land eligible for grants, as well as underserved communities. And finally, it removes a provision adopted in 2019 that requires VLCF to hold grant rounds in advance of appropriations being made, and the agency's been unable to implement this provision as intended. Kind of put the cart before the horse. Madam President, that is the bill, and I reiterate my motion that the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 33, noes 6, Rule 36-1.
Ayes 33, noes 6, Rule 36-1. The bill passes.
Senate Bill 120, Public Utilities, Waste Coal, and Certain Coal-Fired Electric Generating Units.
The gentleman from Tazewell, Senator Hackworth.
Good morning, Madam President. I move that Senate Bill 120 pass and speak into the bill.
Gentleman has the floor.
Senate Bill 120 is a bill that would direct the Department of Energy to conduct a study to identify the volume and number of waste coal piles. And I'll answer any questions that if not, I will move that the bill be passed.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill passes.
Senate Bill 134, Juvenile and Domestic Relations District Courts raises maximum age for delinquency matters. Reported from the, never mind.
The gentleman from Roanoke City, Senator Edwards.
Madam President, I move that Senate Bill 134 pass. And by way of explanation?
Yes, sir. The gentleman has the floor.
This bill would raise to age 21 the delinquency age for the Juvenile Domestic Relations District Court. First, research proves that young adults 18 to mid-20s, sometimes called emerging adults or young adults, often show immature judgment. While cognitive abilities mature around 16, social psychological development is delayed until the mid-20s. We know this because research shows that the judgment factors of the brain, which have been studied by Harvard for 40 years, and in Roanoke, too, at the Research Institute, does not mature until about age 24. We know where it is. It's up here in the subfrontal lobe of the brain. As a result, emerging adults of this age tend to be impulsive, tend to take unwarranted risks, are less able to consider the long-term consequences, seek sensation activities, and are unduly subject to peer pressure. In recent years, neurological and social psychological research confirms what parents have always known. These emerging adults are less competent to make good decisions as adults. At the same time, emerging adults are more amenable to reform and rehabilitation, which the Juvenile Domestic Relations District Court is better able to deal with. And the military understands this too. I can assure you that that do not want you in the Marine Corps, for example, at boot camp, unless you're 17 to say 22. If you're older, you can think for yourselves, and they don't want you to think for yourself if you're an enlisted man. I know as an officer, they train you differently. They train you to make decisions, but not the enlisted men, because they want them at a younger age where they can tear you down and build you back up in their own image. The protection of the public and reform work best can be done at the Juvenile Domestic Relations District Court. And history would also show that this is the case. In ancient Rome, a young man was not considered fully mature until about 25 years. In 1942, the age of conscription was reduced to from 21 to 18 because of the war. Now, the 26th Amendment says you can vote at age 18, and we, first of all, reduced drinking to age 18. Then we realized we were wrong and increased drinking to age 21, which tells you volumes about the young adults. And I might also point out that increasing the age of delinquency to 21, as was the case many years ago, would not change the ability of prosecutors to transfer a case to adult court. And it's also worth pointing out that the bill would only apply prospectively at the beginning January 1, 2024, and it also would not require any change in previous adjudications that occurred before that date. So with that explanation, I move that Senate Bill 134 pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The bill passes.
Senate Bill 174, Protective Orders, Permanent Contact Between Petitioner and Respondent.
The gentleman from Lynchburg, Senator Peake.
Thank you, Madam President. I rise to speak to the bill.
Senator has the floor.
Thank you, Madam President. This is a very simple bill. I know at one point we had proposed it. It caused some concerns among domestic violence groups, and we have done everything we can to address those concerns. The main concern was that this was a reverse protective order. That is absolutely not the case the way the bill is now. What has happened if you ever work in domestic relations field, man and woman, boyfriend, girlfriend will have some disputes. Somebody may get a protective order out, and that protective order almost always says no contact of any kind, including emails, text, voice messages. And then what may happen, sometimes they'll have a child in common, the person who got the petition out may contact the person by phone or email or text, and so who's going to pick up the kid? Have you got their books? Whatever. Who's going to get them to school? If that person responds by text or email, he has technically violated the protective order. And there's no defense for violating the protective order, and he's given an automatic day in jail if he's found guilty of violating the protective order. What this bill does, it says it's an affirmative defense to a violation of the protective order if the person who got the protective order initiates contact with the defendant. And that's the simple part of this bill. It puts no restrictive measures on the person who gets the protective order at all. I'd ask that the bill pass.
The gentleman from Roanoke City, Senator Edwards.
Madam President, I voted no in committee, and the reason was you don't want to deter.
For what purpose does the gentleman rise?
Yeah, Madam Chair, Madam President, the reason is that the petitioner would be deterred or chilled from getting a petition.
The gentleman has the floor.
Yeah, if the reason I oppose the bill is you're giving the petitioner, you want to encourage to go to court to get a protective order. You're chilling the right to do that, and a good defendant can raise these issues anyway. And so therefore the bill is either unnecessary or would chill a person's right to go to court and protect the person. With that explanation, I hope the bill fails.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 27, noes 13.
Ayes 27, noes 13. The bill passes.
Senate Bill 227, misdemeanor sexual offenses where the victim is minor, statute of limitations, penalty.
Chair recognizes the gentleman from Rockingham County, Senator Obenshain.
Madam President, I move that the bill pass. Speaking to the bill.
Senator has the floor.
Madam President, this bill changes the statute of limitation for certain misdemeanor sex offenses involving children and to provide that the statute begins to run on the 18th birthday of the child. So that the statute of limitation for misdemeanors, most of you know, is 1 year. So the misdemeanor statute of limitation for this category of offenses will expire on the 19th birthday of the victim.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill passes.
Madam President, over here.
The gentleman from Washington, Senator Pillion.
Having voted on the prevailing side of Senate Bill 170, which we passed, Senate Bill 174, can we reconsider that vote so a member can...
I'm sorry, Senator, I didn't hear you.
Sorry. Having voted on the prevailing side to which we passed Senate Bill 174, can we reconsider that vote so a member can correct his or her vote?
The question is, shall the vote by which Senate Bill 174 passed be reconsidered? Those in favor of reconsideration will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill is reconsidered. Senator Peake.
Yes, ma'am. Madam President, speak to the bill. Briefly, I would answer the concerns by the senator from Roanoke City. This really does not chill a person from getting a protective order because it doesn't come out until after the protective order has already been taken out and the person's violated the protective order. Thank you, Senator Pike over there. I move that the bill pass.
Question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 28, noes 12.
Ayes 28, noes 12. The bill passes.
Senate Bill 249, sexual abuse of animals penalty.
The gentleman from Eastern Fairfax County, Senator Surville.
Thank you, Madam President. I move the bill pass. Speaking to the motion.
The gentleman has the floor.
Thank you. And first, also like to thank the senator from Franklin County, who's the only no vote on this. It makes me have to talk about this. So, Madam President, this bill is actually a very serious bill. There's actually, if you look at a lot of research, there's a strong connection between animal abuse and sexual abuse. And current Virginia law really uses archaic language to talk about what animal sexual abuse is. This cleans that up. Also, current law does not penalize individuals who are themselves not the abuser of an animal, such as those who solicit or allow others to abuse their own pets. Current law also lacks authority and procedures such as seizure and disposition of animals, and like women and children, animals can be trafficked for sex and used in pictorial descriptions, and this all prohibits that. So basically what the bill does is it makes it clear that anybody who traffics in animals for sexual purposes are now going to become felons. It basically makes animal porn illegal. It also says that anybody who's convicted of this can't own an animal the rest of their life. And I would submit to the body that we heard testimony in committee from people, from detectives who talked about what they find when they go into homes, when they deal with child pornography and other serious situations, and they often find lots of information, documents, pictures, issues regarding animals, but they can't do anything about it under current law. This would change that. This basically brings our law up to speed with what it is in other states, and I would hope we could pass the bill.
Chair recognizes the gentleman from Franklin County, Senator Stanley.
Thank you, Madam President. Speaking to the measure.
Senator has the floor.
Thank you, Madam President. If you noticed my vote in the committee, that's what happens when you give your proxy to the senator from King George, Richard Stewart. So the lesson, Madam President, is never, ever give your proxy in the Judiciary Committee to the senator from King George, because he will make you pay. Madam President, seriously, this is a very good bill. Quite frankly, I think, as has been stated before, those that engage in this type of perversion harm children, harm people, and quite frankly, what has been a problem for a lot of law enforcement is that we don't have laws banning this. This is a good thing, a good bill, and a good measure. And I didn't vote against it in committee. Thank you, Madam President. I hope the body will pass the bill. Thank you.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill passes.
Senate Bill 310, plastic firearms and unfinished frames, etc., manufacture, import, sale, transfer, etc., penalties.
Gentleman from Alexandria, Senator Eben.
Good morning, Madam President.
Morning.
I move the bill pass, and speaking to that motion.
Senator has the floor.
Before I talk about what the bill does, I want to talk about why the bill is necessary. This deals with the parts and kits used to build ghost guns. It fixes a loophole. Manufacturers are currently required to put a serial number on finished firearms, but not on individual parts. This bill is not targeted at finished guns. It's targeted at the parts and the kits that are used to build them. The bill does not capture currently put together guns. It requires manufacturers, dealers, and distributors of these undetectable parts to put a serial number on them. The bill only addresses the unfinished frames and receivers. It's easier to build a ghost gun than to assemble an IKEA dresser. And these weapons are particularly enticing for people who would otherwise not be able to pass a background check, like domestic abusers, minors, or violent felons. Ghost guns have been used in a series of horrific mass shootings, including, I'll just mention two. In 2017, a man under prosecution for multiple crimes killed 6 people and injured 10 in California with 2 assault-style rifles he assembled using parts ordered online. And in late 2019, a 16-year-old used a ghost gun to kill 2 students and injure 3 others at Saugus High School in California. He was too young to legally purchase. And there have been many more instances, including shootings of law enforcement. The ghost guns put law enforcement personnel in significantly more dangerous and difficult situations dealing with untraceable and undetectable weapons. The measures in this bill do not affect legitimate gun sellers. It creates a Class 5 felony for a person who manufactures, imports, sells, transfers, or possesses a firearm that after the removal of all the parts other than a major component is not detectable as a firearm by the types of detection devices commonly used as airports for security screening. And it creates several Class 1 misdemeanors, which are punishable as Class 4 felonies for second or subsequent offenses, making it unlawful to knowingly possess or transfer or purchase an unfinished frame or receiver unless the party is a federal firearms importer who is capable of serializing the weapon. So with that, I renew my motion the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
22, noes 18.
Ayes 22, noes 18. The bill passes.
Senate Bill 348, support orders, retroactivity, areages, parties, incarceration.
Senator Somerville, the gentleman from Eastern Fairfax County.
Thank you, Madam President. I move the bill pass. And speaking to the motion.
The gentleman has the floor.
Thank you, Madam President. This is a child support bill. It only had, I think, 1 no vote against it through the process, or no, I guess 4. But I'll try to be quick here. So the bill does 3 things. It reverses 2 Court of Appeals cases that I thought were wrongfully decided. One of them, the Court of Appeals said that if you file a divorce case in the middle of a juvenile court child support proceeding, then the person who can receive child support loses out on months and months and months of child support, which I think a lot of lawyers thought was the wrong result. Secondly, the Court of Appeals also said that when you file for child support initially, there's usually like a 6-8 month period before you get the final award. You can't get interest on that. It basically made an interest-free loan from child support payors to the payees. So it reverses that. So you get interest from the beginning. The most important thing it does is that it codifies a policy that's required by the Obama administration. Regulations required for us to keep about $75 million of federal funding. And basically, the feds have required us to change the rule that says if you're locked up in prison, a court can treat you as being voluntarily unemployed, which means the court would assume you're still earning the same income you were earning before you went into prison. And the Fed said we can't have that policy anymore. And if we don't pass this bill, it will cost us about $75 million, and thousands of Virginia child support payees will lose their lawyer. So we really need to pass this bill, and I hope we will do so.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 3.
Ayes 37, noes 3. The bill passes.
Senate Bill 352, health care providers and grocery store workers, etc., employers to provide paid sick leave.
The gentleman from Eastern Fairfax County again, Senator Somerville.
Thank you, Madam President. I move the bill pass. And speaking to that motion.
Gentleman has the floor.
Thank you, Madam President. So this bill basically mandates that employers mandate or have sick leave policies for or provide sick leave benefits to grocery store workers and to healthcare workers. And I think with what we just went through in the pandemic, a lot of people came to realize just how essential folks that provide us our food, because they have to go to work every day so we can go and eat even when we're locked down, and those provide health care. And those folks are especially prone to being exposed in pandemic scenarios. It's important that when they're sick, that they're able to stay home and not get other people sick when they're coming to buy food or get health care, and they don't feel compelled to have to work because they don't have sick leave benefits. And basically that's what this mandates. I would just also note that the bill has the clause on it because it does have I think about a $3 million fiscal impact. And so this bill will be subject to further negotiation in the budget if it wants to finally get signed. But that's basically what the bill does, and I would hope we pass it.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The bill passes.
Senate Bill 378, petition for modification of sentence eligibility procedures.
The gentleman from Fairfax City, Senator Peterson.
Thank you, Madam President. Move that the bill pass and speak to the motion.
Senator has the floor.
Madam President, ladies and gentlemen of the Senate, this is a bill that really can be summarized in its title, which is just that, second look. It deals with those persons that are incarcerated in our Department of Incarceration serving long-term sentences and have already completed 15 or in certain cases 10 years of that sentence, meet certain criteria such as having a class level 1 status, not having been convicted of disciplinary violations. And basically it gives them the opportunity to petition the sentencing judge, the trial court judge, and go back and just have a second look. And there's a criteria built into the bill that would allow a sentencing judge to basically take a second look and decide whether or not it's worth reconsidering the decision that was made. There's no obligation. You have to notify the victim, obviously notify the Commonwealth's attorney. All parties have ability to show up. And to be honest, this bill, it really, for lack of a better word, replaces what has become, to some extent, a who-you-know process for pardons. And instead of having a who-you-know process, you'll have a process that's more merit-based. I want to thank Sean Winetta from the Humanization Project who brought this idea for me. Sean was my constituent, served, I believe, close to 20 years for an embezzlement, had the courage to testify in favor, and was a very effective advocate, and I hope you'll pass the bill. Thank you.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 24, noes 16.
Ayes 24, noes 16. The bill passes.
We need to go by temporarily on Senate Bill 391. There is a floor substitute, and it's 461 pages. It's being copied. Senate Bill 394, charitable gaming, registration of landlords, Texas Hold'em poker operations.
The gentleman from Loudoun, Senator Bell.
Thank you, Madam President. I move passage of this bill and speaking to the motion.
The gentleman has the floor.
Madam Chair, this bill is another one of the bills that came out of the working group on charitable gaming and the OISG report on the same subject. A couple things that this bill does is, first off, it requires any landlord leases to qualified organizations register with the department to make sure they know who they are and that there's transparency. They're paying a market fair rate for rent. We found some issues with that, and we wanted to fix that. The other thing we wanted to do in this bill, and it's in a couple places, it's at the very end of the bill, where we specifically state that charitable organizations can conduct Texas Hold'em poker tournaments, not cash games. And that was the original intention when we passed this bill a few years ago, to help charitable organizations replace income that from bingo, which frankly was going down over the years. And this was to seek to replace that income. But we were not authorizing poker halls and open gambling casinos, which in many cases this has become. Very dangerous, considering that there's no standard training, there's no security that would be sufficient to catch cheaters, and frankly, the large amounts of money, just not what we intended to do. And we've had several folks taking advantage of that. This bill will close that loophole and really make it more about an avenue for charities to earn money to replace this bingo money that's going down, but at the same time not create large-scale gaming operations. With that, I renew my motion to pass the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 1, Rule 36-3.
Ayes 36, noes 1. Rule 36-3. The bill passes. Oh. Chair recognizes this gentleman from Fairfax County, Senator Saslaw.
Madam President, I would move that we would stand in recess now until 12:25.
Without objection, the Senate is in recess until 12:25.
Madam President.
Gentleman from Portsmouth, Senator Lucas.
Yes, ma'am. Madam President, before we recess, could we return to the morning hour briefly?
All right. Without objection.
Thank you, Madam President. Madam President, today we have a group of Dominion Energy employees from across the Commonwealth who work in power generation, engineering, regulation, talent, acquisition, renewable energy, and innovations. And they are here to represent the company and to see the process and their legislation and legislatures in action. So, Madam President, if you would mind, I would appreciate it if you would give those members from Dominion working with the energy employees the warm welcome of the Senate.
Will you please stand? Thank you for coming to your Senate, and thank you for the occupations that you're holding, because certainly we need our engineers, our scientists, and everybody else of that ilk to ensure that, well, really, the United States maintains its #1 superpower in the world. So thank you for that. And senators, let us give them the warm welcome of their Senate. Chair recognizes the gentleman from Hanover, Senator McDougal.
Madam President, while we're in the morning hour, could I ask that we give the warm welcome and happy birthday appreciation to an individual that's with us today, Henry Pillion. I'm sure he'll be very embarrassed by this, but his father insisted that we give him birthday wishes.
Well, we will not sing happy birthday to you. Happy birthday to you. Happy birthday, dear. Happy birthday to you. How old are you now? Chair recognizes the gentlewoman from Hampton, Senator Locke.
Thank you, Madam President. Upon recess, if the Senate Democratic Caucus could meet in our usual place.
And we are at recess.
Returning to page 11, Senate Bill 402, Charitable Gaming Board Powers and Duties.
The gentleman from Spotsylvania, Senator Reeves.
Thank you, Madam President. This, again, is a work product of the commission we took over the summer. What this does is changes the Charitable Gaming Board from a policy board to an advisory board in the executive branch of our government. It decreases the membership from 11 to 9 members and moves the power and duty to promulgate regulations related to the charitable gaming in the Commonwealth from the board to the Department of Agricultural and Consumer Services. And with that, Madam President, I ask the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 1, Rule 36-4.
Ayes 35, noes 1, Rule 36-4.
Senate Bill 403, Charitable Gaming, Electronic Gaming is restricted to social organizations, etc.
The gentleman from Spotsylvania, Senator Reeves.
Thank you, Madam President. Brief explanation of the bill.
Senator has the floor.
Thank you, Madam President. This, again, is the work product of the 06 request, and VDAX provided the following observations to us during the summer's work session related to abuse of social quarters and why we have seen these games in bars and restaurants. What this bill does is tighten that up, brings it in alignment with IRS guidelines on and how to redefine social quarters back to what the General Assembly originally intended. It allows some exceptions to that and carve-outs for some of the charities that have come to us out of caution. We don't want to exclude any of our legitimate charities, but it will rein in what we found over the summer to be a lot of fraudulent charities. With that explanation, I ask the bill pass. Thank you, Madam President.
The question is, shall the bill pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 2, Rule 36-3.
Ayes 35, noes 2, Rule 36-3. The bill passes.
Senate Bill 451, Retail Sales and Use Tax Exemption for Essential Personal Hygiene Products.
The gentlewoman from northwestern Fairfax County, Senator Boysko.
Thank you, Madam President. I move we pass the bill and speaking to it.
The gentlewoman has the floor.
Thank you so much. Ladies and gentlemen, SB 451 started out as simply eliminating the tax on menstrual products and incontinence products. However, it now incorporates the senator from Hanover's bill, the senator from Bedford's bill, and the senior senator from Virginia Beach's bill that incorporates the grocery tax exemption. Such sales would still be subject to the 1% local option sales tax. It would provide on February 1st of 23 an allocation of state revenues to fund the distribution to localities for education funding that would have otherwise been distributed to them without the bill. It is still based on school-age population, exactly how the current sales tax is distributed. My good friend from southern Fairfax County, I think, would be happy to answer any questions, but I so move that we pass the bill.
The chair recognizes the gentleman from Fairfax City, Senator Peterson.
Thank you, Madam President. I would ask if the gentleman from southern Fairfax could yield for a question.
Will the gentleman from southern Fairfax County yield?
Yes, I'm happy to yield.
Senator Peterson.
And I would ask the gentleman that one of the critical questions for my area is this idea of the revenue arising from the tax on food, which is distributed based on per pupil. It looks like that's been dropped back into the code on lines 184 through 186, which is under 58.1-61.1. Is that the case?
Senator Barker.
Yes, that is the case. It's basically doing it the way we've done it for years. It's in the code now, so it's not something that's just taken in the budget. And it distributes it based upon school-age population. So.
Further question, Madam President.
Further question, Senator Barker.
Yes.
Gentleman yields. Senator Peterson.
So basically, we're doing now what we did with car tax 16 years ago, which we're taking that amount of revenue and we're basically putting it in the code in a different place under general fund, I guess, where it used to be tied to a specific, well, we're just putting it into the code, basically as a firm commitment.
Senator Barker.
Yes, Senator Peterson. This is exactly what's happening here. It's being put into the code so that it's clear what the distribution will be going forward from here, and it is general fund monies that would replace the amount of funds lost from not continuing to include that 1% tax for schools on groceries.
Final question.
Final question, Senator Barker.
Certainly.
The gentleman yields. Senator Peterson.
I would assume when he meant 1%, he meant 1 1/8%.
Yes.
Thank you. I thank the gentleman.
Right.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 3.
Ayes 37, noes 3. The bill passes.
Senate Bill 463, Campaign Finance, Prohibited Personal Use of Campaign Funds, Complaints, Hearings, Civil Penalty.
The gentleman from Loudoun, Senator Bell.
Thank you, Madam President. Move passes the bill and speaking to motion.
The senator has the floor.
Thank you. This bill is, I will tell you, not a panacea. It doesn't cover every area of the use of personal campaign funds. But what it does, it gives us a great step forward in an area where we have nothing. We looked at this. Frankly, there's many rabbit holes you can go down. If you were to wear a campaign shirt, is that considered clothing? So we took clothing out of this bill, which was originally in it. If you have a piece of pizza at the campaign staff with your staff, is that buying food? Questionable, so we took that out. So we tried to stick to the things that are most egregious. And this bill actually, it's not a catch-all because there's probably many gray area situations. That's why this bill directs the Board of Elections to work with the Attorney General and to make regulations with specific examples of proper use and improper use in response to help the situation. To point out a couple key things, only people who can put complaints in of improper use would be someone who could vote for a candidate, or someone who's given money to that candidate. There are also procedures for false claims. There's a process for investigating claims, and at any point before the investigation is finalized, the person who the complaint is against, who has to be notified right away in the bill, they have the ability to return or pay back the item and the complaint goes away. So we try to put plenty of protections in there to get frivolous, I got you type claims, but again, this is a giant step forward because at the moment we're one of few states that have no campaign finance laws against the personal use of campaign funds. And I think it's critical that we do this. I think it's part of having faith, the public having faith that we're down here not to serve our own purposes, but to serve the people. With that, I renew my motion.
Chair recognizes the gentleman from Eastern Fairfax County, Senator Soroval.
Thank you, Madam President. Speaking to the bill.
The senator has the floor.
Thank you, Madam President. You know, a group of us spent a lot of time over the summer working on this. Senator Deeds, myself, Senator Norman, and we arrived at what I thought was a good consensus resolution to this, which is basically we adopted the federal standards when it comes to personal use. And the reason we ended up adopting the federal standard is because the FEC has issued hundreds of pages of guidance that you can rely on if you have any examples like a T-shirt or a slice of pizza or basically anything else that you're worried about. And unfortunately in committee, I guess there was some concern. People didn't go look to the federal guidance to figure out all the answers were just right there. And so instead of that, the bill got decoupled from the federal guidance and it got deconformed from the federal guidance about clothing, I guess, and food. This bill needs to go back to what we passed out of the joint committee that spent 12 hours working on it over the summer, and it should stay there. And it's my hope, I know that there's not a bill coming over from the inferior body on the western side of this building, but it's my hope that after this goes over there, it comes back looking like the bill that went out of the joint committee that worked on this so hard over the summer, because that's truly the way to solve this. If we invent our own wheel, we're going to be spending decades trying to figure out what it means or getting guidance from the State Board of Elections, et cetera, and that's really the right solution. So I'm not happy with this bill, but I'm going to vote for it just so we get it, keep it going in the process. When you talk to people outside this building, they're dumbfounded that we don't have rules about this. This is a glaring hole that we need to fix, and it should be an easy bipartisan fix. So it's my hope that when it goes over, it will get fixed, so we have something that truly gives us guidance and doesn't create a lot of gotcha opportunities for people out there, Madam President. So I would hope we would support it just to keep it moving.
Madam President.
The gentleman from Roanoke County, Senator Suderline.
Speaking of gotcha, will the senator from Eastern Fairfax yield for a question?
Will the senator yield?
I'll yield.
Senator Suderline.
I would suggest that the Senate is the superior body. Would you agree?
Senator Suderline.
There's no doubt in my mind that this body is the superior body, not only in this Commonwealth, but in the entire United States of America.
That's wonderful.
Senator Suderline. Further question?
Will he yield for another question?
Another question. The gentleman from Eastern Fairfax County.
I'll yield to defend the honor of this institution.
And when we look out this wonderful window, do we not look west towards the wonderful Blue Ridge?
Senator Suderline.
Yeah, I got mixed up. So I was talking about the body on the eastern side of the building. I'm sorry, the eastern side of the building, not the western side. I apologize for that.
I'm very glad we have that clarified, because that is the most beautiful part of the Commonwealth as well. Thank you, Madam President.
The gentlelady from Chesterfield, Senator Chase.
Thank you, Madam President. I rise to ask a question of the patron.
Will the patron of the bill yield?
I yield.
Senator Chase.
Thank you, Madam President. My question is this: is there is still a $10,000 penalty, civil penalty associated with this for violation?
Gentleman from Loudoun.
Madam President, I would answer on lines 458 of the bill, item 4. It addresses this. It says, respondent, if the state board determines by preponderance of the evidence the respondent willfully and knowingly violated any provision of the code, they may repay the amount unlawfully converted to personal use. They may also assess an additional civil penalty in amount not to exceed $1,000 per item found in the provision and not to be greater than $10,000. So there's several different mechanisms, but the per penalty would be a maximum of $1,000, not more than $10,000.
Thank you. Madam President, could I quickly comment to the bill, speak to the bill?
The senator from Chesterfield has the floor.
Thank you, Madam President. Generally speaking, I'm very much in favor of campaign finance reform. My concern is that those in this body, we barely make $18,000 a year. And while I know no one would intentionally violate this, I'm concerned that the penalty outweighs close to almost what we make. So that's why I will be voting no on this bill unless there's an amendment to it. Thank you.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Madam President, would the gentleman from Loudoun yield for a question?
Will the gentleman from Loudoun yield?
Madam President, I yield.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. I want to be clear. Did you say that if an individual files a complaint alleging that you used campaign funds for what some might consider a personal matter, that the complaint could be addressed by repaying the money to the campaign account out of your personal funds?
The senator from Loudoun.
Madam President, to be clear, the only people who can make complaints are someone who could vote for the candidate or someone who gave to the candidate. Having said that, if a complaint is made while the investigation is ongoing, not completed, the candidate or the person accused could choose to either repay for the item or return the item, and then the investigation of the matter would be closed.
Okay. Thank you. Will the gentleman yield for another question?
Will the gentleman from Loudoun yield?
I yield.
Senator Morrissey.
I know I'm getting into the weeds, but I am doing it purposefully. Can you tell the ladies and gentlemen of the body whether or not if I take a group of senators out to dinner wherein we are discussing legislation, if I can pay for that with campaign funds?
The senator from Loudoun.
Madam President, again, there would be avenues to review this by the proper bodies. If a complaint were made, in my opinion, that would be a legal and justified use.
The gentleman yield for a final question.
The senator from Loudoun, will you yield?
I yield.
He yields. Senator Morrissey.
If I go down to Prince George County and meet with some constituents and we eat dinner at Pizza Hut, can I pay for that bill with my campaign account? And I would repeat, I'm meeting with constituents dealing with state Senate business.
The gentleman from Loudoun.
Madam President, to answer the question, you could do that. Again, we took food out of the bill entirely to make sure there could be no confusion in that area. And I would say on the question, on the first question, that would kind of border on the senators about gifts a little bit, but since the gifts would not be coming from a lobbyist or from an organization among a peer, again, I think that would be a legal use.
I thank the senator.
The gentleman from James City County, Senator Normand.
Thank you, Madam President. I rise to speak in favor of Senate Bill 463.
Gentleman has the floor.
Madam President, I associate myself with a comment that the gentleman from Loudoun made, and that this bill is not a panacea. It is not perfect, but it is an incremental movement in the right direction. I further, shockingly enough to myself, associate myself with the comments from the senator from Eastern Fairfax County. I would say, Madam President, that I had the opportunity, and I use that word advisedly as opposed to a privilege, of sitting through many, many hours this summer as the Joint Commission examined a number of campaign finance-related issues. And I would say, with all due respect, once again, this is not a perfect solution, but it is a movement in the right direction. And we had a bipartisan collective group that spent more hours examining this issue than the aggregate of everyone in this Senate body. So I would ask the body to support the bill as a movement in the right direction, recognizing it will have to evolve.
The question is, shall the bill pass? Those in favor will record their votes aye. Those opposed.
Madam President.
The gentleman from King George, Senator Stewart.
I apologize, Madam President. I was a little slow on the draw. Would the gentleman from Loudoun yield for one more question?
Well, gentleman from Loudoun yield.
Madam President, I yield.
Senator Stewart.
Thank you, Madam President. I'd ask the gentleman, line 348, if I read this correctly, you can pay for I'd use the generic term, a babysitter, when you're either campaigning or even after you get into public office with campaign funds. Do I read this correctly?
Gentleman from Loudoun.
Madam President, the way I would read it would be for someone, if they're a candidate seeking office, either for themselves or for a campaign worker, and that was the way it was intended.
Madam President.
Senator Stewart. Further question?
I draw the, yes, would he yield?
Will the gentleman from Loudoun yield?
I yield.
Senator Stewart.
I draw the gentleman's attention to line 348 to 349 for dependent care expenses that are incurred as a direct result of the person seeking, holding, or maintaining public office. So I would ask the gentleman, could you not, pay for a nurse, a sitter? There's a variety of things you could pay for out of campaign money while, for instance, we're here on the Senate floor. Could you not? Today, after already being elected.
The gentleman from Loudoun.
Madam President, to the gentleman, I would say, first, I hear your point, but I'm going to direct you to another place in the bill. If you go to line 361, please, it says there that for the purposes subsection, contributions shall be considered to be converted to personal use if the contribution is used to fulfill any commitment, obligation, or expense of a person that would exist irrespective of the person seeking, holding, or maintaining public office. And to your point, child care, in the case you use it while you're holding public office or other things, those would be expenses you would have irrespective. So I think that we have addressed it in that other area.
Madam President, gentleman, yield.
Will the gentleman from Loudoun yield?
I yield.
Senator Stewart.
I think I respectfully disagree with the gentleman with his interpretation of that, but I'll move on. Is there any provision in this bill to prevent you from paying a family member for these services?
The gentleman from Loudoun.
Madam President, we did not address that because there are some instances where those could be appropriate expenses.
Senator Stewart.
With the gentleman, yield for one last question.
I yield.
The gentleman from King George.
I guess I would ask the gentleman, it is imperative. I guess it is imperative, but I'd rather make a statement. I'd feel much better if we could get this in better shape before it goes to the other body.
Gentleman from Loudoun.
Madam President, I appreciate the gentleman from King George's concerns, and I believe his heart's in the right place. I'll go back to my remarks when I presented the bill originally. This is not a panacea. I'm not going to tell you this is a perfect bill because there's rabbit holes. And frankly, we went down many rabbit holes. I know the working group did to try to come up with the best bill we could. I will tell you a couple of comments I've heard here. My hope is it will make it through the other body down the hall, and we'll have something to start with. At this point, I believe our best bet is to pass what we can pass with this bill. Can you see me at all? I'll look up here a little bit. Because I believe it's a giant step forward. If this bill were to come back, frankly, I'm open to adding the FEC suggestions that the gentleman from Fairfax mentioned. I'm open to debating or lowering the fines, although I think the fines need to be at a meaningful level. And again, if someone is accused of something, they can always return or repay the item, which in most cases hopefully would be less than the fines that are prescribed. I think these are things we can work on and tweak. But at the moment, I think that we need to have something that says that we hold people to a higher standard if they serve in public office, and they should be serving for the good of the people, not to enrich themselves. The last thing I want to mention on this, which I think is critically important, is all of us here, I think this is a group of very honest people, and it's an honor for me to serve here. And I think people do care about what they do and holding the right things in mind. But I will tell you there's been candidates who have ran and lost for public office, and frankly, I think those are some of the most egregious abuses of personal use of campaign funds. And this would prevent that. Is it perfect? I can't tell you it is. Will we have to come back to it? Probably. But it's a big step forward, and it puts a stake in the ground and says that these are things that are so egregious we can agree on them. And with that, I renew my motion.
The chair recognizes the senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. Speaking briefly to the bill.
Senator has the floor.
Thank you, Madam President. I just wanted to address the discussion we just heard related to dependent care and why it's important we include that in the bill. This actually mirrors an exemption in federal law where there was a ruling that federal candidate campaign funds can be used. The specific question was for child care. And here's why that's important. I think we all recognize that our political views, our policy views, how we vote is shaped by our life experiences. And it is critically important, and I think an important perspective to have here is parents of young children. But unfortunately, there's a lot of pressure that has been put, particularly on, but not exclusively, mothers, not to use campaign funds. And if those candidates don't have a job that helps to pay for childcare, which is growingly expensive, then it really prices them out of running for office. The reason dependent care was put in there is because we have an increasing number of candidates who are in the sandwich generation and have to deal with both child care and adult parent care. And so this is just to mirror something that's already allowed under federal law to ensure that we are not pricing those candidates out of running for office.
Madam President.
The gentleman from King George, Senator Stewart.
Would the gentlelady yield for a question?
I yield.
Senator Stewart.
Madam President, while I don't necessarily disagree with that statement, would the gentlelady not agree that perhaps we should not be paying our family members because that at a minimum, and she's an attorney and she understands this phrase, could appear as an impropriety at the very least?
The senior senator from Richmond City.
Madam President, I would say that while I have been fortunate to be able to find child care where I didn't have to pay a family member, I would not want to presume that for every individual that may be their only option. And so I think at the end of the day, that's something the voters can decide if they think it is appropriate. If you have a candidate who the only person available to provide care is a family member, and that person may forego a job to take care of a child that day, I think the voters can make that decision on their own.
I thank the gentlelady. Madam President, I'd like to speak to it at the appropriate time if the gentlelady's finished.
This is that time, sir. You have the floor.
Thank you, Madam President. I do intend to support this, and I wasn't rising to criticize it to try to defeat the bill or anything like that, but that's a pretty significant thing. And I think all of us in here should agree that if voters or constituents or citizens see us what could be viewed as funneling money to family members, we should all be very concerned about that. And I understand it could be perfectly legitimate. But even some things that are perfectly legitimate can be viewed as not being so. And I think for the good of this body and the members and the citizens, we should avoid things like that. But I do intend to vote for this, and because I like the fact that we're making the use of campaign funds more restrictive. And we should be making it much more restrictive because the citizens don't donate money for us to use for any other purpose than for campaigning. And so I appreciate the gentleman's work on this, and I didn't ever mean to suggest that I didn't support it. I just think we really could make a few things in here a little better.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does anyone desire to change their vote? The clerk will close the roll.
Ayes 37, noes 3.
Ayes 37, noes 3. The bill passes.
Senate Bill 535.
Madam President. Peterson.
The gentleman from Fairfax City, Senator Peterson.
Madam President, having voted on the prevailing side by which we passed Senate Bill 378, I move we reconsider so that somebody can get their vote correct.
What page is that, sir?
Page 9, ma'am.
The question is, shall Senate Bill 378, the vote by which it passed, be reconsidered? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? It didn't register. The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill is reconsidered.
Thank you, Madam President. Having previously been explained, this is a second look bill. I move the bill pass and hold everybody to their word. Thank you.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 25, noes 15.
Ayes 25, noes 15. The bill passes.
Returning to page 15, Senate Bill 535, Research Breeders Oversight by Animal Welfare Oversight Officer.
Senator Marsden, the gentleman from Western Fairfax County.
Thank you, Madam President. I move that the bill pass. And speaking to the measure.
Senator has the floor.
Thank you, Madam President. Many of us are familiar with the animal research breeding facility in Cumberland County that has had a number of difficulties including last July and October, several unacceptable audits by the USDA that enumerated a number of problems. And I want to thank the senator from Franklin County, Senator Stanley, who's accompanied me there on 2 occasions to witness firsthand the difficulties they're going through. Some are related to COVID, some related to management issues. But we did have a chance to sit down and talk with those folks and come up with a solution to give them an opportunity to get things turned around. And that is that we are having them we're having VDACs create a fee that will pay for 100% of a full-time investigator who will report to the state veterinarian at VDACs. Also, an advisory board that will be created involving the state vet, a member of the Humane Society, and 2 citizens from the community. And we'll have this investigator have 24/7 open ability to examine anything in the facility and report routinely to the state veterinarian and to the chairs of the Senate and the House Agriculture Committees, as well as consult with the board that we have created. This has been an ongoing problem. They have committed, the Envigo company has committed to $5 million in structural improvements to the facility and in increasing the number of employees. We have a number of complementary bills that have been passed here on the floor. And we are ready to hold them accountable. And if they can't meet with the inspections and the review against USDA or any other state regulations or laws, then they will face closure at some point in time in the future. And with that, Madam President, I would renew my motion that the bill pass.
The question is, shall the bill pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote?
All right, thank you.
The clerk will close the roll.
Ayes 38, noes 2.
Ayes 38, noes 2. The bill passes.
Senate Bill 564, Criminal Records, Selling of Offenses Resulting in Deferred and Dismissal, Disposition, or Conviction.
The gentlelady from Portsmouth, Senator Lucas.
Thank you, Madam President. Madam President, I move that the bill pass.
Yes, ma'am.
Speaking to the measure?
Yes, ma'am. The senator has the floor.
Madam President, you probably know this already because you have a jail ministry, but 1/3 of all American adults have a criminal record. And but for the grace of God, I could have been a part of that 1/3. A criminal record is a significant barrier to housing, employment, education, and other basic necessities of life. In Virginia, a criminal conviction is a public record and stays public forever. Last year, the General Assembly passed groundbreaking legislation that would allow individuals with criminal records for the first time in Virginia's history to seal their criminal convictions from public view. When the record sealing law takes effect in 2025, a person who has remained crime-free for a number of years will be able to seal the criminal records that so often prevent them from getting hired for a decent paying job or renting a suitable apartment. And I think, Madam President, one of the things that's significant is that I indicated that the records would be sealed for people who have remained crime-free. And initially what we did was we opened it up to everybody, but there was an amendment put on it in finance that limits the fines or fees to those who are declared indigent. And with that, Madam President, again, I move that the bill pass.
Question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The bill passes.
Madam President.
The gentleman from Williamsburg, Senator Mason.
Thank you, Madam President. Before we move along too far, having voted on the prevailing side by which we approved Senate Bill 402 on page 11, I would move that we reconsider. I believe one of our colleagues has cleared up his Rule 36.
Question is, shall the vote by which it passed Senate Bill 402 be reconsidered? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The vote is reconsidered. The gentleman from Spotsylvania, Senator Reeves.
Thank you, Madam President. Having previously explained the bill, I ask the bill now pass.
The question is, shall the bill pass? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 1, Rule 36-3.
Ayes 36, noes 1, Rule 36-3. The bill passes.
Returning to page 17, Senate Bill 576. Sports betting allows betting on Virginia college sports.
Gentleman from Williamsburg, Senator Mason.
Thank you, Madam President. Madam President, I move the bill pass. And speaking to the motion.
Senator has the floor.
Thank you, Madam President. Madam President, members, last night, much to the chagrin of our friends in Charlottesville, the Hokies knocked off the Wahoos 62-53 in a hotly contested basketball game. One thing we know, Madam President, is that no Virginian wagered on that game last night. Because, of course, it's illegal to bet on Virginia colleges and universities. Now, Madam President, I doubt anyone sitting in the room really believes that. That certainly, with two teams with a 16-10 record, you bet that wagers among friends, but also wagers in gambling establishments were cast. Madam President, that's the crux of this bill. Whether you believe in gambling and gaming or not, I understand some do not. But if you're not a fan of it, this bill drives to move it into the daylight. So make sure you have an account that's registered that can be tracked and can be taxed. Your wagers can be taxed rather than going to your local bar, pub, and grill and going in the back room and putting your $100 the way it's been done for centuries. Madam President, this is an attempt to drive all wagering above board and to put illegal gaming behind the scenes out of business. It has nothing to do with additional revenues. It just has to do with making sure it's all done above board where we can see it, track it, and tax it. With that, Madam President, I will renew my motion the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 23, noes 17.
Ayes 23, no 17. The bill passes.
Senate Bill 591, cannabis shape prohibitions.
Gentleman from Augusta, Senator Hanger.
Thank you, Madam President. I move the bill pass. I'd like to speak to that briefly.
The gentleman has the floor.
Thank you, Madam President. I think I can be brief because this bill made the rounds, and already 34 members of this body have already seen this bill as it was discussed in 3 different committees. But what it does in technical terms, well, backtrack. I had an interest after working on the landing team for Ag and Forestry to come up with something to promote the growth of hemp. Now, we talked about that yesterday, industrial hemp. But my thoughts about that were promoting traditional uses of hemp, that being for bedding, clothing, structural materials, those types of things. What came up in the conversation was that there was some concern because some of the extract from hemp, as we're all aware, at certain levels can give you a high, and it's become popular in edible products, commonly referred to as Delta 8, Delta 9, that have higher than 0.3% content of THC and THC acid. There have been situations where young people, unsuspecting, have eaten these gummies. The senator from Franklin had already prepared a bill, as I was getting ready to prepare a bill, which basically would make the distribution in retail outlets of these gummies that are laced with this THC and THC acid illegal. We talked about it, and he allowed me to take that bill rather than getting another one drafted. And much to the chagrin of the senator from Prince William, who chairs the subcommittee in rehab that was reviewing this, I changed it from a 1-page bill to a 59-page bill before I arrived at his committee early one morning, after he had already allowed me to go first. But what it does, in simple terms, it eliminates the possibility of these gummies, at least legally, getting into the hands of children who are unsuspecting, and certainly their parents not expecting their children to get high and be hospitalized, that they have been hospitalized after consuming these gummies. Further, it addresses the content of the THC and THC acid, which can be legally in these products, commonly referred to as Delta 8, in the outlets. And that would restrict them to legally to a content of no more than 0.3% THC and THC acid, and it would also restrict the individual servings to 0.25 milligrams, and in a package of a properly labeled package of 1 milligram per package. I hope it would be the will of the majority here to pass this bill. Thank you, Madam President.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Senate Bill 598, College Partnership Laboratory Schools Application and Establishment.
Gentleman from Washington, Senator Pillion.
Madam President, I move the bill passes. Speaking of that motion.
Senator has the floor.
Thank you, Madam President. This bill, as substituted and recently amended, expands existing provisions of the College Partnership Lab School program. The bill before you is a product of weeks of bipartisan collaboration between members of this body and input from key stakeholder groups. I'd especially like to thank the Senior Senator from Chesterfield, the Senior Senator from Richmond City, and the Senator from Fairfax City. Their contributions led to the version of the bill that's before you today. I renew my motion that the bill pass.
Senator Favola, the gentlewoman from Arlington.
Thank you, Madam President. Madam President, I rise to speak to the bill.
Senator has the floor.
Thank you, Madam President. I do have a great deal of respect for my colleague from Washington. And I know he is very collaborative, and I know he did work diligently with certain senators on my side of the aisle who are on Ed and Health. I do have to say, I respect the fact that we're heading down a path that could be a good path. It's a path that does speak to innovation, and those are two good things. But in my view, I don't have enough comfort level to support the bill, and I'll explain why. I just feel I should put an explanation on the floor because voting no on a bill that on the face of it sounds like a good idea really does deserve an explanation. In my perspective, as I understand this bill, public institutions of higher education and nonprofit private institutions of higher education can submit an application to the Board of Education and get a grant to operate a school, a K through 12 school. There were provisions made that a member of the local school board would be sitting on the governing body, but the governing body would be appointed by the institution of higher education. And that's one element of this bill that gives me great pause. This bill really removes local control over this school and gives it to a private entity. I believe that local school boards should really have control over whatever lab school or innovation might take place in their school system. The second issue that gives me pause is there's nothing in this bill. Now, it may come in through an application, and I understand that. I understand that the application can be much more detailed than this bill. But there's nothing in this bill that would require the lab school to provide transportation in the district that it's serving, to participate in the USDA free and reduced lunch program, to take special needs kids and to offer the range of services that our public schools now have to offer under the federal Education Act. So I'm wondering exactly what element of our children will be served by this new idea. Again, these are questions I have. These are concerns. They may be addressed in another version of this bill, and I stand open to seeing the revisions. But right now, this bill is not at a place where I feel I can vote for it. Finally, I will conclude, if we are going down the path of creating these different and unique boutique school examples, I really believe accountability and transparency, especially at the local level where you have locally elected school board members who, in my mind, can provide more accountability than a board that is appointed by the organization operating those schools, has to be acknowledged, and we have to have systems that in totality serve every child. And for those reasons, Madam President, again, I acknowledge the hard work of the colleagues on my side of the aisle and, of course, my dear friend, the senator from Washington, but I cannot vote for this at this moment, and I thank the body for indulging my comments.
Senator McClellan, the senior senator from Richmond City.
Thank you, Madam President. Speaking to the bill.
Senator has the floor.
Thank you, Madam President. I just wanted to briefly respond to some of the concerns raised by the senator from Arlington. I first preference by saying lab schools already exist in Virginia. They've existed for a very long time. I actually attended one. The senior senator from Chesterfield attended one outside of Virginia, but I attended one at Virginia State University for kindergarten and first grade. So what this bill does is actually strengthens the relationship between lab schools and the local school division. It makes clear for the first time, which is not in current law, that the application has to include a description of how the applicant will cooperate with one or more local school boards in the creation and operation of the lab school. Because under existing law and the prior law, it wasn't clear there had to be that relationship between the local school division. We also provided in the substitute that the local school division has to have a member appointed to the board, following the model of the governor's schools, which are cooperative schools between regions, and each participating region has a member on the board. The only provision for a private entity to be involved is that you can have a memorandum of understanding where a private entity could provide apprenticeships or career training or faculty training and support, but this bill does not allow a private entity to run the lab school, be part of the governing process of the lab school, and that was one of the changes to the original bill. This bill also allows, which is unclear whether this can happen under current law, that if a local school division wants to create a specialty school, like a STEM academy or something like that, they can do so through the lab school partnership. That's not clear under current law. I know there is a lot of concern about whether this bill could become a vehicle for charter schools. And some people use lab schools and charter schools interchangeably. Let me be clear. Lab schools are not and have never been in Virginia charter schools. Any amendments to this bill to turn it into a charter school will not be looked upon favorably among those of us on this side of the aisle who support lab schools. They're very different and were created for different purposes. And this strengthens that partnership. This bill strengthens that partnership between higher ed and the local school divisions to educate our children. And for that reason, I support the bill.
Senator Hashmi, the senior senator from Chesterfield.
Thank you, Madam President. Speaking briefly in support of the bill.
The senator has the floor.
Thank you, Madam President. I want to associate my comments with the comments of the senior senator from Richmond. And first of all, I want to thank the senator from Washington for his steady work and collaboration on this particular piece of legislation. I certainly understand the concerns of the senator from Arlington. I shared those concerns initially when we saw the legislation. But as the senior senator from Richmond has pointed out, we've already had the opportunity for our institutions for higher education to establish laboratory schools. It's been part of the code for well over a decade now. And lab schools serve a distinct purpose. They have an opportunity to provide collaboration between our institutions of higher education and our local school divisions. As the senior senator from Richmond has pointed out, these are absolutely not charter schools, and we have ensured that there are strong provisions in this particular legislation in front of us that reiterates that collaborative process between colleges and universities that choose to engage in a partnership to create a laboratory school. And for those reasons, we are in a good posture with this particular legislation. It has the support of VEA, it has the support of school board, it has the support of many other school organizations. It also has the insights provided by the State Council of Higher Education as well. And just to address a point that the senator from Arlington raised, the school must provide plans for providing transportation, food service, and other significant operation services. I certainly understand that those are serious concerns. We want to make sure that there is equitable opportunity for all children in the particular area that a lab school might serve to be able to access that particular school. And so I appreciate those concerns that were raised. Madam President, I ask that the body pass this bill.
Returning to the patron, gentleman from Washington, Senator Pillion.
Thank you, Madam President. As the senior senator for Chesterfield mentioned, this bill is actually endorsed by the Virginia Association of School Superintendents, the Virginia School Board Association, and the Virginia Education Association. They vetted it, and I feel that their expertise put this bill in its current position. So hopefully that gives some relief to my dearest friend from Arlington. With that, I would renew my motion that bill pass.
The question is, shall the bill pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 4.
Ayes 36, noes 4. The bill passes.
Senate Bill 612, Highway Use v. Knowledge-based user fee program clarifications.
Gentlelady from Northwestern Fairfax County, Senator Boysko.
Thank you, Madam President. I move the bill pass. And speaking to the bill.
Senator has the floor.
Thank you, Madam President. Ladies and gentlemen of the Senate, you may remember in 2020, the General Assembly established a highway use fee as a new source of revenue for the Commonwealth Transportation Fund and ordered the Department of Motor Vehicles to convene a work group to develop a mileage-based user fee program as an alternate method of collecting revenues. This is a cleanup bill, and in response to that outcome of that group, and it includes, which we just did yesterday, includes provisions to protect privacy, and I move the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The bill passes.
Senate Bill 624, Home Health Workers Providing Agency Directed Services Employers to Provide Paid Sick Leave.
Senator Favola, the gentlelady from Arlington.
Thank you, Madam President. Madam President, I rise to speak in favor of the bill, and I ask...
The senator has the floor.
Thank you, Madam President. I ask that the bill pass. Senate Bill 624 would provide home care workers who work for home care agencies and are placed in individuals' homes. This is known as agency-directed care. It would make these individuals eligible for up to 5 days of paid sick day a year. This is incredibly important, and this bill parallels a bill that this body passed just last year. It may have been in the special session, where consumer-directed home care workers got up to 5 days of paid sick leave. So in my mind, if individuals are doing the same work and one category gets, up to 5 days of paid sick leave, and folks who are doing the same work because they happen to work for an agency are not entitled to that same sick leave, I think is really unfair. But on a much larger and bigger picture level, we're dealing with folks who are caring for our most vulnerable, who are going into their homes, and sometimes these workers are not feeling well, they're sick themselves, they're being forced to choose between feeding their families or paying rent or staying home and getting better. And most of them are choosing to go to work. And that is, in effect, how we're spreading germs. And we had an incredible COVID outbreak among many individuals who were in their homes getting care from home care workers. And there was a journal in the American Medical Association just this last summer that outlined the need for quality care in our homes and the need to protect the workers who are working in individual homes. There is a fiscal clause on this bill, and I sincerely hope that it is the wish of the body to pass it. Thank you, Madam President.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The bill passes.
Returning to page 2, Senate Bill 741.
Senator Surville, the gentleman from Eastern Fairfax County.
Thank you, Madam President. I would move the bill pass. And speaking to that motion.
Senator has the floor.
Thank you, Madam President. So, ladies and gentlemen, this is the facial recognition bill. We debated a little bit yesterday, and we have it here today on final passage. And first, I just want to tell you what this bill is not. This legislation cannot be used for surveillance, cannot be used for monitoring, and it's not going to be used in traffic stops. It's not. Now, what it is it says that law enforcement in Virginia are allowed to use a certain narrow group of software programs that have been approved by the Virginia Department of Purchase and Supply, like we do with our radar and our LiDAR guns, that have been validated by the Department of Commerce's NIST, National Institute of Standard Technology, and found to be 98% accurate. So I'm sure if you go Google, you'll find a lot of other companies that don't meet these accuracy standards who've had problems. That's not what we're talking about today, is all the things you can find on the internet if you poke around. We are talking about a very, very narrow set of companies that meet extraordinarily high accuracy standards as determined independently by the United States federal government. NIST, by the way, has 5 Nobel laureates that work there, and they've been testing facial recognition algorithms since 2000, and they continue to do so every year. And the last report that was issued on the accuracy of these programs was issued about 1 month ago. And I guarantee you that anything you're reading on the internet didn't consider a report that came out 4 weeks ago. So, starting from that, NIST also looks at the accuracy of this software across gender and across racial subtypes, and they also look for different matches in different scenarios. They test these things to death to make sure they're accurate to avoid false positives, and that's the only software that can be used. Secondly, the legislation in front of you says that this technology cannot be used in connection to establish probable cause for the issuance of a search warrant or an arrest warrant. So it can't be stated in the affidavit that they use this technology to identify a person. This technology is only used to create leads that then have to be followed up, and that person has to state other things in their search warrant affidavit and their arrest affidavit to establish the person's identity. They have to corroborate it. What the software uses is publicly accessible images. They don't go out and buy images. They access publicly available photos. So if you hear anything about Facebook and the Texas Attorney General suing Facebook because Facebook is selling its images to somebody, that's not what this bill is about. Please keep that in mind. I would also point out that no law enforcement agency is allowed to use this technology until they've adopted a memorandum setting forth the parameters within which it can be used. And the parameters have to meet certain minimum standards of the affidavit of a model policy that's adopted by the Virginia State Police. And one of the key things that the model policy requires is that, you look in line 168, the procedures for confirmation of any initial findings generated by facial recognition technology has to be reviewed by a secondary examiner. In other words, once they get back the information from the software, a second person has to look at it to validate it. That means it can't be used in a traffic stop because the officer's not going to be able to call back home and talk to the secondary validator back in the office to look at it. And it's not going to be used to monitor people marching in a march down the street because they're not going to have the secondary evaluator there to evaluate the product. That wouldn't work in those scenarios. That's not what this is about. This is about developing leads for specific investigations of specific crimes, which is what it can be used for. What this software will do, it will allow our law enforcement to use stuff that's been out there. Before we passed our legislation last year, we heard from a Fairfax County detective that they had used the software successfully. They had used it over 12,000 times in Fairfax without a single wrongful identification. Now they can't use it anymore. Now, what does that mean if you can't use it? It means there's leads they can't follow up on. You want to know an example of something they can't follow up on? They caught a guy in my district, or I should say actually was in the senator from Alexandria's district, at least for the next year and a half. They found him pushing 2 dead bodies down the street in a shopping cart. Y'all wonder why I have problems with shopping carts. That he was pushing 2 dead bodies down the street in a shopping cart. When they later started looking into this person, they tied him to 4 other murders in multiple other states. One of the companies that provides the facial recognition technology has information They put his mugshot, his picture, in their software, and it came back with pictures of this individual who likes to push around dead bodies in shopping carts in multiple states. They found pictures of him with other people that were publicly available online. But they can't show them to the police department because of our statute. So who knows how many other people this guy murdered, but one of the leads that's standing in the way of figuring this out is the bill that we passed last year. The way this is also written, it can apply to citizen welfare examples. So, for example, if you find somebody who's a person who has dementia or Alzheimer's, they're wandering around, they don't have ID on them. It can be used for that type of citizen welfare scenario. If they find a person who's unconscious in a hospital bed, they can use it for that. If they find a dead body in a ditch with no ID on it, they can run the picture through the algorithm to see what it produces. Right now, we are barred, our law enforcement is barred from doing that because of a bill we passed in our infinite wisdom. We can't use software that's 98% accurate to identify these people. What we also cannot use it for right now is exonerating people. 80% of wrongful DNA convictions involve situations where somebody was incorrectly identified. When they've done independent testing of witness lineups, they find that 60%, that witness lineups are only accurate about 60% of the time. In other words, 4 out of every 10 times somebody is fingered in a lineup, they got it wrong. This software gets it wrong either 1 or 2 times out of 100. And I would submit that if people are concerned about the technology being wrong, why haven't we banned witness lineups yet? We still allow that to be used as a technique, and if you have concern about it, you raise it in cross-examination. This bill will result in the right people being identified, the right people being excluded from prosecution. It will not result in wrongful convictions, and it will also help families be reunited with loved ones. It'll help the police solve crimes. It'll help our community be a safer place. I would just submit that the bill is being mischaracterized by a lot of folks who find all kinds of things out there by doing Google searches about other companies who've had other problems in the past or things that occurred when these technologies were much less accurate 5 or 10 years ago, but not today. So, Madam President, I would hope the bill would pass, and I'm happy to answer any questions that people might have about the legislation.
Senator McDougall, the gentleman from Hanover.
Would the gentleman from Eastern Fairfax yield for a few questions?
Senator Surville, will you yield?
I will yield to my former colleague from the JMU Student Senate.
Madam President,
Senator McDougall.
I'd ask the gentleman, can you point to me the line in the bill where it says that facial recognition technology cannot be used until the policy has been created by the state police?
Senator Surville.
It says, I believe on line 53, that a local law enforcement agency shall publicly post and annually update its policy regarding the use of facial recognition technology before employing such facial recognition technology to investigate a specific criminal incident or citizen welfare information.
Madam President, I ask the gentleman an additional question.
Will the senator yield?
I'll yield.
Madam President, so does the local law enforcement policy, can that be created before the state police create a model policy for the entire state?
Senator Surville.
Madam President, what it says is, if you look at line 53 through 56, that the local law enforcement agency that uses it does not adopt a model policy. They have to develop their own within 90 days of publication by the state police policy that meets or exceeds the standards in the state police policy. So, in other words, it seems to say, from my point of view, that the state police policy comes out first, and then they have to issue their own within 90 days of publication of the state police policy. So I would submit that there's no enactment clause that orders the state police to put out a policy within X days of the bill or by July 1. But if you read paragraph D, I don't see how a local police department can issue a policy until the state police has its policy, because this says they have to do it within 90 days.
Gentleman from Hanover.
Madam President, I'd ask the gentleman an additional question.
Will the senator from Eastern Fairfax County yield?
I'll yield.
Madam President,
Senator
I'd ask the
McDougall.
gentleman, does he believe that a Class 1 misdemeanor is a criminal offense?
Senator Sorovell.
Yes.
Madam
Senator
President,
McDougall.
ask the gentleman further question.
Further question, the gentleman from Eastern Fairfax County.
I'll yield again.
Does he believe that reckless driving is a Class 1 misdemeanor?
Senator Sorovell.
I believe about all 12 versions of it in the code are Class 1 misdemeanors.
Senator McDougall.
Madam President, I believe there are about 19, but
Okay.
ask the gentleman an additional question.
Additional question, Senator Sorovell.
I stand corrected. I'll yield again.
Madam
Senator
President,
from Hanover.
does the gentleman believe that distribution of narcotics or any other Schedule 1 or Schedule 2 drug is a criminal offense?
Eastern Fairfax County. Mr. Sorovell.
Madam President, it still is, even if we pass Senator Morrissey's bill all the way through and the governor signs it.
So, thank you, gentlemen. Madam President, speaking to the bill.
Gentleman from Hanover has the floor.
Madam President, I don't present any negative thoughts to the senator from Eastern Fairfax for what he's trying to do. And certainly, as we discussed yesterday, technology is important. What I do point out is if you look at the bill, and we went through those questions, localities are going to be able to promulgate their own policies. There's no requirement on the time when the state police has to promulgate their policy, and localities could choose to go first. As you heard the gentleman from Eastern Fairfax articulate, some jurisdictions in Virginia were already using this before we placed a ban. As you look at the way the bill is currently written in the version in the Senate, it allows for this technology to be used for investigating specific criminal incidences or specific citizen welfare situations. Now, one can interpret that how they would like, because as far as I can see, it's not defined in the bill. But as the gentleman just conceded, reckless driving is a Class 1 misdemeanor and a criminal incident. Distribution of drugs, of most, or Schedule 1 or Schedule 2 drugs, are criminal incidences. So those would be ones where if there was surveillance of that drug distribution area, whether it be a residence or business, that this technology could be used. And certainly, I don't know that departments would use it for that reckless driving incident, but they would not be prohibited under this bill. Madam President, we also talk about the technology, and I'm not an expert in this area, I would concede, but as you look at what the NIST literature says, and certainly as it was reviewed by the CBO last year, it indicated that NIST text, the database that it uses for these algorithms, are significantly smaller than the databases that law enforcement traditionally uses. The CBO actually indicated in one time situation it was 69% smaller. And they concede that the larger the database, the less the reliable the technology. The worse pixelated or the worse condition of the pictures, the less reliable the technology. And the NIT's determination is based off of a mugshot to mugshot technology, and that increases the reliability. So, Madam President, we certainly look at these things and we all have our different views, and the senator from Eastern Fairfax is 100% accurate. There are some things that law enforcement will use this for that are extremely positive, and there are some things that will be helpful to law enforcement. But we also look at what are the unintended possibilities and the negative things that could be used for. In this bill, even with the policies and the restrictions placed, there are no penalties if you violate it. So if somebody decided in the office to look up their next door neighbor or their friend's girlfriend or boyfriend, there's no penalty in this bill for doing that. You might violate a policy that is yet to be created that we don't know what it is, but there is no penalty. So, Madam President, I certainly think that this legislation is one that should be deliberately considered by this body. It's one that I think we should put some substantial restrictions on before we allow its use, and one that we should certainly put some penalties on if it is misused. Just like if you misuse a criminal history now, there is a penalty. You can only be a certain qualified individual to have access to that database. That might be created in the future. There might be those restrictions, but the way this legislation will move out of this body, those will not be in place. I think that this is too important. The opportunity for misuse or overuse is way too high for us not to get it right on the first time. This is one that should be more thoroughly discussed before it's passed, and there should be more protections in place. I would ask that you defeat this bill, or, in a way to make sure we get it right for the future, consider returning it to committee and us getting it right this summer.
Senator Edwards, the gentleman from Roanoke City.
Madam President, speaking against the bill.
The senator has the floor.
Madam President, this bill was sent to general laws. I'm not sure why we sent it from judiciary to general laws. It should have remained in judiciary committee, in my opinion. Just last year, we passed a bill to prevent Virginia from using this technology. And I understand the senator from Eastern Fairfax thinks that it's reliable now, but I've just recently received from Harvard University a art document that says it was written in October 2020, 16 months ago, not that long ago. It says the headline, Racial Discrimination in Face Recognition Technology. It goes on to say face recognition was recently banned by certain cities, such as Boston and San Francisco, for the reason that the dominant biometrics in use is the least accurate and is rife with privacy concerns. I could go on and on. And then another part of it says inequity in face recognition algorithms. Just last year, as I mentioned, we banned it, and because of a bill that was passed by both houses beginning July 1 has been banned. And I think it's too soon to jump ahead and say now we should authorize it. And I don't see any urgency. It needs to be studied further. And it can be used in good ways, no question about it. But it also can be used in bad ways. I'm really concerned that it could be used in a way that innocent people can be picked up inadvertently. It's been said 98% accurate. Well, in some cases, not anywhere near that much of being accurate. And I think it's too soon to go ahead and approve this bill, and I recommend that the body defeat the bill or pass it over at least for another year. Thank you, Madam President.
Senator Peake, the gentleman from Lynchburg.
Yes, thank you, Madam President. I rise to see if the gentleman from Eastern Fairfax will yield for a series of questions.
Senator Somerville, will you yield?
I'll yield.
Thank you, Senator. And Senator, I'm not made up my mind on these, so I'm truly asking these to find out, to clarify some questions I may have. So if you will indulge me, Madam President, first, this statute does not seem to say that facial recognition is admissible in courts. Is that correct?
Senator Somerville.
I would agree it does not say that.
And Madam
Senator
President,
Peake.
To your knowledge, is facial recognition technology admissible in courts as we stand?
Senator Somerville.
Madam President, what I would say to the gentleman is I'm not aware of any cases where that's been validated by an appellate court, and I'm not aware of any trials where such evidence has attempted to be admitted. As with all technologies that are new, whether it be things like DNA years ago or fingerprints or others, there's certain reliability standards that have to be met in court before a court would ever allow the evidence to be admissible. And I'm not aware of anybody ever trying that So nobody's told me that it either has been used or hasn't been used. I suspect that it has not been, at least in a Virginia court, but I can't say that definitively.
Gentleman from Lynchburg.
Yes, Madam President, some more questions. Thank you, Senator. And looking at
Senator
your bill,
Somerville, will you yield?
I will yield.
And so in
Senator
looking at your
Peake.
bill, it seems that it does not make it admissible. So that the accuracy is not so much my concern. My concern is more of the libertarian, free from government oversight parts of this bill. And so, Senator, how does this relate to the license plate recognition technology that we passed a session or two ago? Is this stored forever?
Senator Somerville.
I'm sorry, I think I didn't hear the last three words. I think you asked, could it be used forever?
What? Yeah, how long is this stored for? Stored.
Got it. Well, first of all, this is not like LPR technology. LPR technology, if you've seen it on a lot of the cruisers, they have these dual cameras that sit on the trunk. They're bolted to the trunk and face left and right. And as officers drive along the road, it hits the plates, and then it gets positive returns, and that tells them, oh, there's, this car has somebody that might be suspended in it. I mean, they run around trolling and surveilling with that technology, where they can sit a camera on the side of the road and troll. That's true surveillance or monitoring. And that's not what this is, okay? First of all. So secondly, with regard to the storage, if you read the bill, what it specifically says is that any law enforcement agency who uses it has to keep a record of what they did.
And Madam President,
Senator.
Yes, Senator, and it says 10 days and 15 days, but that's if there's a warrant. My question is, what if there's not a warrant? Where is this facial recognition held? Are there just pictures that are taken as the cars roll down the street that's held in the cloud forever until you submit a request?
Senator Somerville.
Madam President, I don't think he's reading the bill correctly. I'm not aware of this 10 or 15 day thing, but what it does say is that every year, if you look on line 66 through, or basically paragraph F, for some reason the bill has two paragraph Fs on line 66 and 81, but it's in any event, it says that
line 98 says 10 days with a search warrant, and line 90 says within 15 days. So that's if there's an issuance of a warrant. Madam President, excuse me. So that's, and Senator Somerville.
I'll yield.
Senator Fraser Fairfax, yes.
I'll yield.
My concern is how long the government will hold this stuff. So let's say during the Black Lives Matters demonstrations in Richmond, would this bill allow the police to use facial recognition of video of what was going on that day and night to then continually search for
Senator
to
Somerville.
make charges?
Madam President, I'm still not seeing this 10-day thing. I'm kind of wondering if he's looking at Senator McDougal's substitute instead of my bill.
Oh, is that what's showing up on LIS?
Senator must stand if the gentleman is asking a question.
Is that what is showing up? Yes, I am.
Yeah.
I apologize. But still, my question, I understand.
I'll yield again.
Senator Peake.
My question then.
Further question.
Black Lives Matter protest. How do they use it? What would happen?
Senator Somerville.
Well, Madam President, that was what I said in my opening comments, was that I don't think it's feasible to use this technology the way this is currently constructed in that type of scenario, because it would require, if you read it says the model policy requires there to be a procedure for confirmation of any initial findings generated by facial recognition technology by a secondary examiner. That's on lines 168 and 69 of the bill, and that's in the model policy. So there has to be a person to confirm the initial findings by a secondary person. And
the Senate will come to order. Excuse me, Senator.
Thank you, and I thank you, Madam President. And I don't see how it'd be feasible for to be processing that quantum of data with another person validating results when that much is coming in that fast. I mean, so typically what this involves is taking one picture, putting it in, seeing what it returns, and developing leads off of that for a specific investigation, or in a welfare situation where you got somebody who's unconscious or can't be ID'd or something.
Gentleman from Lynchburg.
There we go, Madam President. So,
Further question?
I'll yield.
yeah, and thank you. So what is the database that they're running it? Where do they get the database? So you take a picture, you see somebody coming out of a bank who just robbed the bank. What is the database that they are running it against? Where do they get that database?
Senator Surville.
Madam President, as I believe I said in my opening comments, they have developed these databases solely off of publicly available photographs, and they have their own separate database of publicly available photographs. You know, for example, if you go on Google and type in Mark Peak, they'll probably pull up 40 or 50 pictures of you off Google. You know, you can actually take a picture of yourself and search that picture on Google and see all the places on the internet it appears publicly. They develop it off using algorithms or off, you know, web crawlers and things like that. That's how they developed it, according to what they have advised me.
Thank you, Madam President.
The gentleman from Southern Fairfax County, Senator Barker.
Madam President, speaking to the bill.
The senator has the floor.
Madam President, members of the Senate, as chair of the General Laws and Technology Committee, we reviewed this bill, or bills related to this issue last year and then again this year. And I can tell you that there has been tremendous development in the technology, and the information that we received this year was significantly different from what we received last year, which was why we did not move forward with the bill last year, because there were some concerns. And what we're seeing now is the 98, 99% accuracy of the databases and the technology that is now used and the algorithms that are there, and the consistency of it across racial and ethnic groups in ways that clearly had been troubling, even just as recently as last year. So with the changes that have occurred this year and the technology developments, we voted in favor of it on a 12-0 vote with one abstention, and I would hope that the body would pass this bill.
Senator Stewart, the gentleman from King George.
Thank you, Madam President. Would the gentleman from Eastern Fairfax yield for a quick question?
Will the senator yield?
Yeah, I'll yield.
Senator
Thank
Stewart.
you, Madam President. I voted for this in general laws and actually added some amendments to it to make sure it was extremely limited. And I've listened to my friend from Hanover, whom I have tremendous respect for, and others on this. So I want to make sure I understand what I voted for, because I'm starting to wonder here. I would ask the gentleman, I understand that what this does, or let me start differently. Right now, as we sit here and speak today, every one of us is being surveilled by something probably. Isn't that correct?
Senator Surville.
Madam President, all I can tell you is I don't know what the NSA does, but they're pretty scary, and the answer is probably.
That was a
Senator
friendly question,
Stewart.
Madam President.
Yeah. Yeah, probably.
Okay. And so...
Further question?
I'll yield.
Further question. I apologize. Yes, ma'am. Further question.
Senator Stewart.
Thank you, Madam President. And so if I understand this bill, and I just want to make sure I understand it correctly, there are pictures out there everywhere of us and others that are being either taken through existing surveillance or are being posted of people's own volition, or somehow getting out to whatever you call that atmosphere where all these pictures are. Is that correct?
Senator Surville.
That is accurate. It's probably especially true for all these pages sitting in the room. We're probably posting lots of pictures on Instagram.
Senator Stewart.
Further question, Madam.
Will the gentleman yield?
I'll yield.
Gentleman from King George.
Madam President, I would ask the gentleman, does this bill in any way allow or utilize any type of independent surveillance or taking pictures or surveillance of people?
Gentleman from Eastern Fairfax County.
No, it does not authorize surveillance or authorize taking of pictures. It only makes a service available for somebody to compare a picture they have with a database these companies have.
Further question, Madam President.
Will the gentleman yield?
I'll yield.
Gentleman from King George.
He gave me a compound answer, and I was looking for a single answer. So, Madam President, I just want to make sure that I understand this. And so what this bill is authorizing are in two particular instances, either a citizen welfare check, which I guess could be a little broader than just citizen welfare, and investigation of a criminal incident. We would be authorizing the police to use this software to look through this whole atmosphere of pictures to see if they recognize someone. Is that correct?
Senator Sorovell.
Pretty much. Yes.
Thank you. Further question, Madam President.
Further question, Senator Sorovell.
I'll yield.
Senator from King George.
Madam President, then finally, what would be allowed is to use this as an investigative measure, but it could not be used either for a search warrant or arrest. Is that accurate?
Senator Sorovell.
Pretty much. I just want to be clear about the search warrant or arrest piece. What the bill says is that it cannot be, it says on lines 46 through 48 that the facial recognition technology cannot be included in an affidavit to establish probable cause for a search warrant or an arrest. But what law enforcement could do is use the software to develop leads and then use the information generated from those leads and put the leads in the affidavit. They just can't mention the facial recognition technology as a way to bolster the probable cause.
Thank you, Madam President. I thank the gentleman.
Appreciate the questions.
Senator McClellan, the senior senator from Richmond City.
Would the senator from Eastern Fairfax yield for a question?
Senator Sorovell, gentleman from Eastern Fairfax County.
Madam President, this seems to happen every session, yes.
Senator McClellan.
Following up on a question from the senator from King George, could the pictures used from the database to be introduced as evidence in a criminal trial resulting from the investigation that the pictures from the database were used for?
Senator Sorovell.
Madam President, what I would say is Senator Peake asked a version of this, which is that I don't believe nobody could say that, like, we use this software and the software gave us all these pictures and affirmed the person's identity. But what, under the rules of evidence, if there were pictures they found using the software, they would have to independently authenticate those pictures for their use in court. In order to put a picture in court in evidence, you have to have a live witness that can authenticate where it was, who it was, that they're the person in the picture, et cetera. So you'd have to have a witness authenticate it. You couldn't just say it came out of some computer and wave it around. You'd have to have a live witness do that. I think that's the question you're asking.
Senator McClellan.
Would the gentleman yield for a follow-up question?
Senator Sorovell, will we yield?
I'll yield.
Senator McClellan.
And absent this bill and the software that essentially aggregates pictures that are publicly available on the internet, could an investigator today, following a lead, take a picture from Facebook and use it for an investigation, is question number one, and eventually introduce that into evidence?
Senator Sorovell.
Madam President, the answer, I think, to that is probably. They'd have to, first of all, know where to look and know how to find it. And, pictures sometimes go on Facebook and then people change their privacy settings and they vanish. And the company might have grabbed it while it was out there. And then after it went private, they kept it or something like that. But they would still have to have that witness authenticate the subject of the picture and what's in it and all that for it to be admissible.
Senator McClellan.
Follow-up question, Madam Chair.
Follow-up question, Senator Sorovell.
I'll yield.
Senator McClellan.
So essentially what the software that is authorized in this bill, which has to meet a 98% accuracy rating, does is aggregate and allow police to look in one place to find pictures that if they had the manpower and the resources to do, they could sit in front of an internet and search Facebook, Instagram, Google, and find these pictures anyway.
Senator Sorovell.
Madam President, what I would say is that's mostly correct, and that's mostly how I understand that works, except as I mentioned a moment ago, they might have grabbed a picture that's no longer on the internet and kept it in a database, but it was public at one point in time. And so you might not be able to find that today, whereas you might have been able to find it like a year ago or 2 years ago. But generally, your question or assertion is correct.
I thank the gentleman.
The gentleman from Eastern Fairfax County, Senator Sorovell.
Thank you, Madam President. If nobody else desires to speak, I'll wrap up.
Gentleman has the floor.
Thank you, Madam President. Just to add a couple things. I mean, Senator Barker, Senator from Southern Fairfax, already covered the general laws. This been through there twice. It was sent there by the Judiciary Committee. I would also just note that if the Senator from Hanover would like there to be an enactment clause saying this can't be used until the model policy comes out, I'm happy to add that. I will also just note, as with many bills, this is a process, and this bill has generated some interest on the eastern side of the building, and there are some amendments coming over there, including some consequences for people that misuse the technology. And this will not be the final vote you take, and I think the bill that comes back from the House will make people even more comfortable, or comes back from the bad side of the building will make everybody more comfortable. So I would hope we could pass this and keep this conversation going, because this isn't going to be the end of it. Thank you, Madam President.
The question is, shall Senate Bill 741 pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 26, noes 14.
Ayes 26, noes 14. The bill passes.
Madam President, point of order.
The gentleman from
Thank you.
Northern Chesapeake, Senator Sproul.
I believe so. If I'm using the right term, point of order. Is that the right point?
The gentleman has the floor.
Thank you, Madam Chair. My point of order, Madam Chair, is that if we can get used to members to respect the chair, I showed Senator Lewis my text 3 different times. They were saying they're not going to the chair. They asked each other questions on both sides, and you constantly yourself have to say, interrupt yourselves. We have called you everything. We haven't called you queen yet. So I'm just hoping that we have learned how to respect the chair. You're Madam President. And a lot of us on both sides, Madam President, are not going to the chair. We, because I'm part of this group, are being disrespectful. So I'm hoping that we will learn how to address the chair as Madam President. I'm hoping when we ask a question, give you a chance to call, what have you, we just talking to one another, ask questions to one another without going to the chair. I'm hoping that I'm not out of order. Thank you so much.
I thank the senator.
Returning to the forest on page 9. Senate Bill 391, Cannabis Control Retail Market.
The gentleman from Alexandria, Senator Eben.
Thank you, Madam President. I would like to move that we reconsider the vote by which SB 391 was ordered to be engrossed and advanced to its third reading in order to get to the floor substitute.
The question is, shall the vote by which 391 passed engrossed and advanced to its third reading be reconsidered? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The vote is reconsidered. Senator Eben.
I now move that we reconsider the vote by which the Finance and Appropriations Committee substitute was agreed to.
Question is, shall the vote by which the committee substitute was agreed to from Finance and Appropriations be reconsidered? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. That vote is reconsidered. Gentleman from Alexandria.
With the recommendation that it be rejected, I move the committee substitute.
With the recommendation that it be rejected, the question is, shall the substitute...
Madam President, over here.
Gentleman from Hanover, Senator McDougal.
Madam President, if we accepted the committee amendments, we do not get to the floor substitute. If we reject the committee amendments, then we can only pass the floor substitute or the bill in its current form. Is that correct?
Let us check that, Senator. Senate will be at ease.
Let us check back.
You shouldn't like the other person better.
Never get to the floor substitute if we can. Then a point of parliamentary inquiry.
Does that make sense? Yeah. That's why I was procedure.
Returning to the gentleman's question, I am informed that if we agree to the floor substitute, to the reconsideration of it, then we will be rejecting the substitute.
Madam President, further parliamentary inquiry?
The gentleman has the floor.
Madam President, would it be appropriate for the discussion to be now about what's in the floor substitute versus what's in the committee substitute so we could make an informed decision before we vote not to accept the committee substitute?
As I understand it, Senator, we have rejected the committee substitute. No, that's the motion on the floor. But we have rejected the Finance and Appropriations Committee substitute as well as the reconsideration of the third reading of the vote, which means that we are now, again, at the point of possibly rejecting the committee substitute. So that is in order. The discussion.
Madam President, if I could restate my parliamentary inquiry maybe a little clearer, would it not be the best time for us to debate the committee substitute and what's in that versus the floor substitute? Because once we take a vote on the committee substitute and reject it, then we cannot come back to the committee substitute.
We could, sir, in a circuitous route, but that would be with unanimous consent. So to get to your point, sir, then it would be appropriate to reconsider it now, to discuss it now.
I thank the President.
Yes. So we are now, your motion, sir, was that we reject the committee substitute. Is that right?
That's correct.
And now we have someone to speak to it, and that Senator from Lynchburg, Senator Peake.
Thank you, Madam President. Speaking to the motion.
The senator has the floor.
And I believe we should not reject the committee substitute, because if we reject the committee substitute, is my understanding, Madam President, that if we reject the committee substitute, they will then put before us what was delivered at 1:30, a 400-page document that is a complete rewrite and substitute of the cannabis bill. Is that correct, Madam President?
That is correct, sir.
Absolutely, we should not do it. This is absurd. Insulting. This
For what purpose does the gentleman rise again?
against rejecting the substitute, Madam President.
Senator has the floor.
Exactly what happened last year. They came in, we were in special session for a year or two, and they put together a cannabis bill that was how many thousands of words and lines and pages. They had no idea what was in it. It's a bunch of crap. It's still a mess. It is still a mess, and we were getting hit with a 400-page substitute at 1:30 today. We should not address this substitute. I ask that you accept the committee amendments.
Speaking to that.
We have another senator. Gentleman from James City County, Senator Normant.
Madam President, addressing the issue before us.
Senator has the floor.
Thank you, Madam President. I think traditionally we have allowed there to be a discussion between comparing and contrasting the committee substitute with the floor substitute before a vote is taken on it. I believe that we have done that traditionally. I would further say that if, in fact, the committee substitute is rejected, then that substitute is dead absent a reconsideration, and the only matter that would be before the body, would, in fact, would be the floor substitute. Finally, following up on the comments of the senator from Lynchburg, I perhaps won't be so vitriolic about it, but I recall very vividly when we were in session and the floor substitute on this cannabis bill was offered, and I was an agitated senator. In fact, I had suggested that we pass it by to give individuals an opportunity to read it. And I haven't been a fan of this bill from the beginning because it is an omnibus bill that attempts to address so many diverse circumstances that does not provide the opportunity for a fair and reasonable analysis and debate. But I recall when the floor substitute was presented on us and there was not the willingness to pass it by, that in fact one of the senators stood up and echoed Nancy Pelosi and said, "Go ahead and pass it, and then you can read it later on." I suggest to you that there is a significant floor substitute that is before us. I think, being objective, that there are only a few changes in it, but this is a very bad precedent on two levels. One, writing these omnibus bills that are in 300 and 400 pages that incorporate a number of very diverse topics that ought to be the subject of individual bills. And number two, presenting floor substitutes of this dimension, and especially on a crossover day. Thank you, Madam President.
Chair recognizes the gentleman from Alexandria, Senator Eben.
Speaking to the motion to reject the Finance and Appropriations Committee substitute.
Senator has the floor.
Thank you, Madam President. I'd like to detail for the senator from Lynchburg what the floor substitute does that's different than what you adopted yesterday. The first thing it does is it removes all languages to unions or labor unions that you saw in last year's bill. And it might be better if I just go over and tell you what's in the whole thing in the floor substitute for you to make your decision. This legislation is the vehicle to license new businesses in a regulated, equitable adult use market. And I've appreciated the bipartisan, thoughtful input and amendments that's gone through to get to this point. Since we legalized possession of cannabis in 2021, state agencies, stakeholders, and colleagues on the Cannabis Oversight Commission have worked to create the bill before you today, which stands up a consumer-focused, safe, taxed adult use market, which is primed to serve as a vehicle for both economic development and transformational investments in pre-K, community revitalization, addiction diversion, and treatment. While you've seen most of this bill this year, I want to briefly walk through the major provisions of the substitute to ensure that we're clear what we're voting on. What the floor substitute does is adopt language from my transitional sales bill with an amended fee from Senator Morrissey as passed yesterday and strikes union language incited by our former governor. It begins sales on September 15th with 4 pharmaceutical processors totaling 6 facilities capped at 150,000 square feet of canopy, like yesterday's transitional sales bill, and a $6 million entrance fee. It combines the transitional sales with this bill. The transitional sales period would last from September 15th, 2022 of this year and January 1st, 2024, when the full market would be open. And the on-ramp is crucial for 3 reasons. It ensures that consumers can purchase safe, regulated products legally until the full market is open. It begins the long but crucial process of capturing illicit market sales, reducing crime, and building a base for the market. And it will ensure the little guy, especially those most disadvantaged by the prohibition on cannabis, to receive the seed funding and startup support necessary to slingshot small Virginia businesses into economic success. Eventually, the market would be overseen by the Cannabis Control Authority, a regulatory body vested with the authority to regulate all consumable cannabinoids, including Delta-8 and other synthesized products, grant licenses, and disperse precision loans and investment dollars to economically disadvantaged communities. The areas that differ from last year's reenactment include...
Senate will come to order.
And this is what was in the bill yesterday and today. The Northam administration cleanup language, recommendations from the Cannabis Oversight Commission, and JLARC recommendations from a review of the 2021 bill. It ensures that those most significantly impacted by criminalization of cannabis will get a fair shake at building generational wealth through the industry and will receive the training and support to enter the complex marketplace. The bill also focuses on undoing the harms of prohibition, providing for fiscally responsible, vetted approaches to record sealing and resentencing for nonviolent cannabis crimes, as passed in bills from Senators Surville and Lucas. It also sets out appropriate measured penalties for the illegal sale and distribution of cannabis to close the door on the black market without recriminalizing law-abiding citizens. It sets a mid-range penalty for possession in public or on your person of 4 ounces, which is 4 times the current 1 ounce limit, which is punished as a Class 3 misdemeanor or for a first offense and a Class 2 misdemeanor for a second or subsequent offense. It sets an upper possession limit for home or other non-public place of 4 pounds. That's for people who are growing at their home and have multiple harvests, which is punished the same as having more than 1 pound in public, which is a very significant penalty, 1 to 10 years. It allows businesses under 8,000 square feet to vertically integrate, providing for a craft or micro license. It adds a marijuana testing lab expert and consumer advocate to the Cannabis Public Health Advisory Council. Again, the substantial changes between yesterday and today are the removal of the union language, allowing the early sales that we adopted yesterday in the junior senator from Richmond's floor amendment integrated into this bill. So there are no changes other than the removal of the union language and the early sales language being included with this bill. With that, I would renew my motion that the Finance and Appropriations Committee substitute be rejected.
Senator McPike, the gentleman from Prince William.
Thank you, Madam President. Speak to the motion.
The senator has the floor.
Thank you, Madam President. The 30-second explanation, and I appreciate the gentleman from Lynchburg's comments to this. So we had actually requested on the substitute to see if there's a way just to provide you with the sections that were changed. You had received the 5 pages at the back, which is essentially the provisions of Senate Bill 313, as amended by Senator Morrissey, as well as the incorporating the elements from the senator from Alexandria, including the temp 10 industrial hemp. So it's increasing the number of opportunities in the agriculture community. It kept the fee that we debated yesterday at $500,000. It kept the start date under Senator Evans' bill at September 15th of 2022 under the pharma, so we have a transition. And then it deleted on page 218, section P as reference. So there's really 5 pages plus 1 line deletion. So that is what's before you now in the 450 pages. And I apologize to all the trees. And unfortunately, there was not another process we could do to present these changes. But here's why it's important. Here's why I recommend that you reject and help reject so we can get to this floor substitute, is because this now provides a coherent methodology of the transition from pharmaceutical as well as enforcement. And that's the key. We actually don't have, as the written, a logical transition into the full enforcement under the Cannabis Control Authority. That's why this amendment is important. We want to make sure we have the appropriate amount of transition as well as illicit market capture. And that's what this new substitute does. That's why it's important that we reject the substitute and get to the floor substitute. Reject the substitute from finance to get to the floor substitute, Madam President, and urge the body to reject it. Thank you.
Senator Suderline, the gentleman from Roanoke County.
Thank you, Madam President. Will the senator from Alexandria yield for a question?
Will the senator from Alexandria yield? He will. Senator Suderline.
Thank you, Madam President, and I thank the senator. So I just voted for Senator Pillion's fine lab school bill that I was assured was endorsed by the VEA, and so my union score is going up. Why now would I want to vote to take out the fine union folks of the Commonwealth of Virginia from this bill?
Because
Senator Eben.
I yield. I'm sorry. Because I know you to be a champion of bipartisan compromise and working for a product that more senators can support.
Senator Suderline.
I'm not.
Further question?
No, thank you, Madam President.
I renew my motion that the Finance Committee substitute be rejected. I move that it be accepted with a recommendation that it be rejected.
With the recommendation that it be rejected, the question is, shall the Finance and Appropriations Committee substitute be agreed to? All in favor of the motion will say aye. Aye. Those opposed, no.
No.
The chair is uncertain. This will be a recorded vote. Those in favor? The question is, those with the rejection that it be, with the recommendation that it be rejected, the question is, shall the Finance and Appropriations Committee substitute be agreed to? All in favor of the motion will say aye. We'll record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 15, noes 25.
Ayes 15, noes 25. It is rejected, the committee substitute. The gentleman from Alexandria, Senator Eben.
I now move to waive reading of this floor substitute, please.
The question is, shall the reading of this floor substitute be waived? Those in favor will say aye. Those opposed, no. The reading of the floor substitute is waived. Senator Eben.
Now, I move that we agree to the floor substitute, but I'd like to start with a commercial or public service announcement while we're trying to build
the senator. The senator has the floor.
Thank you, Madam President. While this bill creates a new industry, I want to pay tribute first to Virginia's forestry industry, and I also want to put in a commercial for the recycling industry. I hope that those who want to read this will take it home with them if they haven't already read what we were voted on yesterday. But if you don't, you can recycle it on your desk after we're done here today. This legislation, as I said, is the only vehicle to license new businesses in a regulated, equitable adult use market, and it took a lot of input and compromise and bipartisan support to get to this point. We've gone through some of the major points. The biggest difference from last year's bill is that we took recommendations from JLARC, from the Cannabis Oversight Committee, and from the former governor's office on some cleanup provisions, which were in the substitute adopted yesterday, but we've melded it together with both Senator Morrissey's cap of $500,000 on licensing for industrial hemp providers who have processed significant amounts of industrial hemp before, who can apply through a competitive process to get into the cannabis processing business and have the early sales in there. So that's the bill. I'd prefer to take questions if there are any. Move that we adopt the floor substitute.
The question is, shall the floor substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The floor substitute is agreed to. The gentleman from Alexandria, Senator Eben.
I move we engross and advance the bill to its third reading.
The question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed and advanced to its third reading. Senator Eben.
Now move that we suspend the rules and dispense with the third constitutional reading.
The question is, shall the rules be suspended and the reading of the third constitutional reading be dispensed with? Those in favor say aye. It's a recorded vote. Those who agree will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The reading is dispensed with. It is on final passage. Senator from Alexandria, Senator Eben.
Thank you, Madam President. I now move the bill pass. I believe I've explained it, but
the senator has the floor.
I believe that I've explained the differences between last year's bill and this year's bill and where they came from, and I hope it will be the body's pleasure to pass the bill.
The question is, shall the bill pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 23, noes 16.
Ayes 23, noes 16. The bill passes.
Page 21, uncontested calendar, Senate bills on second reading.
The senior senator from Fairfax County, Senator Saslaw.
Madam President, I move that all Senate bills on second reading on the uncontested calendar on pages 21, 22, Senate Bill 38 through 723, be advanced to their engrossment and third reading in a block after the adoption of any amendments thereto. Any senator desiring to remove a bill from the block, please do so after the clerk has read the number of the bill.
The question is, shall all Senate bills on second reading on the uncontested calendar on pages 21 through 22, Senate bills 38 through 723 be engrossed in advance to their third reading in the block after the adoption of the amendments, and that any senator desiring to remove a bill from the block may do so after the clerk has read the number of the bills. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The clerk will now read the number of the bills.
Senate Bill 38, reported from the Committee on Rules. Senate Bill 62, reported from the Committee on Rules with amendments.
Senator Favola, the senator from Arlington.
Thank you, Madam President. Madam President, I move that the amendments be adopted on Senate Bill 62.
Question is, shall the amendments be adopted? Those in favor will say aye.
Aye.
Those opposed, no. The amendments are agreed to.
Senate Bill 723, reported from the Committee on Rules.
The gentleman from Loudoun, Senator Bell. Oh, I'm sorry, you don't. That's true. The question is, shall the Senate bills be now engrossed in advance to their third reading? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The bills are engrossed in advance to their third reading. Chair calls on the senior senator again from Fairfax County, Senator Saslaw.
Madam President, I move that all Senate bills now on third reading on the uncontested calendar, pages 21 through 22, and Senate Bill 38 through 723, that the rules be suspended and the third constitutional reading of the titles be dispensed with.
The question is, shall the rules be suspended and the third reading of the titles of the bills be dispensed with? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, noes 0. The reading of the titles is dispensed with. Returning to page 21, the bills are now before the Senate on final passage. The senior senator from Fairfax County, Senator Saslaw.
Yes, I move that all those Senate bills now on the third reading on the uncontested calendar, pages 21 and 22, again, Senate Bill 38 through 723, be placed on their final passage in a block. Any senator desiring to remove a bill from the block, please do so after the clerk has read the number of the bill.
The question is, shall the Senate bills on the uncontested calendar, third reading now, pages 21 through 22, Senate Bill 38 through Senate Bill 723, be placed upon their final passage in the block, with the understanding that any senator desiring to remove a bill from the block may do so after the clerk has read the number of the bill? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The bills are again before us in the block. The clerk will read the number of the bill.
Senate Bill 38, Senate Bill 62, Senate Bill 723.
The question is, shall the bills in the block pass? All in favor of the passage of the bills will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, noes 0. The bills in the block pass.
Regular calendar, Senate bills on second reading. Senate Bill 36, School Principals Incident Reports, reported for the Committee on Education and Health with a substitute. And there are 3 floor amendments.
The senator from James City County, Senator Norman.
Madam President, speaking to the bill, first,
Senator has the floor.
An aspirational point, and secondly, a factual point. The aspiration is that I am hopeful this bill will not take 38 minutes. I like the facial recognition bill, and the factual part is it will not include 451 pages for us to read. I would respectfully move that the committee substitute be agreed to.
The question is, shall the substitute be agreed to? Those in favor will say aye. Aye. Those opposed, no. The substitute is agreed to. The gentleman from James City County, Senator Norman.
Madam President, taking up the floor amendments number 1 and 2, I would ask that those amendments be severed, please, and taken up separately.
Without objection.
Madam President, I would first move that the floor amendment number 1, that only includes the word physical, pass with a recommendation that it be rejected, so I may get to floor amendment number 3.
The question is, shall floor substitute...
He needs to waive the reading.
Yes, that's right. Have to waive the reading.
I apologize. I respectfully request that floor amendment number 1, that the reading of it be waived.
The question is, shall the reading of floor amendment number 1 be waived? Those in favor of waiving the reading of the amendment of the floor substitute say aye. Those opposed, no. The reading of the amendment is waived. Senator Norman.
Now, Madam President, as to floor amendment number 1, I ask that it be accepted with the recommendation that it be rejected.
With the recommendation that it be rejected, the question is, shall floor amendment number 1 be agreed to? All in favor of the motion will say aye. Those opposed, no.
No.
The noes have it. That number 1 floor amendment is rejected. Senator Norman.
Thank you, Madam President. As it relates to floor amendment number 2, I would respectfully waive the reading of floor amendment number 2.
Question is, shall the reading of the floor amendment be waived? Those in favor of waiving the reading of floor amendment number 2 will say aye. Those opposed, no. The reading of the floor amendment is waived. Senator Norman, senator from James City County.
Thank you, Madam President. I would now ask that floor amendment number 2 be agreed to, and speaking to that amendment, please, ma'am.
The gentleman has the floor.
Ladies and gentlemen, Senate Bill 36, I have been, since the bill was reported from committee, trying to work with several of you to address some of the concerns that were raised. One of the concerns that had been raised was how, in fact, this bill in its postures was passed in 2020 and also as proposed in Senate Bill 36 would impact students that might have emotional, mental, or artistic issues. And consequently, if you look on page 3 of the bill, you will see that lines 125 through 136 provide an alternative school discipline process. However, to address additional concerns, floor amendment number 2 is offered, which provides that a principal is not required but may report to local law enforcement agencies any incident that is described in A4, which are a number of criminal matters, if it is committed by a student that has an IEP or an individual education plan. It's just an additional consideration. I would further say, Madam President, that this bill, as passed last year, and certainly as I hope will pass this year, addresses some provisions that are in Title 22.1, and that is the Board of Education. And I would say to those of you who are concerned about students who may have some mental, emotional, or artistic issues, that already in the Code of Virginia under 22.1.279.6, that the Board of Education and individual school districts are directed and authorized to adopt policies to specifically address students that have these issues so that they are not adversely impacted as a result of a disability that they might have. So with that explanation, Madam President, I would ask that floor amendment number 2 be agreed to.
Chair recognizes the senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. Speaking to the amendment.
The senator has the floor.
Thank you. While the senator from James City and I have a disagreement on the policy of the underlying bill, I do appreciate the problem that he is trying to address and believe that it can probably be further massaged as this bill makes it to the other side of the body. But since I may not be part of those conversations, I just want to point out one quick thing, and that is that not every child that has an IEP is autistic or has an intellectual or developmental disorder. and not every child who is autistic or has a disability has an IEP. And so I think as this bill makes its way through the body, I think this amendment could be more precise by addressing individuals who either have or are suspected of having a disability. And here's the reason for the concern. For young children especially, these conditions often manifest themselves first in behavior. And so either by blurting out something in the heat of the moment, or what could rise to the level of a misdemeanor assault, sometimes it's that first action happens through that act. They may not have been diagnosed, but that begins the process of making sure they are diagnosed if there is something suspected. So again, I unfortunately am going to have to vote against this amendment because I think as written does not solve the problem that the senator's trying to solve, and hopefully as this bill makes its way through the body, it can be tightened up.
Chair again recognizes the patron, Senator Norman.
Thank you, Madam President. I appreciate the comments and observations and efforts that the senior senator from Richmond has made, and I have told her that I've been through a couple of different versions of the language in an effort to try to address that issue in this bill, and I have given her my assurance that I will continue to work on that language and see if we can refine it to even address her concerns more directly if it moves through this body to the House, which I am prayerful that it will. So with that representation, I would ask you to agree to floor amendment number 2.
The question is, shall the floor amendment number 2 be agreed to? It's not a recorded vote. So those who agree will say aye. Aye. Those opposed, no. The floor amendment is agreed to. Senator Norman.
Thank you, Madam, and ladies and gentlemen of the Senate, I appreciate your patience. Madam President, I would now like to take up floor amendment number 3, and I would respectfully request that we waive the reading of that floor amendment.
The question is, shall the reading of floor amendment number 3 be waived? Those in favor of waiving the reading will say aye. Those opposed, no. The reading of the floor amendment is waived. Senator Norman.
Thank you, Madam President. With the recommendation that floor amendment number 3 be agreed to, I would like to address that, please.
The senator has the floor.
Madam President, this one-word amendment also has come about as a result of a discussion with the senior senator from Richmond, and it has been through a couple of versions, of course, which represented in the rejection of the floor amendment number 1. And on line 37 of the bill, what it does is it inserts the word written. The concern was this, that we were trying to avoid the principal having to report threats that were made against school personnel, etc. And threats can come in various forms. You can have a physical threat. You could have a written threat, an oral threat. And we were trying to encompass situations which did not incorporate physical threats. So we ultimately have come down with inserting the word written. So what it provides is that any written threats against school personnel at a school activity may be reported, but not oral threats that could otherwise come about. So I think that addresses a concern that came up in committee, and I would ask that floor amendment number 3 be agreed to.
The question is, shall floor amendment number 3 be agreed to? Those in favor will say aye. Aye. Those opposed, no. The floor amendment is agreed to. Gentleman from James City County.
Thank you, Madam President. I would now move that Senate Bill 36 as amended be agreed to, and speaking to that motion.
Engrossed and advanced. Is that what you're saying?
Oh, I apologize. I got ahead of myself. I would respectfully move that Senate Bill 36 as amended be engrossed and advanced to its 3rd reading.
Question is, Shall the bill now be engrossed in advance to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed in advance to its third constitutional reading. Senator Norman.
Madam President, now speaking, I think it has been engrossed in advance to its third reading in spite of what the board may say.
Wait 1 second, Senator. I think I've gotten ahead of myself. So now we're just going to go through the motions of all of them and put them all in a block. Isn't that right? Ready? In a block and then come back. Yes, exactly that. So we will go through and dispense all of the second reading and then come back and put them in a block and then go over them again. So
thank you, Madam President. I got the message that we're going to do it all at once.
All right. So you're fine. Your bill is now engrossed in advance to its third reading.
Yeah.
Senate Bill 313, cannabis products retail sale of by certain pharmaceutical processors and industrial hemp processors. Reported from the Committee on Rehabilitation and Social Services with the floor substitute and amendments have been adopted.
The gentleman from Alexandria, Senator Eben.
Thank you, Madam President. I have a motion. I would move that SB 313 be recommitted to the Committee on Rehab and Social Services. And speaking that motion.
The senator has the floor.
We have adopted the key all the provisions of the yesterday's floor substitute by passing the other bill, so it no longer is necessary. So I move that we recommit it to Rehab and Social Services.
The question is, shall Senate Bill 313 be...
Madam President.
For what purpose does the gentleman from Richmond City rise?
Speak to the motion.
The senator has the floor.
Thank you, Madam President. Madam President, ladies and gentlemen of this body, let's put things in its proper posture. Senate Bill 313, which was my 4.5-page substitute, was brought to the floor yesterday. It was read, it was debated, and it was on the verge of passing when the senator from Alexandria voted to take it by for the day. What's happened since then? We then had a 11,990 line bill substitute for 391, 451 pages. We read it, we debated it, we argued it, and we voted on it in less than 20 minutes. The point is now is that Senate Bill 313, which a majority of this body supported yesterday and was ready to vote on yesterday, is now no longer necessary. Why is it no longer necessary? Because Senate Bill 313, Senate Bill 313 is now incorporated into the larger bill. It is not. It's a standalone bill. It is separate. It is detached. And if you liked the bill yesterday, 24 hours ago, if you liked the fact that we're going to allow hemp farmers to participate in this process, if you were ready to vote for it yesterday, has anything changed that you would not support 313? If you agree with me, then I'd ask that you reject the senator from Alexandria's motion that we PBI it, or pass it by for the day. Thank you. And put up a no vote.
Madam President.
The gentleman from Virginia Beach, Senator DeSteph.
Madam President, will the junior senator from Richmond yield for a quick question?
Will Senator Morrissey yield?
I yield.
Senator DeSteph.
Madam President, Senator Morrissey, the gentleman from Richmond. I'm not sure about you, but in your statement you just said that in 20 minutes we read this, 191,000 words. I didn't read it. So I just want a quick point of clarification. I don't think anybody in this body read this bill that's 11,900 and something lines, 500 pages, 191,000 words. I don't think any one of us read it in 20 minutes. So I just want a quick point of clarification on that, Madam President. And Senator Morrissey, back to you, sir.
Madam President.
The junior senator from Richmond City, Senator Morrissey.
I would respond to the senator from Virginia Beach that my 6-year-old daughter would say, Daddy, you're being sarcastic now, aren't you? I understand that it wasn't read. My point is a simple one. You understood my 4.5-page SB 313 substitute yesterday. We debated it. We talked about it. We understood it. And we're getting ready to pass it. Now it's not necessary. I disagree with that. And if you agree with me, you'll put up a no vote for the senator from Alexandria's motion to PBI it.
The question is, the gentleman from Prince William, Senator McPike.
Thank you, Madam President. Speaking briefly to the senator's motion.
The senator has the floor.
I would encourage the body to support the patron's request, as is the custom, use, and practice of the Senate. And in fact, just a point of clarity, the elements of this bill have been fully incorporated into Senate Bill 391. So I would encourage the adoption of the senator's motion and honor that request as the patron. Thank you.
The gentleman from Roanoke County, Senator Suderline.
Madam President, would it be appropriate to make a motion to pass the bill by for the day? Substitute motion. I would move that, as I believe that's what's in the patron's wishes, and moves this along quicker.
Is that the motion? Yes, ma'am. Without objection.
Point of parliamentary inquiry, Madam President.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Madam President, if we pass it by for the day, does that not effectively kill the bill?
Yes, sir, it does.
Madam President, speaking to that motion.
The senator has the floor.
For the same reasons I said a moment ago, I'd ask that you vote no to the substitute motion to pass it by for the day, that if we return to the senator's motion, Senator from Alexandria, that we vote no.
All right. So shall the bill go by for the day? This is going to be a voice vote. Those in favor of having Senate Bill 313 go by for the day will
Madam
say...
President, may we have a brief recess?
For how long is the recess, Senator? For 2 minutes, without objection. The substitute motion on the floor is to pass the bill by for the day. Those in favor will say aye. Aye. Those opposed, no. No. The chair is uncertain. We will have a recorded vote. Those who wish to pass the bill by for the day will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
19.
Ayes 21, noes 19. The bill is passed by for the day.
Senate Bill 631, Fair Labor Act, Overtime Employer Liability. We have a floor substitute.
The gentleman from Southern Fairfax County, Senator Barker.
Yes, Madam President, we rejected let's waive the reading of the floor substitute.
The question is, shall the reading of the floor substitute be waived? Those in favor will say aye.
Aye.
Those opposed, no. The reading of the floor substitute is waived. Senator Barker.
All right, and we had rejected the committee substitute amendment yesterday, so I don't
yes, sir,
need to go
did.
back through them. I move the floor substitute and speaking to the measure.
The senator has the floor.
I was sort of interrupted about halfway through this yesterday, but I won't try not to repeat what I was saying yesterday, but I'll add just a little bit to it. What this does is this floor substitute is completely consistent with the Fair Labor Standards Act, except for one provision that is in here. And that provision is in here because of some differing and somewhat conflicting federal laws. A number of people who work at airports throughout the Commonwealth and doing things like doing various jobs like pushing wheelchairs, cleaning the cabins of planes between flights, line attendants, passenger service agents, those types of people, do not end up receiving, or they're not automatically covered under any of the overtime acts that there are there. And the reason for that is that they are covered under the Railroad Labor Act, which is mostly dealing with union issues and not dealing with the same types of things that the Fair Labor Standards Act, and they are explicitly excluded from the Fair Labor Standards Act. This substitute provides overtime protections and a state cause of action for those individuals. And that's the only change that is not consistent with the Fair Labor Standards Act. And I hope that we'd pass this floor substitute.
The question is,
Madam President.
The gentleman from Roanoke County, Senator Obenshain.
Rockingham, but that's okay. Madam President, speaking to the floor substitute.
Gentleman has the floor.
Madam President, members of the Senate, I would urge the members strongly to consider voting against this floor substitute. My understanding is that last year there were certain representations made about this bill being in conformity with federal law, and after we left town, and I remember actually having a discussion back in the back of the chamber with a member of the other body about its that it did exactly conform. It did not, very clearly did not. And my understanding was that the legislative goal this year was to bring this into conformity. My concern is that if we adopt this floor substitute, we are, number one, granting the first of what will become inevitably a long line of exceptions to this conformity bill. I really hope that we will consider rejecting this floor substitute in order to adhere to
what was represented last year and what I understood to be the goal this year. So I would hope that we will reject this, stick with the original, and pass this pure bill, which had broad bipartisan support.
Senator Eben, the chair recognizes the gentleman from Alexandria.
Yes, would the senator from Fairfax, the sponsor, yield for a question?
Certainly.
Senator Eben.
Thank you, Madam President. I'd ask the senator if he's seen email traffic from last year where representatives of business had agreed to include a carve-out for the derivative carriers as a compromise, and if that not, in fact, was why this is now in the bill.
Senator Barker?
Yes, there certainly was some email traffic. This is a little different from some of that, but what there was agreement in terms of how to proceed and making sure that there was separation of flight attendants and the pilots and those types of people who are covered by union contracts, and this would so it was designed not to interfere with those union contracts.
The question is,
Madam Chair, if I might just briefly respond.
The senator may continue.
Yes, the senator from Rockingham is clearly correct, and I was going to address that when we get to third reading on this issue. That last year there were what was represented to the Senate Commerce and Labor Committee was clearly inaccurate in a wide variety of situations. Who was covered? How you calculate overtime pay and damages just being some of the issues that were different. We had adhered to this. The bill was introduced in a particular way. The only provision that is not completely consistent with the Fair Labor Standards Act is the one covering these individuals who work in airports and would, by and large, be covered if they were anywhere else, because of a conflict between the Railroad Labor Act and the Fair Labor Standards Act. And so what we need to do is, this is a provision, and this is one category of employees, and certainly I have no intention whatsoever of trying to use this as a Christmas tree. So we'll, I would hope it would be a pleasure of the body to adopt this floor substitute.
The question is, shall the floor substitute be adopted? Those in favor will say aye.
Aye.
Those opposed, no. The floor substitute is rejected. There being 8 hands, and apparently the chair was uncertain, we will now move to a recorded vote. Those in agreement with the floor substitute will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The floor substitute is agreed to. The gentleman from Southern Fairfax County.
Yes, I move to engross and advance this bill now to its third reading.
The question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed and advanced to its third reading.
Thank you.
Senate Bill 643, firearms removing, altering, etc., serial number, selling, etc., or possessing. Reported from the Committee on the Judiciary with a substitute, and from the Committee on Finance and Appropriations with a substitute, and there is a floor substitute.
The gentleman from Alexandria, Senator Eben.
Thank you, Madam President. In order to get to the substitute from the Committee on Finance and Appropriations, I move that we reject the Committee on Judiciary substitute.
For what purpose does the gentleman from Virginia Beach rise?
Madam Chair, Madam President, speaking to that motion, because
I'd
like
the senator has the floor.
Thank you, Madam Chair. Madam President, I would like us to reject the Finance Committee substitute, and speaking to that measure.
Point of order.
That's not the one before us. That's not the one before us yet, Senator. It's the the next one. That will be the next one.
Got it. I'm sorry. As you were, Madam President.
Senator Eben, will you restate?
Yes, with the recommendation that it be rejected, I move that the report from the Committee on Judiciary be the substitute be accepted.
The question is, with the recommendation that it be rejected, shall the committee substitute from the Committee on the Judiciary be agreed to? Those in favor will say aye. Those opposed, no.
No.
The substitute from the Committee on the Judiciary is rejected. Senator Eben.
Thank you. I now move that we agree to the substitute from the Committee on Finance and Appropriations. And speaking to that motion.
The senior senator from Virginia Beach. Actually, no.
Him first.
The patron must speak first. Senator Eben.
Yes. So speaking to that motion, this bill has to do with people who would distribute a firearm that has had the serial number removed. The language that is before you from the Finance Committee substitute was developed in collaboration with the Virginia Citizens Defense League, with the State Police Association, prosecutors, and several gun safety groups. The bill makes it a Class 6 felony to knowingly transfer a firearm whose serial number has been purposefully removed, altered, or destroyed, which brings it into conformity with federal law. It also makes it a Class 1 misdemeanor to possess a firearm whose serial number has been removed, altered, or destroyed. Currently, the law states that it's a Class 1 misdemeanor to remove the serial number itself, but we heard from prosecutors that they had found the guns but not found people who actually were in the process of removing the serial numbers at that time. But other language from the original statute was updated in collaboration with VACDL.
The gentleman, the senior senator from Virginia Beach. Senator, the staff.
Madam President, speaking to the measure.
The senator has the floor.
Madam President, where I know the gentleman from Alexandria is trying to solve a problem, but what he's done is he's created another group of felonies, and he has not completely solved the problem. As a matter of fact, he's made the problem worse, Madam President. And let me explain a little bit behind that. First of all, I want to say that the underlying code still has some issues that need to be addressed, and I agree to that. But what this substitute that the Finance Committee has passed out, and working with with VCDL, the state police, working with NRA, and our Sheriff's Association, I've got to tell you that we've tried to fix a majority of the problems, but let me point out those problems, Madam President. So the first problem with this is, as many in the body here know, that when you have a handgun, the serial number is on the frame of the handgun. And a lot of individuals who like to change and make their handgun either easier to use or more competition friendly, or in some instances, some may Cerakote it to change the color of that gun, because some of us really like our different colors, and that's okay. But Madam President, if that slide, which normally has the manufacturer of the weapon and the model number of that weapon, is switched out, now that becomes a Class 1 misdemeanor. Now, Madam President, if I Cerakote that, Cerakote is adding a Teflon coating to it, and that in any way changes, obscures, or modifies any of those, the model, the serial number, or the manufacturer, because I'm here to, like some folks in this body, maybe the gentle lady from Portsmouth who likes purple, and we all agree purple's a pretty cool color. We want to Cerakote this and turn it purple, and I did that for her. So not only am I guilty of changing or modifying it, I am obscuring it, and I'm guilty of a Class 6 felony for doing it for her. Now, as soon as I give that back to her, she's guilty of a Class 6 felony as well. So we've just created another class of felonies. Now, Madam President, let me explain another situation. So a lot of us here are familiar with ARs. You've got some that are 223.556. That's your primary AR platform. Let's say I want to go hunting in Ohio. Well, you can't use a 223.556 in Ohio. You have to use a 350 Legend. To change that, the serial number is on your lower. I can swap it out today and swap out the upper to a 350 Legend and be okay to hunt in Ohio. Under this law, if I do that, now I'm guilty of a Class 6 misdemeanor because I've swapped out that upper, and it could be done. It could be manufactured by one of 54 different manufacturers, and because I've changed the manufacturer and because I've changed that piece of it, I'm now guilty of a crime. And Madam President, let me explain one other thing to you. So when I have a Glock, an H&K, a SIG, a Beretta, just about any handgun, and I don't like the slide on it because it's too stiff to pull back and release, and I put on an easier slide, and let's say that the original gun is a Glock, SIG, Beretta, but the slide I want to do is one of the competition slides, like a Brynells, a Lone Wolf, Damascus Steel, and Agency Arms, something that's really made to do it more frequently and easier, sliding that back. Well, now I'm guilty of a Class 6 misdemeanor. And Madam President, I know that's not the intention of the gentleman from Alexander, but the unintended consequences of this have made that now a Class 6. Now let's take it into something that may be more current and relevant, the Olympics. So any of the Olympic competition shooters, they're using either a .22 caliber rimfire or they're using a .177 caliber. Either one of those. When you have your frame and you're comfortable with that frame and you're swapping it out depending on the competition you're using, and those are all third-party aftermarket slides on that in different barrels to shoot a .177 or a .22 rimfire. When you swap that out, and if I were the armor for the Olympic team stationed here in Virginia, then I'd be guilty of a Class 6 felony. When I give that gun back to that Olympic athlete, now that Olympic athlete's guilty of a crime. So I know that's not the intended underlying issue he's trying to cover under this bill, but that's the unintended consequences of this. Now, the floor substitute I provided fixes all of the instances I've just explained to you, but there's one piece that the floor substitute has not fixed, and that's if my grandfather has a weapon that somebody intentionally ground out the serial number of, and my grandfather gives that gun to me, or I inherit that weapon, then that's still a Class 6 misdemeanor. Well, Madam President, what I'm trying to make sure here is that we cover as many things as possible on that. I may not like that's still an issue, but I'm sure that I've not created another entire class of felons in the state of Virginia. I'm sure that I've taken a group of competitive shooters who now, under the substitute from the Finance Committee, would be breaking the law, and that's not what any of us want in this body. We're trying to go after criminals, and the way this bill is structured, it does not do that. Madam President, I'm happy to answer any questions about this. I'm happy to go into any further detail. I can talk about this all day long. And I'll tell you that one of the other things in the underlying code section and the substitute coming from finance is we actually keep referring to machine guns. And the way we're doing that, we're referring to it as ATF. Well, machine guns are NFAs. They're covered under a separate part of the ATF laws. And as a matter of fact, it has a separate system that has federal stamps that you have to have with it, and it has federal background checks that are completely different, but it's covered under a different section of the code. The reason I bring that up is because the way it's structured here, we call this like a Toyota, and we're comparing it to a Formula One racer. We're putting the two sections of the code together that weren't meant to be that way. And on the federal level, it's structured differently for just that reason. Here, we're trying to combine them all together, and it doesn't work. So, Madam President, we've worked with a lot of folks trying to fix this with what's the floor substitute that I provided today and gets to 95% of fixing every issue with this bill. But, Madam President, if we pass or we accept what's in the Finance Committee's recommendation and the Finance Committee substitute, we've just created another class or group of felons in the state of Virginia, and we've just made a whole bunch of competition-type folks to include Olympic athletes. We've just made them lawbreakers. And we've made them where they've now come under a Class 1 misdemeanor or a Class 6 felon, depending on how they wanted to do it. Madam President, that's my concern with this bill. And the gentleman from Alexandria, we've talked about this multiple times. I've actually, the first day I saw this bill, the substitute from the Finance Committee, I provided him with a 10-point analysis I had done on the floor here that went through each and every one of these issues and then worked with our wonderful attorneys up in LIS to correct that, then send it around to the NRA, VCDL, State Police, Sheriff's Association. We sent it around to everybody to see if anyone had any issues with it. And, Madam President, we didn't hear of any issues, and everybody was much happier knowing the unintended consequences of the underlying floor substitute that came from the Finance Committee. Madam President, happy to answer any questions on this. But with this, I hope we would reject the Finance Committee substitute and adopt the substitute that I provided here today on the floor.
Madam President, would the gentleman yield for question? Over here.
The senator from Loudoun, Senator Bell.
Thank you, Madam President. The gentleman, I asked a question. If I'm understanding you right, you wanted basically this to only be a Class 1 misdemeanor in all areas. Is that correct?
Senator DeStaff.
Madam President, Senator Bell, that is not correct. I'm okay with the felony side of this when it's willful and intentional and it's going that direction. And as a matter of fact, on the substitute that I provided on this, if you take a look on...
Madam President, if I can clarify my question.
The gentleman from Loudoun.
Yep. Thank you, Madam President. What I'm looking at is I noticed you changed the penalties to Class 1 misdemeanor, except for on line 2526, it's still a Class 6 felony, and I just wanted to make sure if that was your intention. Thank you, Madam President.
Senator DeStaff.
Madam President, to answer the gentleman's question, the other two were Class 6 misdemeanors in the Finance Committee substitute, and the last portion of that on line 26 in Section C, it was a Class 6 felony. I've not changed any of that. What I did change was the manufacturer, model number, and eliminated where it refers to machine gun because that's covered under a different section of law, and that truly conflicts with the way this was written here. So we tried to bring it all in line and make it easier to be able to swap out your uppers and lowers when you're doing it for the appropriate reasons, and to make sure that you can legally swap out on a handgun if you want to change the slide to make it easier to slide back, or we want to make sure that our Olympiad athletes or our high school shooting teams don't get any trouble, college as well.
I thank the gentleman.
Thank you, Madam President.
Gentleman from Spotsylvania, Senator Reeves.
Thank you, Madam President. Will the gentleman from Virginia Beach rise for a question?
Will the gentleman from Virginia Beach yield?
Madam President, I'm happy to yield.
Senator Reeves.
Madam President, just to be perfectly clear to the gentleman from Virginia Beach, so I understand how you rewrote the floor substitute. So if I took my Glock 19 and put a speed rail or a hex fire slide on it, I'd still be legal under your substitute?
Senator DeStaff.
Madam President, Senator Reeves, you would not have an illegal weapon at that point in time. If we accepted the floor substitute, the way I've drafted this, that would be perfectly fine. If we accept the Finance Committee substitute, then you'd be guilty of a Class 6 misdemeanor.
Madam President, just
gentleman
one
from
quick follow-up.
Spotsylvania.
So the same would be said of my lower on my 5.56, and I wanted to go hunt deer with a 300 blackout upper, which many military use all the time in our Commonwealth. Without your bill, then they would be illegal.
Senator DeStaff.
Madam President, that's absolutely correct. Without the substitute that I provided on the floor, if we accepted the finance substitute, that would be, in that case, illegal. If we accept the floor substitute, that would be absolutely fine to do.
Thank you, Madam President.
So, Madam President, if I may wrap it up. Madam President,
Senator DeStefano.
I would suggest and hope that the body would reject the Finance Committee substitute and adopt the floor substitute that I've provided. Thank you very much for your time.
The gentleman from Alexandria, the patron, Senator Eben.
Briefly, if no one else wishes to speak.
The senator has the floor.
I appreciated the senator from Virginia Beach providing me with a memo on his objections, which I shared with my local prosecutor, who provided me with a 5-page legal memo of rebuttal, which I will not read in its entirety. Very briefly, he points out, and when I spoke to the representative of the NRA, he said that they had not been able to agree on the language that the gentleman from Virginia Beach proposes, first paragraphs B and C, that their lawyer hadn't fully analyzed it. But the word willfully, adding willfully on lines 21 and 24 makes this bill completely unusable. Add willful to B and C would require prosecutors to prove the intent of two separate people to use the statute, the processor or the seller and the person who changed the serial number, who we'll call the changer. The changer is likely to be a mystery person. Even if they're not a mystery person, willful is the highest intent standard and very unlikely to ever be met by a prosecutor in dealing with this fact pattern. It's important to note that most guns have serial numbers in more than one place, and further, there is reason to include machine guns. The goal we're hoping with this bill is to remove guns with serial numbers, without serial numbers from our streets. It's not touched on directly by any other machine gun section in the code. So with that, I would ask that we accept the Finance Committee substitute that was vetted with the NRA, the VA, CDL, prosecutors, and gun safety groups.
Having spoken to the measure twice, the Senate being without objection, Senator DeStefano.
Madam President, if I may, I've only spoke to the measure once at this point, but I'm happy to speak again and just clarify here.
Senator DeStefano.
If there's
Senator
an objection,
DeStefano.
I'm happy to sit down. But, Madam President, I want us to know if we accept this Finance Committee substitute, which the NRA did, in fact, review and approve, and they're in alignment with paragraph A, as well as all of the other groups are good with the entirety of this. If we accept the Finance Committee substitute, what we're doing is we're creating another class of felons and another class of criminals in the state of Virginia when that's not the underlying intent of the bill, in my opinion. Thank you.
With the recommendation, he agreed. All right. You're wanting to agree to it?
Just to restate the motion.
Yes, sir.
I move that we accept the Finance Committee substitute.
The question is, shall the Finance and Appropriations substitute be agreed to? Those in favor will say aye. Aye. Those opposed, no. No. The substitute is agreed to. Which now means the floor substitute is out of order, if I'm not mistaken. You want 8 hands. 8 hands is called for. I am very uncertain today. Therefore, this will be a recorded vote. Those in favor of agreeing to the committee substitute will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The committee substitute is agreed to.
Hey, Lindley, redo the thing.
It normally does it itself. I've learned.
The chair now recognizes again the senator from Alexandria, Senator Eben, since the gentleman's floor substitute is out of order, and it won't be taken up.
I now move that SB 643 be engrossed and advanced to its third constitutional reading.
The question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 655, unemployment compensation required.
The gentleman from Spotsylvania, Senator Reeves.
I hate to do this and break the cycle a little bit before we get too far along. Having voted on the prevailing side in which Senate Bill 391 passed, I ask that that vote be reconsidered.
What page is that, sir?
That would be page 9.
We'd have to finish this section before we come back to it.
Thank you,
All right?
Madam President. Yes, ma'am.
Yes, sir. Continuing. Oh, all right. Senator Eben, the gentleman from Alexandria.
Thank you, Madam President. I move that on SB 655 that we reject the Committee on Commerce and Labor substitute in order to get to the Finance substitute.
With the recommendation that it be rejected, the question is, shall the substitute from the Committee on Commerce and Labor be rejected, be accepted? All those in favor will say aye. Those opposed, no. The substitute is rejected. Senator Eben.
I now move that the Committee on Finance and Appropriations substitute be accepted.
The question is, shall the substitute from the Committee on Finance and Appropriations be accepted? Those in favor will say aye.
Aye.
Those opposed, no. The committee substitute is accepted. Finally, Senator Eben.
I now move that the SB 655 be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 687, abuse and neglect, financial exploitation, changes term and incapacitated adults, penalties. Reported from the Committee on the Judiciary with a substitute and from the Committee on Finance and Appropriations.
The gentleman from Williamsburg, Senator Mason.
Thank you, Madam President. Madam President, I move that the substitute be agreed to.
Question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. The gentleman from Williamsburg.
Madam President, I move the bill be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 706, trucks operation in certain weather conditions. Reported for the Committee on Transportation with a substitute.
The gentleman from Western Fairfax County, Senator Marsden.
Thank you, Madam President. I move that the committee substitute be agreed to.
Question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. The gentleman from Western Fairfax County.
Thank you, Madam President. I move that the bill be engrossed and passed to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 708, driving decarbonization program and fund created. Reported from the Committee on Finance and Appropriations.
Gentleman again from Western Fairfax County, Senator Marsden.
Thank you, Madam President. I move that the bill be engrossed and passed to its third reading.
Question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 727, Virginia Football Stadium Authority established definitions report. Reported from the Committee on Finance and Appropriations with a substitute, and there is a floor amendment.
The senior senator from Fairfax County, Senator Saslaw.
Madam President, I would move that we adopt the Senate Finance and Appropriations substitute.
The question is, shall the substitute be adopted? Those in favor will say aye. Those opposed, no. The substitute is adopted. The gentleman from...
I would yield to the senator from Bedford for a floor amendment.
The senator from Bedford, Senator Newman.
Madam Chairman, I move that we waive the reading of the floor amendment.
Question is, shall the reading of the floor amendment be waived? Those in favor will say aye.
Aye.
Those opposed, no. The reading of the floor amendment is waived. Senator Newman.
Madam Chairman, we made a lot of progress in the Committee on Finance in regards to this bill, and a number of those will be explained soon. One of the items that was discussed but was not picked up in the substitute is one related to sports bet. It's come to my attention from a number of members, including the senator from Prince William and the senator from James City, that we have already put into the previous legislation that sports bet is allowed. However, without this piece of legislation that's in the floor amendment, then it is unclear whether or not the tax that is generated from this would be kind of exempt from coming back to the Commonwealth. This cleans that up and ensures that is our money and is not included in the bonded money.
You're moving the floor amendment?
Madam Chair, I move that the floor amendment be agreed to.
The question is, shall the floor amendment be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The floor amendment is agreed to. The senior senator from Fairfax County, Senator Saslaw.
I now move that Senate Bill 727 in form of substitute with a floor amendment be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 740, Common Interest Committees, Communities, Standards for Structural Integrity, and Reserves for Capital Components. Reported from the Committee on General Laws and Technology with a substitute, and from the Committee on Finance and Appropriations with amendments.
Gentleman from Eastern Fairfax County, Senator Soroval.
Thank you, Madam President. I would move the Committee on General Laws substitute.
The question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Soroval.
Thank you, Madam President. I would move the Committee on Finance and Appropriation amendments.
Question is, shall the committee amendments be agreed to? Those in favor will say aye. Aye. Those opposed, no. The committee amendments are agreed to. Gentleman from Eastern Fairfax County.
Thank you, Madam President. I move the bill be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 742, Marijuana Expungement of Offenses, Civil Penalties. Reported from the Committee on the Judiciary with amendments, and from the Committee on Finance and Appropriations.
Senator Soroval, the gentleman from Eastern Fairfax County.
Thank you, Madam President. I would move the Committee on Judiciary amendments.
Question is, shall the committee amendments be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The committee amendments are agreed to. Senator Soroval.
Thank you, Madam President. I'd move that the bill be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third constitutional reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 745, Parole Exception to Limitation on Application of Parole Statutes, Felony Marijuana Convictions. Reported from the Committee on the Judiciary with a substitute, and from the Committee on Finance and Appropriations with an amendment.
Gentleman again from Eastern Fairfax County, Senator Soroval.
Thank you, Madam President. I would move the Committee on Rehabilitation and Social Services substitute.
Question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Soroval.
Thank you, Madam President. I would move the Committee on Finance and Appropriation amendment.
Question is, shall the committee amendments be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The committee amendments are agreed to. The gentleman from Eastern Fairfax County.
Thank you, Madam President. I'd move the bill be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. Bill is engrossed and advanced to its third reading.
Senate Bill 704, School Health Services Information, Superintendent of Public Instruction to Survey School Division. Reported from the Committee on Rules.
The junior senator from Virginia Beach, Senator Kiggins.
Madam President, I move that Senate Bill 704 be engrossed and advanced to its third constitutional reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor of the motion will say aye. Those opposed, no. The bill is engrossed in advance to its third reading. The senior senator from Fairfax County, Senator Saslaw.
Madam President, I move that all Senate bills now on third reading on the regular calendar, pages 22 through 30, that's Senate Bill 36 through 704, that the rules be suspended and the third constitutional reading of the titles be dispensed with.
The question is, shall the rules be suspended and the third reading of the titles of the bills be dispensed with? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The reading of the titles is dispensed with. The bills are now before the Senate on their final passage. Returning to page 22.
Senate Bill 36, Senate Bill.
We got to take the individual vote.
Okay. Senate Bill 36.
The gentleman from James City County, Senator Normand.
Thank you very much, Madam President. I would respectfully move that Senate Bill 36 pass as amended. Speaking to the bill, please. Thank you very much.
The senator has the floor.
Ladies and gentlemen, Senate Bill 36 is one that you are familiar with, and the reason I say you are familiar with, as far as the substantive provisions are concerned, in 2020, that bill came out of, without some of the amendments I've made, came out of Education and Health 12-3, passed the Senate 28-11, and the House 81-15. A lot of the bill has merely been restructured to make it read in a little more presentable fashion. And I say that as far as some of the offenses that are recited in it. And as you look through lines 26 through 31 on it, most of, if not all of those provisions were primarily contained in the original bill. Where the really substantive changes have come about is the requirement that in certain instances the principal must report to the superintendent or other administrators in law enforcement when criminal offenses have been committed by a student. And I listened very carefully to some of the comments and concerns that were raised in education and health, and perhaps I'm being too pragmatic. I appreciate that there are certain students that have either emotional, mental, or some disability issues, and we have tried to carve out those objections. And as I indicated to you, I'll continue to work to evolve language that would improve that situation. But as I also pointed out to you, there is also on the last paragraph an alternative school discipline process that's available, as well as provisions that are already in Title 22 of the Code of Virginia. What has changed is that there are certain provisions where the principal must advise the parents, and to me that does not seem to be so egregious. We've spent a lot of time talking about parental involvement and commitment, and I think there's some very positives to doing that. So, Madam President, I would respectfully ask that Senate Bill 36 pass.
The gentlelady from Arlington, Senator Favola.
Thank you, Madam President. Would the senator from James City County rise for a question?
Will the senator from James City yield for a question?
I would be happy to.
Senator Favola.
Thank you, Madam President. Can you help me understand? I'm going to give you an example, and maybe you can tell me how this example would apply to now our amended bill. So you have a young student maybe in middle school, 8th grade, 9th grade, student wants to see how strong this baseball is. And he deliberately throws the baseball into a school window, shattering the window. And it's, let's just say the window is fairly costly. The school, just instituted the double pane stuff. But this young man thought it would be a great test to see this baseball, how strong his baseball was, how good his arm was, and he's 13 years old. Would the principal in that situation be required to turn that incident and report that child to the superintendent and law enforcement?
Senator from James City County.
Madam President, my response would be, one, as long as it was not coupled with any threat that was made to an individual or another student, it would not be required. What that, in fact, would be is a property damage situation which doesn't fall within alcohol, assault and battery, sexual assault, threats against personnel, firearms, firebombs, other threats, or a threat to another student. So I would say, no, that's a property damage situation. Also, I would say, from a practitioner's standpoint, my experience has been that many times, even though these incidents, not the hardball, but other situations are reported to law enforcement, that there is always the opportunity, particularly if they are a juvenile, to do a diversionary activity rather than run it through the court systems. And that is very, very common unless a student has a fairly egregious history of prior offenses.
Follow-up question, Madam President.
Will the gentleman yield for another question?
That was going to be my next question.
Senator Favola.
Thank you, Madam President. Could the principal, let's just say a threat was involved in this, okay, so it meets the criteria that you have in your bill. Could the principal recommend a diversion program when she is reporting the incident to the superintendent and to law enforcement, knowing that she's had experience with this child, knows this child, and believes this was a one-off?
Gentleman from James City County.
Madam President, I believe, once again, as long as it's a property damage situation that doesn't result from any of the criteria that I just reviewed with you, ranging from alcohol to bomb threats, I think that, in fact, the principal can do that. But be mindful, in most instances, other than maybe late juniors and seniors, we're still dealing with juveniles that afford a diversionary process, and this is not designed to be onerous to those type of students.
Thank you, Madam President.
The senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. Speaking to the bill.
The senator has the floor.
I just wanted to clarify what this bill does that is new, because I think there has been some confusion or misinformation about what we did in 2020 that some people think this bill fixes, but it was never a problem. And that is, under current law, and this bill does not change this, any activity that could constitute a crime, whether a misdemeanor or a felony, must be reported to the parents of the children involved. What the senator from James City has done is moved where that code section is. But if you look at lines 107 to 112, that has always been the law. So I want to make sure, for people who think this is just a parental notification bill, parental notification was already the law. What is new, and the senator from James City has rewritten this code section, which was, and some would argue still is, confusing. The one new piece is that in 2020, we made it discretionary for the principal to report to law enforcement certain things that were misdemeanors. As amended, this bill puts back in a mandatory reporting posture misdemeanor sexual assault offenses. There's going to be a policy decision, and I recognize that, on whether that should be mandatory or not. I would submit that is a decision that should be left to the family, the parents, and the child involved. By mandatory reporting, that takes away agency from that family. Is this something that we can handle? Is this something that can be handled through the disciplinary process or not? And this mostly comes up with little children who don't understand that certain activity could be sexual. It's probably not meant to be sexual. It also comes up with those children that we've discussed who have disabilities. But the bill in 2020 was a result of a study that showed Virginia led the nation in referring kids to law enforcement. And it disproportionately impacted children of color and children with disabilities. And this was one of a package of bills to try to alleviate that problem by recognizing kids are going to do things that technically are crimes, but if they are misdemeanors and can be handled through a discipline process or some other way, they should be. Now, again, I recognize there's just going to be a policy dispute over whether that should apply to misdemeanor sexual assault. But I want to be clear on what the bill does and what it doesn't do and what is already in and isn't in current law. Thank you, Madam President.
Senator Boysko, the gentlewoman from Northern Fairfax County.
Thank you, Madam President. Question for the Senior Center from Richmond.
Will the senator rise?
I yield.
Senator Boysko.
Thank you, Madam President. I have a question of clarification. Is there an age limit on a student who could be charged with a misdemeanor sexual assault? Like, would a first grader who pulled down somebody else's pants or slapped somebody on the behind, would they be subject to this policy?
Senator McClellan.
So to clarify, this section of the code does not deal with charges. It is a first step to whether charges can be filed, and that is referral to law enforcement. So I just want to clarify that. But to answer the senator's question, yes, the two examples she gives would technically constitute misdemeanor sexual assault because they are unwanted touching of a sexual nature, and that child, regardless of age, would have to be, under this bill, reported to law enforcement.
Madam President.
Further question? Senator Boysko?
Speaking to the bill.
The senator has the floor.
Thank you, Madam President. I had intended to vote for this bill. I know that we want to make sure that families and parents are informed and understand what's going on when an occurrence happens in a school. However, after getting the clarification from my senior senator from Richmond, I have great trepidation in bringing the police into a 6-year-old who might have slapped a classmate on the bottom or pulled down their pants. And so because of that, I will not be able to vote for this bill.
The senator from Fairfax City, Senator Peterson.
Thank you, Madam President. Speak to the bill.
The senator has the floor.
Madam President, it just sort of in the deep recesses of my mind, I tend to remember that any act by a child under the age of 14 comes with a presumption that it is an act by an infant. And an act by a child under age 7, that presumption is conclusive. So people want to go around saying that 6-year-olds are going to get charged with it. That doesn't happen, okay? So I just want everyone to be clear. This bill didn't come out of a vacuum. And the problem is not, and believe me, nobody believes more in parental rights than I do, okay? But the problem is not the parents of the first child that is the subject of an assault. It's the parents of the second child that didn't know about the parents of the first child. That's the issue, folks. And so this is not about 6-year-olds, okay? Let's stop pretending that's the issue. This is about teenagers, and I was a teenager, and I'm a parent of teenagers. And, again, I'm not saying what happened is prevalent, but there have been incidents that have occurred that have caused people to question whether or not we are taking seriously sexual assault within our schools. And this bill is intended to address that for better or for worse. It's not about 6-year-olds.
Madam President.
The gentleman from Western Fairfax County, Senator Marsden.
Thank you, Madam President. Speak to the bill.
The senator has the floor.
Discretion it seems we're more and more beginning to remove discretion from our laws and the way we treat our children. We have exercised discretion in terms of who we now incarcerate in our juvenile detention centers. And we've gone from 1,440 kids in 2002 when I left the Department of Juvenile Justice, and today we're at 500 because we're using better discretion, we're using tools, we're using judgment to do that. And these situations are irreversible. Once you start down the police path, that's where you're likely to end up. When you start on the discretion path, you're likely to solve the problem and not try to teach somebody a lesson. We want to solve the problems, and let our principals, let our school staff, let our parents discuss this, make a determination as what's in the best interest of both kids involved to make sure that this doesn't become something that does damage to the victim, does damage to the perpetrator. And it may not be a perpetrator. It may not be a damaged child. It may be something that just gets out of hand and always ends up with law enforcement because people are concerned. Let's exercise discretion. Let's have our police, let's have our school system exercise that discretion, and let's not go down this road. Thank you.
Chair again recognizes the patron, Senator Norman.
Thank you, Madam President. If no one else desires to speak.
Senator has the floor.
I want to thank the senator from Fairfax City because I hope that point was not lost on you, that he reminded you what the law is and has been in Virginia for many years if you're 7 or younger. The fact example that was, I think, somewhat exaggerated about a young child pulling down the pants of another one as a matter of law would not fall within the parameters of this bill. Secondly, there is the presumption from 7 to 14 again. And I'm interested in hearing the word discretion because that's exactly what I wrote down on the top of this bill as I was listening to the comments. And there is an awful lot of discretion that is involved here, still within the principal, still within the superintendent, and determining whether or not a crime has been committed. And I suggest to you that I, as an individual, believe that if there is, in fact, a sexual assault, and it is a sexual assault by a student who is of the age that can be held accountable, then it should be reported and that, in fact, the parents should be aware of it. However, in almost all instances, there still will be an opportunity for diversion. Just because a principal reports to a superintendent and law enforcement does not automatically mean that that student is going to go out and get arrested. There are many safeguards that are built into the system whereby they are screened if they are a juvenile, that they are screened by the juvenile authorities, they are screened by the Commonwealth Attorney's authorities to determine whether or not, in fact, a criminal offense has taken place. So it doesn't mean just because it's reported that the ladies and gentlemen in blue are going to show up and arrest this child. So I appreciate the differences of opinion. I will continue to work on the bill if this body deems it appropriate to report it, but I do request that the bill be reported.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 26, noes 14.
Ayes 26, noes 14. The bill passes. The gentleman from Tazewell, Senator Hackworth.
Madam President, having voted on the prevailing side of Senate Bill 313, I move to reconsider the vote. On page number 23. What's the motion on it? vote which we took by for the day. I'm sorry.
Yes, sir. We're checking to see if you were on the prevailing side.
I was.
I'm going to pass back temporarily.
The question is,
Madam President, substitute motion.
the senator from James City County, Senator Norman.
Madam President, I'd respectfully ask to be passed by temporarily.
Without objection, it is so moved. Senate Bill 313 is passed by temporarily.
Madam President.
Senator Reeves, gentleman from Spotsylvania.
Thank you, ma'am. Since we're doing reconsideration, earlier I asked when we were in another block if I haven't voted on the prevailing side in which we passed Senate Bill 391.
We're still in the same section, so we've got to get to it.
Yes, ma'am.
Page 24, Senate Bill 631.
Gentleman from Southern Fairfax County, Senator Barker.
Yes, Madam President, I move passage of 631. And speaking to the measure.
The senator has the floor.
All right. I reviewed a good bit of it yesterday and more earlier today on second read. What I'll do now is just highlight a couple of things as it relates to this bill. The senator from Rockingham County who spoke earlier on this bill was absolutely correct. Last year, and that's really the fundamental reason this bill is before us now. Last year, there was a bill put in on the House side to have an overtime section of the code in Virginia, which we had never had before. We had relied really on, in terms of overtime, the Federal Fair Labor Standards Act. When the patron came to the Commerce and Labor Committee the last week of the session last year, there were numerous comments that were made about it being consistent with the Fair Labor Standards Act, which it clearly was not in several different respects, and other things that in effect created the problem that we had passed something without having it correctly and properly explained. We in this body and we in the Assembly together with the members of the House, it is critical that we have integrity in terms of how we handle things, that we have consistency, that we have the legislation that we are considering be properly explained, and that was not done. And so I think what this bill does now is moves us in the direction of undoing, basically coming up with a bill that with legislation that is reflective of what was said last year, but does not go beyond that since there was a real problem on that. And I would hope that we would have it would be the pleasure of the body to adopt this bill and pass the legislation now.
Chair recognizes the junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Madam President, would the gentleman from Fairfax yield for a question?
Certainly.
Will the gentleman yield? The gentleman yields. Senator Morrissey.
Thank you, Madam President. I would ask the gentleman that some individuals have suggested that this bill weakens the wage theft that we tried to address last year. Can you address that, please?
Senator Barker.
The most fundamental aspect of this bill really is the overtime thing. I'm not aware of any weakening of wage theft, but if that would be something that we would address in the future, I'd be happy to do that.
I thank the senator.
Question is, Senator Newman, the senator from Bedford.
Madam President, speaking briefly to the bill.
The senator has the floor.
Madam President, there still is an unresolved issue about whether or not the amendment that went on the floor is a good idea or not. I did not care for that carve out because I think it does begin a Christmas tree. But I hope every member of the Senate will consider voting for the measure because ultimately what happened last year is very unfortunate in the business climate in Virginia, and therefore this bill does a lot of good, and I hope we can get it over to the other side for a continued discussion about the amendment that we had earlier. Thank you, Madam President.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 31, noes 8, Rule 36-1.
Ayes 31, noes 8, Rule 36-1. The bill passes.
Page 25, Senate Bill 643.
The gentleman from Alexandria, Senator Eben.
Thank you, Madam President. I move the bill pass, and speaking to that motion.
The gentleman has the floor.
This is the bill with the serialized firearms that have had serial numbers removed. And under federal law, as I stated before, it makes possessing, transporting, or delivering a gun with an altered serial number a 5-year felony. Under Virginia law, none of those things is a crime. With this bill, we will be able to have our local prosecutors act on such offenses. I move the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The bill passes.
Senate Bill 655.
Gentleman from Alexandria, Senator Eben.
Thank you, Madam President. I move that SB 655 pass, and speaking to that motion.
Senator has the floor.
This has to do with the VEC, and I view this as a complement to more comprehensive legislation from the senators from Prince William and Spotsylvania to improve the VEC. SB 655 does two things. It requires employers to submit information related to a claim electronically unless they're granted a waiver by the VEC, and that's one of the JLARC recommendations. And secondly, in keeping with the JLARC recommendations, it would require the VEC to tell us how they would conduct a pilot program of employers to provide separation report proactively to both the individuals and the VEC electronically. However, this pilot, it would be telling us how they would conduct the pilot program. The pilot program would not actually begin without our authority, and it would only be for employers of 15 or more employees. Again, I move the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 24, noes 16.
Ayes 24, noes 16. The bill passes.
Senate Bill 687.
The gentleman from Williamsburg, Senator Mason.
Thank you, Madam President. I move the bill pass. And speaking of the motion.
The senator has the floor.
Thank you, Madam President. Madam President, this year the gentleman from Rockingham and I had two bills from the Virginia Criminal Justice Conference. He moved one on, and this one's the other. This was designed to try to clean up portions of the code that previously referred to incapacitated adults and has changed the definition to vulnerable adults, which does expand to some extent folks that are included. It's designed to try to avoid elder abuse and neglect from people that can't protect themselves. And that was the cleanup of the bill, Madam President. I move it pass.
The question is, the gentleman from King Stewart, Senator Stewart, King George, Senator Stewart.
Thank you, Madam President. Speaking to the bill.
Senator has the floor.
Madam President, with some trepidation, I rise on this, but I spoke to the gentleman from Williamsburg a little while ago. I looked at this bill in committee and I abstained. Had a little bit of concern, and I just, not asking you all to vote no, but just give this a little bit of thought. When we initially drafted this statute, I worked really hard with Attorney General Mark Herring when he was still in the Senate to come up with some language that was relatively narrow. And now when you go down to the definition of vulnerable adult on line 89, we are broadening that dramatically. If you read that definition, now it's broadening the class of people that can come into it. And what really concerns me is we're placing a reasonableness standard. And what I mean by that is I think every one of us should have the right to make bad decisions. And it concerns me anytime somebody else gets to change what they believe is right for us. And that's what concerns me in this. And so if you just look at that, and I think I just ultimately object to broadening this so much because there are a bunch of people that may get caught up in it as time moves on. And this is a criminal statute. And I know, I'm not even sure you can use a reasonable standard in a criminal statute, but somebody put it in here, so it must be so. But I'm not sure we should be substituting what is reasonable by a court or somebody else for our own judgment. I think we should have the right to make our own decisions. Now, when people take advantage of people because they have a mental incapacity, then we should prosecute them for it. But this is going way beyond that, and what I really see is a drastic expansion of it, and I think we should really take pause at that.
Senator Sorovell, the gentleman from Eastern Fairfax County.
Thank you, Madam President. Speaking to the bill.
Senator has the floor.
Thank you, Madam President. And Senator Stewart raised, the senator from King George raised this issue in Judiciary when we were vetting this bill, and wish I'd focused a little more carefully on it. I have some similar concerns. I'll just note that this came out of the VCJC, so it's been very heavily vetted. And the VCJC is the body where I think a lot of the prosecutors look at bills. But wouldn't be the first time we rejected a VCJC recommendation. I'll tell you that too. But I'll just note that what concerns me is two things. As Senator King George kind of hit on, number one is we typically don't use reasonable person standards or reasonableness standards in our criminal statutes because they're not sufficiently defined to put people on notice as to what the exact class of criminal conduct is that the statute covers. And it tends to allow a jury to sort of define what the crime is as opposed to the legislature. And the U.S. Supreme Court, blew up a 1911 1918 price-fixing statute during World War I because it used a reasonableness standard. The Supreme Court of Virginia blew up the noise ordinance statute. People from Virginia Beach might remember this, but the city of Virginia Beach had adopted a unreasonably loud noise statute or something, and the Supreme Court of Virginia blew it up because it was being selectively enforced on certain restaurants, and said you can't use a reasonable person standard in a statute. So it sort of treads on that. But more importantly, if you read it really carefully, under existing law, it says an incapacitated adult is somebody who has a disability, and because of that disability, they lack sufficient understanding or capacity to make or carry out reasonable decisions about themselves. This statute decouples their ability to make decisions from their incapacity. So you could have somebody who's perfectly mentally competent, but they have a physical disability that makes it hard for them to care for themselves, and that person becomes a vulnerable adult where you can be criminally prosecuted now. Whereas today, you have to have both an intellectual disability and be unable to care for yourself. That's the standard today. But if we were to adopt this, you could be completely mentally fine. Not a thing wrong with you mentally, but physically in a position where you can't care for yourself, and now you can be criminally prosecuted if somebody has a suspicion that there's some advantage being going on. And that's where it really broadens this up and basically gives a prosecutor a lot of weapons to go leverage somebody. And that's anytime we give the Commonwealth the ability to leverage somebody really hard in a criminal scenario, that always gives me pause. And so that's why I'm now a little worried about what we've done here. Thank you, Madam President.
Senator Obenshain, the gentleman from Rockingham County.
Madam President, I rise to speak to the bill.
The senator has the floor.
Madam President, members of the Senate, you know, we have experienced really an epidemic of financial abuse of elders and others who are disabled and vulnerable. And this represents the best effort of prosecutors and defense lawyers across the Commonwealth of Virginia to protect these people who are being robbed and their families who are being robbed. Senator from Eastern Fairfax talks about those who may be mentally competent but reliant upon others. That describes a lot of seniors right now. People who are homebound, whose families maybe during the past year have not been able to visit them, check on them, take care of them. And they've had to rely on others to take care of them. It puts them in a particularly vulnerable position because they know that this person who comes into my house every day is somebody I cannot really survive without. And these vulnerable adults are in a position in which people can and have been taking advantage of them and stealing from them to the extent of billions of dollars a year. It is a growth industry in Virginia. These are people who cannot protect themselves. And I would respectfully submit that this is a really important measure to help protect these who are amongst our most vulnerable citizens. So I would hope that we will pass this.
The gentleman from King George, Senator Stewart.
Madam President, if nobody else wishes to speak, I just wanted to respond to the gentleman from Rockingham.
The senator has the floor.
Thank you, Madam President. And I would respond to the gentleman, if you look at line 56 of the bill, the definition that's being struck of mental incapacity, and it says mental incapacity means that condition of a person existing at the time of the offense described in subsection A that prevents him from understanding the nature or consequence of the transaction or disposition of money or other thing of value involved in such offense. And I would submit to the gentleman that each one of those situations he just described to you of people being robbed would be covered under that definition. And so this is not a matter of trying to get at that. This is a matter of the VCJC expanding this really dramatically. And I want to get those people who are taking advantage of elder folks as well. That's why I worked really hard to draft this some years ago. But I think we should all take pause at broadening this and decoupling it, as the gentleman from Eastern Fairfax said. I think we're just giving too much to prosecutors in this case and ultimately may not benefit the folks we're trying to help.
The gentleman from Rockingham County, Senator Obenshain.
Madam President, speaking to the bill.
Senator has the floor.
At risk of making this a running debate, which I won't do, Senator from King George has it right in one respect, that this does expand the law. It does expand it beyond persons who are suffering from mental incapacity. And that's the problem, is that there are a lot of elders and a lot of homebound adults who are vulnerable to exploitation, who are being taken advantage of because of their particular vulnerabilities beyond simply mental incapacity. If someone is homebound and is reliant, cannot survive without the help of the person who comes into their home every day, they are especially vulnerable, even if they are 100% mentally competent. And if somebody is successful in talking that vulnerable adult into transferring or a bank account or naming them as payable on death beneficiaries of $1 million bank account, they should be able to be prosecuted for this, even if that person was competent because of their vulnerability. This does not unreasonably expand the law. I salute the gentleman from Williamsburg for his efforts. He and I have teamed up over the past couple of years in efforts to try and provide additional protections for these vulnerable citizens. So I hope the members will vote for this.
The gentleman from James City County, Senator Norman.
Thank you very much, Madam President. I rise to speak in support of Senate Bill 687.
The senator has the floor.
Ladies and gentlemen, I've been very blessed in life, and I wear a lot of different hats at different points during a week, and none of them fit particularly well because of the enormity of my head. But having said that, one of the positions that I enjoy on a part-time basis is an involvement with a bank, and I can tell you that in recent years, the concern of elder abuse on financial situations has been elevated enormously within the banking community, and many of the banks have instructed everyone from tellers on up as to how to be observant and sensitive to incidences that may suggest that there is elder abuse, but they can only do so much. With another hat that I wear, I have the opportunity on a very frequent basis to review estates. And when I use the term estates, I'm not just talking about the dearly departed. I am talking about those individuals who are incapacitated and may have guardianships or conservators. And my office is very vigilant where we see transactions that have taken place through checking accounts, savings accounts, or stock transactions to be certain that we are not observing anything that may cause concern for inquiry of a guardian, conservator, or other fiduciary who might be engaged in some nefarious financial transactions. So I rise in support of it, and I compliment the senator from Williamsburg in continuing to move this forward, and would ask that you support it.
The gentleman from Williamsburg, Senator Mason.
Thank you, Madam President. Madam President, I appreciate the members who've made some very solid points. I very rarely would stand up against a bunch of trial lawyers and try to tell them what they do for a living. Senator Spool suggests that I'd be quiet then. But, Madam President, I would like to point out that currently we changed the definition from incapacitated adult to vulnerable adult. And in the current definition, it says carry out reasonable decisions concerning their well-being. So that language is currently in the bill that we just transfer down. The early definition speaks to intellectual disabilities. We say intellectual or developmental disabilities. The expansion is here, Madam President. Has one or more limitations that substantially impair the adult's ability to independently provide for his daily needs or safeguard his person, property, or legal interests. So that seems to be the expansion, Madam President. I urge you to support the bill.
The question is, shall Senate Bill 687 pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 3.
Ayes 37, noes 3. The bill passes.
Madam President.
The gentleman from Loudoun, Senator Bell.
Thank you, Madam President. Having voted on the prevailing side by which we pass SB 631, move we reconsider the vote so a member may change their vote.
Page 24. Okay. The question is, shall the motion by which Senate Bill 631 passed. Be reconsidered. Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill is again before us. Senator Barker.
Madam President, I haven't been explained previously over a couple of days here. I renew my motion to pass the bill.
The question is, shall the bill pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 32, noes 8.
Ayes 32, noes 8. The bill again passes.
Senate Bill 706.
Gentleman from Western Fairfax County, Senator Marsden.
Thank you, Madam President. I move that the bill pass. And speaking to the bill.
The senator has the floor.
Thank you, Madam President. We all remember what occurred in early January with one of the most horrendous snowstorm traffic backups and catastrophes that the Commonwealth has experienced. It led to over 24 hours of people being stranded in their cars. Thank goodness no one was seriously hurt or was killed in that situation. Felt like there's some things that we could do. One of the main causes that we know, and they're doing a sort of an autopsy on what happened, and we haven't gotten that final report yet, but we do know there were a number of jackknife trucks. And it occurred to me, and I talked with some individuals, that it would be a good idea to try to keep trucks in the right-hand lane during these kinds of snowstorm, ice storm, freezing rain events while it's actively going on. And what we've finally done here is, while it's not a mandate, it is, if it's practicable and safe, that you should stay in the right-hand lane of a two-lane or more road if you are driving a 26,000-pound vehicle, and because that is the safe thing to do. It precludes a lot of attempts at passing under these circumstances, and we don't know all the causes of the jackknifes, but we do know that that could be something that would improve the odds of that not occurring in future storms. We also learned, and I appreciate the work that we did with and the support that we got from the Virginia Trucking Association, who also brought up the concern that people were using compression brakes and cruise control, and that could have been a potential cause. Although we don't have any proof of that, it is certainly something that you don't want to do in this kind of an active ice situation where the precipitation is still coming down out of the sky. And this is a secondary offense. So in other words, no police officer is going to be able to pull you over and say, I heard you use your compression brakes, or do you have cruise control? It's a secondary offense. If there is a jackknife, if there is an accident, the computer of the truck can be checked to see if there was a violation. So this isn't going to solve the problem of jackknife trucks in snow or anything else, but it's going to move you in a direction where you have a better chance that this will not occur. And it will bring attention to truck drivers everywhere that you need to exercise caution, especially when these events are just beginning, and to stay in the right-hand lane if that's practicable and safe, and to not use your cruise control or compression brakes. And again, I want to thank the Trucking Association for their assistance on this bill, and I ask that the bill pass.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Would the gentleman from Fairfax yield for a question?
Will the gentleman yield?
I yield.
The senator yields. Senator Morrissey.
Thank you, Madam President. I would preface my question with the comment that I thought it was an excellent bill until I saw the words on line 13, if reasonably possible. And I would ask the senator, do you not gut your entire bill by putting those words in there?
Senator Marsden.
Senator Morrissey, it certainly weakens the bill to a certain extent. But what I learned from talking with a number of truckers is that it may have created other dangerous situations, like a wall of trucks who were blocking other motorists from exiting the highway if everybody was in the right lane. Another circumstance that was brought to my attention is the move over law. You could have something on the shoulder, and the truck would be required by another Virginia law to move over. And so we did have to weaken the language a little bit in that circumstance. And we also had situations where trucks might need to move over to let somebody enter the highway from on an interstate from a merge lane. And so it was just a little bit tricky. And so we decided to make sure that truck drivers knew they should do this if practicable and safe, but we couldn't quite make it that affirmative.
I thank the senator speaking to the bill when possible.
The senator has the floor.
Thank you, Madam President. I would tell, Madam President, I tell the body that I'm going to support the bill, but I'll tell you this. There will not be a single individual who was ever convicted, any truck driver, for driving in the left or the center lanes with this legislation. I thought that the goal of the bill, the genesis of it was very noble. When you have that sleet and that rain and that snow, get the trucks over to the right-hand side so it's not splashing onto your windshields. However, with that said, let me assure you that if any trucker is ever stopped and is charged, he will absolutely have a reason why it wasn't possible for him. So it maybe gets some of the way there, and that's why I'm going to support it. But it's like drinking warm beer. Thank you.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator require to change their vote? The clerk will close the roll.
Ayes 26, noes 13.
Ayes 26, noes 13. The bill passes.
Senate Bill 708.
The gentleman again from Western Fairfax County, Senator Marsden.
Thank you, Madam President. I move that the bill pass. And speaking to the measure.
The senator has the floor.
Thank you, Madam President. With our switch, which is in progress, from people driving fossil fuel vehicles to driving hybrids and then fully electric vehicles, one of the concerns that we have had is that people are struggling with making the shift because of range anxiety. They don't know necessarily where they're going to be able to find a place to recharge their cars. And what this does is two things. It creates the driving decarbonization program, and the driving decarbonization fund, which what this will do is allow that 70% of a developer of a developer's non-utility costs for charging stations installed in historically economic disadvantaged communities in the Commonwealth, they can get 70% funding for that through the grant, and 50% funding for developers' non-utility costs for charging stations installed in any other area of the Commonwealth. The federal government is putting $5 billion into charging stations. They're going to be covering our interstates. We need to find the places where these things will work, where they will allow people to feel comfortable in terms of driving fully electric vehicles. And it's a matter of the money in the Appropriations Act this year, and that's still up for decision. But this creates the fund, and I urge you to support the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 26, noes 14.
Ayes 26, noes 14. The bill passes.
Senate Bill 727.
The senior senator from Fairfax County, Senator Sasslaw.
Thank you, Madam President. Tell you a few things about this Stadium Authority bill. Virtually every concept that, if you read the bill, that's in there has been in legislation before here in Virginia. We had the Baseball Stadium Authority, which passed in the 1990s when there was an attempt. And at the time, the city of Washington didn't have a baseball team, was to get one here. But these, the ability to recapture taxes, which is in this, was used in the bill such as the expansion of the Hampton Convention Center, the George Washington Hotel in Winchester, Hotel Roanoke, former Stonewall Jackson Hotel in Stanton. And they've been, along with various performance incentives. Second, and this is important to remember, this bill does not create any debt backed by the Commonwealth. There's no general obligation pledge. There's no moral obligation pledge. And before the Stadium Authority, which is appointed by the governor, before they can issue any bonds, the state treasurer has to certify that the state is not, and let me repeat this, not on the hook for any money whatsoever. No money out of the general fund. If, for instance, let's say they couldn't generate enough money to make the bond payments, that's between the football team, the Stadium Authority, and the bondholders. We have no obligation whatsoever. Third, it's pointed out there are no new state taxes are raised to pay for the stadium. A similar, and what they're building here is in addition to the stadium, it's almost a mini city with hotels, retail, residential. It's like I said, it's almost a mini city. In the other states, and they've done this in Atlanta, Dallas, Las Vegas, and Santa Clara, in a lot of those projects, state taxes was used. None are being used here. The only taxes the ones that we're going to see are the ones generated at the facility. There's two places. You have the stadium and the general campus. The Stadium Authority bonds, which they're authorized to issue up to $1 billion for 30 years, that's in the bill. They will be used only to pay for the stadium and the facilities associated with that, like practice field and things like that. The rest of the campus will run about $2 billion. That will be paid for by the owner of the team. No state money. As I said, the bill authorizes there's no money to be spent. It sets out the framework for how it'll be funded. All the money generated is new money that would not exist except for the stadium. And a majority of that money goes directly in the state coffers. And let me tell you this. They get to the football team, and the money ultimately goes to the Stadium Authority. The income generated by the football team, it's the players, the staff, everybody. The bulk of those taxes will go to pay off the Stadium Authority bonds, but a portion of that will still wind up in the general fund, and I will get to how much that is. And like I said, we've written the bill to build in a number of checks and balances to protect the state. And that to me was the most important thing, that we would, not have that problem. Now, with respect to the income taxes, as an example, the recapture part from the sports complex is as you know, our state tax essentially is if you reach 17,000, and I don't know any football player that doesn't get past that. But anyway, 4.25% is used to pay off the bonds, and the rest goes to the state. And when all is said and done, and they're using, how successful this concept has been in several other places, $60 million a year would be wind up in our state coffers. Okay, $59 million will be retained by the locality. They'll be getting that in the form of sales taxes and whatever else they have. And then about $34 million a year from the recaptured funds will wind up going to the Stadium Authority to pay off the bonds. And and the team has to stay there for 30 years. Okay, they can't move. So this is, I think, we've done a pretty good job of, protecting the state interest. Right now, my understanding is they're looking at two localities, Loudoun and Prince William County, and based on what I've heard, and it's, there's no definite statements yet, they're more interested in, I think, Prince William County and near that I-95 corridor. They're also talking, obviously, with Maryland and with D.C., but their current headquarters are in Loudoun County, and they just soon have the operation in Virginia. But anyway, at the end of the 30-year period, you're looking at $1.8 billion would be generated in Virginia taxes that would go into our coffers. That's, as I pointed out, that's $60 million a year. That's even after the team gets the recapture to send the money to the Stadium Authority to pay for the bonds. And also $1.8 billion by whichever locality they wind up in. So it's a great economic development project. With that, I would hope that the bill would pass.
Senator Newman, the gentleman from Bedford.
Madam President, speaking briefly to the bill.
The senator has the floor.
Madam President, this is the type of bill that I have rarely supported. As a matter of fact, just a few of you are here back when Disney's America tried to come, and that late night discussion was something else. I was in the House, and Clint Miller took that bill apart, and we did not pass that bill. That bill was an ability for Disney to reach into the Commonwealth's coffers and take the money out. Madam President, that is not this bill. And the reason why I am going to support this bill is that this is a different animal. This is a self-help bill. The senior senator from Fairfax has gone through it fairly well, but I want to add a couple more items to it. One, we have in committee excluded all non-football and performance-related tax entitlements. The other is that we've put in an amendment to this bill to say that even if you put on campus something that's selling these products on the internet, if you put an eBay center, for instance, on that facility, you cannot keep any of the taxes. Something that was very concerning to many of us early on was there was an eminent domain provision within the bill, and that eminent domain provision has now been taken out. The other one is, I think this is pretty critical, the senior senator from Fairfax talked about it. The Finance Committee has put a complete and utter kill switch into the bill. What that means is if the current team leaves in 12 years to go to Maryland or another place, basically all of the tax incentives end up dying. We also changed the bill to require that local discretion as it relates to zoning was back into place. The amendment we put on the floor also indicated that there would be the restrictions on sports bet, and none of that money will be going into the fund. Madam President, I've looked at what we first considered, and that is the Disney's America approach. There's no way I could support that. I've looked at what this is, which is a self-help program, as the senator indicated, much like what happens in Atlanta or what happened in Atlanta. We've put a lot of provisions on this bill to help make sure that money is coming back to the Commonwealth. As the senator indicated, not only is not one dime going to be written out of our coffers, but $1.8 billion is going to be coming in. That's a different type of program, Madam Chair. And I do believe there is still work to be done. I know the House of Delegates is planning to work on this, and I imagine the governor's office as well. But those are the reasons, Madam President, that I'm supportive of the bill, and I think that this makes sense for the Commonwealth of Virginia.
Senator Sorovell, the gentleman from Eastern Fairfax County.
Thank you, Madam President. Speaking to the bill.
The senator has the floor.
Thank you, Madam President. So back in 1992, when I was at school, we were going through a horrible recession, and somebody decided to propose taxpayers to fund, I think it was about $130 million towards a $160 million stadium at Potomac Yards. I remember back then I had a horrible reaction to it because the way our colleges were getting creamed and we couldn't get any money for school buildings, et cetera. That really made me angry, and that whole thing cratered. This is totally different. And I'm really excited about this for a couple reasons, but primarily because 2 of the 3 locations being looked at are in areas that I represent. And I'll just tell you that I when I was knocking doors back in 2015, I knocked about 8,000 doors down in Dumfries, and I cannot tell you how many people told me sort of the lack of sort of things to do there are around there. Like somebody told me that he has to plan 30 minutes either side of a movie to be able to get to a movie at the right theater because he has to drive so far. And since then, the Potomac Nationals left Eastern Prince William County, and there's just not nearly as many entertainment options. Prince William also has suffered because it doesn't have near the commercial development that Fairfax County has in terms of its tax base. And if either of the 2 locations in Eastern Prince William are selected for this project, it'll be transformational for the eastern part of Prince William County. Transformational. It will also, I think, create a real impetus to focus on investing in getting the metro to the location, which we need to really look at seriously. For those of you who have to go through the Occoquan bottleneck every day, we need to come up with another solution to get across the Occoquan River. It'll stimulate the Long Bridge investment, which is probably the most important transportation project in the Commonwealth. I serve on the High Speed Rail Commission with Senator Cosgrove and I think somebody else. But that Long Bridge is going to uncork passenger rail all across Virginia, all the way to North Carolina, Atlanta, and New Orleans. And a project like this, I think, would really serve to stimulate and move that along. And so I'm really excited about this bill, and I hope we can get it through.
The gentleman from Northern Chesapeake, Senator Sproul.
Thank you, Madam President. A question to the senior senator from Fairfax.
Will the gentleman yield for a question?
Yes.
Senator Sproul.
Madam President, I have 2 questions. First one, if I vote for this, could you get them to change that name?
Senator Saslaw.
I believe you may. It wouldn't have been my first choice.
Senator Sproul, further question?
Last question.
Senator Saslaw, will you yield? Will you yield?
Yes.
Yes.
Yeah.
Senator Sproul.
Thank you, Madam President. I heard you mention 2 locations and not being from that Virginia, the other Virginia. You mentioned 2 locations. I don't know which one is closer to Richmond. I don't know which one is closer. Senator
Saslaw.
Probably the one in Eastern Prince William, but it's. I mean, I'm not going to mislead you. That's still a pretty good distance from Richmond.
Okay, thank you, Madam President.
The gentleman from Lynchburg, Senator Peake.
Yes, ma'am. Thank you, Madam President. I rise to ask the patron a question.
Will the patron yield?
Yes.
Yes, thank
Senator
you.
Peake.
The senator from Fairfax, and I don't mean these to be hostile. I want to get some information so I'm clear. there will be a stadium authority that actually owns the stadium. Is that correct?
That's correct.
Senator Saslaw.
Madam President, I would say to the senator from Lynchburg, that's correct.
And then, Madam
Senator
President, who will own the property adjoining the stadium?
Senator Saslaw.
That will be the for instance, if a hotel goes in or a retail store goes in, the people that own the hotel or the retail store chain or whatever, that they would own that.
Madam President,
Senator
further
Peake.
question. How much money is projected that those private companies that are going to own the land next to the stadium are going to make in this 30-year deal?
Senator Saslaw.
Are you talking about in the framework of the rest of the campus or outside of that?
Madam
Senator Peake.
Yes, Madam President. In their development, and we're going to get, if the Commonwealth's going to get $1.8 billion over 30 years, and there's going to be a stadium authority that owns the stadium, the people who are developing all that land around the stadium, how much money is projected in these numbers that people are running, are they going to make in that 30-year period? Is there a projection?
No.
Senator Saslaw.
Okay.
What they've done is they've taken what's occurred, and that I think it may be called the Battery in Atlanta, Madam President, and they projected numbers off of that, and also off of what they I think are doing. They have a similar project in outside of Dallas.
All right. Then, Madam President.
Senator Peake.
McPike or McPeak, whichever, Madam President. Senator, is there any guaranteed amount of payment over those 30 years that would be coming in to the state?
Senator Saslaw.
I don't think there's any guarantee. I know there is no, Madam President, there is no obligation on the part of the state. For instance, let's say the whole thing just didn't generate enough money. That's between the bondholders, the authority, and the owner of the team. The state has no obligation whatsoever.
Madam President, thank you, Senator.
The junior senator from Richmond City, Senator Morrissey.
Would the senior senator yield for a question?
Will the senator yield?
Yes, ma'am.
Senator Morrissey.
Thank you, Madam President. I heard the senator clearly when he said that the state would not be taking on additional debt or incurring debt, and that the state was not on the hook. I understand that. These bonds that would be floated would be purchased by whom?
Senator Saslaw.
By citizens, groups, financial organizations, but no obligation on the part of the state.
Senator Morrissey.
Would the senator yield for another question?
Will the senator yield?
Do you envisage the Commonwealth of Virginia purchasing any of those bonds?
I have no idea. They could, I guess, if they thought it was a good deal.
Would the senator yield for another question?
Will the senator yield for another question?
Yes, ma'am.
Senator Morrissey.
So NFL teams move from time to time, and they have to do it with the permission of the NFL. The Oakland Raiders moved to Los Angeles Raiders, moved to Las Vegas. Los Angeles Rams moved to St. Louis and back to Los Angeles. What would happen? And I'm trying to look at the worst case scenario.
They can't move until the
Senator Saslaw.
Madam President, they cannot move until the lease is up and the bonds are paid.
Okay. All right. I thank the senator.
The gentleman from Chesapeake, the senior senator, Senator Cosgrove.
Thank you, Madam President. Would the senior senator from Fairfax County yield for a question?
Will the senator yield? Senator Cosgrove.
Thank you, Madam President. I'd ask the gentleman, I heard his retort about the name for the particular team. And I will tell you that those of us who have served in the United States Naval Service and are indeed commanders would like to know why you have a problem with commanders.
Senator Saslaw.
I just said it might not have been. I didn't have a problem with the previous name either.
Thank you. I thank the gentleman.
Senator Suderline, the gentleman from Roanoke County.
Thank you, Madam President. Will the senator from Eastern Fairfax yield for a question?
Will the senator yield?
I'll yield.
Senator Suderline.
President, I always enjoy every few years we get a new transportation tax increase through, and it was great hearing about how this is, all revenue positive for the Commonwealth. And then you got up and you told me about how it's also going to build these wonderful transportation projects. How much do those transportation projects cost? And is Northern Virginia currently in line for that money, or will that actually require new revenue?
Senator Sorovel.
I appreciate the senator's question. First of all, the Long Bridge, I think, is mostly funded right now. And to the extent there's anything left, I think there's probably some federal funds in the New Infrastructure Act to clean that up. In terms of VRE and the Long Bridge, I think that's already pretty much funded. I just thought this project might speed things up in terms of construction and getting it going. In terms of a metro extension, that's probably 20 years away because nothing's been designed or approved or put in anybody's comp plan, really. So that's years and years and years away. But I've seen some very some engineering cost projections with really large ranges, but nothing plus or minus like $1 billion. I mean, big ranges for Metro.
Senator Suderline.
So we were told that this proposal is for the next 30 years, and the Metro that we would hope that this would spur, we shouldn't expect for another 20 years. So I shouldn't expect any request for revenue for at least 20 years.
Senators Sorovel.
Madam President, it depends where they put it. One location's on the VRE, and the other one is on the western side of I-95, and it really depends which location they would pick. And but no, I think that should they pick the Potomac Mills location, we'll speed the Metro up, and then we can have a conversation about that when the time comes.
Further question?
I thank the senator for his answers. I have a feeling that time's going to come a lot sooner than has been suggested. Although whenever we find a bill that gets so many proponents speaking before any critics, it usually gives me some more caution.
Returning to the patron of the bill, the senior senator from Fairfax County, Senator Saslaw.
If there are no other questions, no one.
The senator has the floor.
As it's been pointed out, we drew this to protect the state. There is no obligation on the part of the state. They are totally protected from having to spend any money out of the general fund or any other purpose to build this. This is going to have to be done by private groups. And it's a huge economic development project wherever they decide. And it's money that we wouldn't have if we didn't do this. And when I can't remember any projects that we've had that generate this kind of money, and yet we didn't have to put up a nickel. So with that, Madam, I would hope that the bill would pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 33, noes 7.
Ayes 33, no 7. The bill passes.
Senate Bill 740.
The gentleman from Eastern Fairfax County, Senator Sorovel.
Thank you, Madam President. I move the bill pass and speaking to the bill.
The senator has the floor.
Thank you, Madam President. This bill basically directs DPOR's Community Association Ombudsman to put together a study to look at how we are currently inspecting and funding multifamily dwellings. It's a study that I've been talking to the Community Association Institute and some others because of what happened at Surfside down in Florida where 98 people were killed in a condo collapse. And most people probably didn't realize it, but there was another condo that nearly collapsed in Senator Ebbins' district that I'll be picking up in about a year and a half. But people were watching a Washington football game back in 1996 when the building shifted by 4 feet in a partial collapse. And this is a real problem that we need to make sure we're looking at these buildings and inspecting them correctly, and that our condo associations are saving enough money. And this will get to the bottom of that and get us some recommendations for next year. So I'd hope we'd pass the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 5.
Ayes 35, noes 5. The bill passes.
Senate Bill 742.
Gentleman again from Eastern Fairfax County, Senator Surville.
Thank you, Madam President. I move the bill pass and speaking to the motion.
Senator has the floor.
Thank you, Madam President. So this bill is basically a cleanup bill off the ceiling bill that we passed last year, and it basically does four things. Number one, the governor's amendments to the marijuana bill last year created this new process of automatically sealing marijuana convictions, but they called it expungement when it was really sealing. And so this corrects that terminology and calls the marijuana sealing and not expungement. So number one is that was that clarification, so we don't have incorrect terms being used and people don't get confused about what they got. Secondly, it says that any petition filed to seal a case will be sealed. Right now, any petition you file to expunge a case will be sealed. The bill we passed last year, sealing petitions are sealed, but expungement petitions are not. This makes them both the same. Number three, it subjects the data broker people to civil liability for publishing information about expungements. Right now, they only have that liability for sealing. And this allows them to get access to a list of expunged convictions, which they actually want. And the fourth thing it does is it makes the court-appointed attorney fund available to people who do expungements in addition to sealing. Right now, they only get a court-appointed attorney for sealing, but not expungement. So it basically just makes sealing and expungement the same, which is what we thought we did, and cleans up what the governor's amendment did. It's not really new policy from my perspective. It's more of a cleanup, and I would hope we could adopt the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The bill passes.
Senate Bill 745.
The gentleman from Eastern Fairfax County, Senator Surville.
Thank you, Madam President. I move the bill pass and speaking to that motion.
The senator has the floor.
Thank you, Madam President. This bill has to do with sort of more follow-up work on the marijuana bill that passed last year. It basically deals with people who were either convicted of marijuana-related offenses and are still imprisoned, or people who were convicted of a different crime and received a sentencing enhancement due to a prior marijuana conviction. Senator Lucas had a similar bill that got rolled into this, and I believe this identical language is in the bill we just passed a few moments ago, Senate Bill 339 by Senator Eben. But basically what this bill does is it says if you have a marijuana conviction and you're currently imprisoned, and that's all you have, you can apply for resentencing in front of the judge in which your case was heard. And then the judge can look at the fact that we legalized marijuana and then consider whether to resentence you or not. They don't have to, but they at least have that option. Then, if you were convicted of a different felony and you're currently in prison, but not a violent felony, those are excluded, and your sentence was enhanced because you had a prior marijuana-related conviction, you can apply to get resentenced or a different sentence via the parole board. So for cases that are not marijuana convictions but were enhanced by a prior marijuana conviction, you can go to the parole board and get looked at for that. And that's basically what the bill does. There's a lot of other details I can get into if we need to, but I suspect this will be worked out in conference and we'll be talking about it later. But that's what the bill does, and I would hope we'd pass it.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 17, Rule 36-1.
Ayes 22, no 17, Rule 36-1.
Senate Bill 704.
Madam President.
The senator from Fauquier, Senator Vogel.
Thank you, Madam President. Having voted on the prevailing side by which we passed Senate Bill 745, I'd like to ask that please be reconsidered.
The question is, shall the vote by which Senate Bill 745 passed be reconsidered? The Senate will come to order, please. Right. So, the question is, shall the vote be reconsidered? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The vote is reconsidered. Senator Sorovell.
Thank you, Madam President. Having previously explained the bill, I would move the bill pass.
The question is, shall the bill pass? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The bill passes.
Senate Bill 704.
The junior senator from Virginia Beach, Senator Kiggins.
Madam President, I move passage of Senate Bill 704 and speaking to the bill.
Senator has the floor.
Madam President, this is a school nurse bill that is not like the school nurse bills that we've brought in the past, but if everyone remembers last year, during COVID, we were pushing for a school nurse in every school in Virginia, but there was a lot of unanswered questions about, do we really need that? What type of nurse do we need? Registered nurse, LPN? What type of jobs were they doing? We needed more information before we can have a bill in its best form that would pass. So we asked the Board of Education to publish a report of just recommendations for what we could do to have these questions answered. And one of the things that the board provided in their findings was that we needed to make a survey that currently is a voluntary survey that each superintendent is asked to fill out annually. They recommended that we make this survey a requirement that they do annually, just so that we have answers to these questions. And the survey is not complex or complicated. I know in committee we spoke a lot about, was there a cost? No, there's not a cost. It's voluntary right now. We had 68% of all schools in Virginia actually do it for the last school year. So making it a mandatory report as opposed to voluntary, we'd like to have 100% participation. But the types of questions this survey asks, and it's about 50 questions or less, but it's, how many students have visited the clinic? Are the nurses doing medication management? Are they treating kids with concussions or chronic care management? Is there infection tracking and tracing? What exactly are these nurses doing? How many kids are they seeing? What level of nursing is providing the care? So having that information and asking each superintendent again to provide it annually in the form of this survey that already exists online would just help with our gathering of information, so that we could then go forward and put a good bill in place that we could get, if not a school nurse, some type of school nurse, some type of health services in every school in Virginia to be able to provide the best care. And with that, I move passage of Senate Bill 704.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, noes 3.
Ayes 37, noes 3. The bill passes.
Returning to page 23.
Madam President.
The gentleman from Tazewell, Senator Hackworth.
Madam President, having voted on the prevailing side, I move to reconsider the vote by which we passed by Senate Bill 313 for the day.
The question is, shall the vote be reconsidered? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll. Ayes 40, no 0. The motion is reconsidered, by which the bill was passed by for the day. The gentleman from Alexandria, Senator Eben.
Yeah, I have a substitute motion. Move to strike my SB 313.
Shall the bill go back today? We have a substitute motion to strike from the calendar, so just want to make sure you were in order. But the motion, well, no, we'll go to the substitute motion, which is strike from the calendar.
Chair recognizes the junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Madam President, this is the third iteration of the same thing. Can point of parliamentary inquiry.
The senator has the floor.
Before we can address the substitute motion, do not the Senate rules require that we address the motion that the Senator Senator Hackworth just made?
No, because we have a substitute motion, so that takes precedence over the primary motion.
Additional question, Madam President.
Yes, sir. The gentleman has the floor.
Thank you, Madam President. The motion to strike, is that a vote that goes on the board, just like a motion to pass by for the day? I'm seeing yes.
Yes, sir, it does.
Thank you. Speaking to the measure.
The senator has the floor.
Thank you. Folks, we know what's going on here. The first motion was to pass it by for the year, and then it was to pass it by for the day, and now it's to strike it. It's the same thing, to prevent the body from ruling on Senate Bill 313. I hope you put up a no vote for this. Thank you.
The gentleman from James City, Senator Norman.
Madam President, speaking for the substitute motion to strike the bill.
The senator has the floor.
Madam President, obviously there is a division of perspective on Senate Bill 313 as it relates to Senate Bill 391. But there are certain protocols and traditions and respect that we still retain in the Senate, and extending courtesies to colleagues regardless of what side of the aisle they may sit on. And one of those courtesies, Madam President, as long as I can recall, is that if a patron makes a motion to strike her or his bill, then we allow them to do that as a matter of courtesy. And I suggest to you that I think this is a protocol that we should continue to follow, because once you start breaking that tradition and that protocol, some unpleasant things happen. And so I would respectfully ask the body, just from a protocol and tradition standpoint, that we allow the senator to strike his bill.
The gentlelady from Richmond City, Senator McClellan.
Thank you, Madam President. Speaking to the motion.
The senator has the floor.
I'd like to echo the sentiments of the senator from James City and remind the body that I think it was 2, 3, 4 years ago where we had one of the most heated debates on this floor about this very subject, because at that time a Senate member's bill was hijacked, and we had a very heated debate over that because that bill was amended in a way that senator did not like. And the senator from Bedford gave one of the most passionate speeches I had ever heard. And even though I agreed with the underlying substance of the way that bill was, I voted to let that member strike their bill, and then had one of my own bills hijacked by the body across the hall at a moment when it was too late to reject the amendments, and we had the same debate, and that courtesy was given to me. Having served in both bodies, I've really come to appreciate the tradition of the Senate and the courtesy that we give each other as a family, because there are only 40 of us. And on the other side of the hall, emotions and passions get the better of them sometimes, and we have seen a degrading of decorum that I hope we don't see in this body.
Chair recognizes the gentleman from Bedford, Senator Newman.
Madam President, I don't think I can say it any better, but I'm really going to urge you to allow the gentleman to strike the bill. You know, I've been around a while. Some of you may remember when parental notification went to the other end, a big debate over there. But the traditions of the House of Delegates were upheld. I didn't like it, but it was the right decision to make. This body is different than the other body. During the last couple of sessions, the other body has cut off debate. The other body has not allowed the minority to be involved in the budgetary process, and they are weaker for it. Madam President, I would tell you that I don't think you get this back if you let this go. It's a tradition that is only as strong as every one of us decides that it is. We, on a routine basis, stand up and allow a bill to be reconsidered. Why? Because we are a collegial, decent body. That's why. There's no other reason why we do that. We do it because that is the type of body we are. I know this one is hard. And honestly, I know the gentleman from Richmond City is impassioned about it, and I understand it. And in a lot of cases, many of you know that I've taken votes that I wouldn't normally take to get us out of this mess, right? But I would hope that we find another way to deal with the issue that is before us, but that we allow the gentleman to strike his own bill. Thank you, Madam President.
Chair again recognizes the junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Madam President, would the gentleman from Bedford yield for a question?
Will the gentleman yield?
Madam President, I yield.
Senator Morrissey.
Thank you, Madam President. Does the gentleman realize that Senate Bill number 313 is actually my substitute, and the gentleman from Alexandria, by striking his bill, is actually striking my substitute in its entirety?
Senator Newman.
Yes, Madam President, in general terms, Madam President, I would say that you are in many ways correct.
I thank you, Senator.
But if you don't mind, I would even urge you, sir, to consider withdrawing the motion, and it's up to you, sir. I understand. But in fact, there is no way to parse that. When the bill that I spoke of earlier went to the House of Delegates on an item that I was pretty passionate about, it wasn't the bill that the original person had planned to bring. It was something that Senator Mark Earley, if I remember correctly, put on his bill and sent down there. And it was a long night. It was a tough night. But in the end, I think this is one that will help every single member and will help us as a body. So I hope that answers your question, sir.
I thank the senator speaking to the measure.
The senator has the floor.
Thank you, Madam President. And I'm sincere. I appreciate the senator's comments. I thought they were very genuine. It's not, he asked if I would remove my motion. I don't have a motion. There's a motion from the gentleman from Alexandria to strike the bill. And that motion was a substitute motion to, I believe, Senator Hackworth's motion. However, it boils down to this. I certainly agree with the traditions of the Senate being honored about allowing an individual to strike his own bill. And I've seen it for the last dozen years in both the House and the Senate. But that's not the same fruit here. It's my bill, my substitute, floor substitute, that is being struck in its entirety. It doesn't resemble the senator from Alexandria's bill that he originally put forward. And for that reason, I think it's two different things. We can still honor the tradition of the Senate while at the same time.
For what purpose does the senator from Virginia Beach rise?
Will the junior senator from Richmond yield for one quick question?
Will the senator yield?
I yield.
Senator DeSteff.
Madam President, Senator Morrissey, does the gentleman from the junior senator from Richmond realize that the underlying vehicle here that we're talking about, the true traditions of the Senate are on the underlying vehicle that we're referring to here, which is from the senator from Alexander?
Senator Morrissey.
I understand that the underlying vehicle lies with the senator from Alexandria.
Madam President, one follow question.
Will the gentleman yield for another question? Senator Morrissey.
I yield. I'm sorry, Madam President. I yield.
Senator DeSteff.
Madam President, does the gentleman from Richmond, the junior senator from Richmond, does he realize that the traditions we're referring to are for that underlying vehicle, which is put forward by the gentleman from Alexandria?
Senator Morrissey.
As I said a moment ago, I understand the tradition.
Madam President, thank you.
Senator Favola, the senator from Arlington.
Thank you, Madam President. I am speaking to the motion.
The senator has the floor.
Thank you, Madam President. I'm speaking to the motion by the senator from Alexandria to strike his bill. And certainly comments have been made that I completely agree with. And in the decorum of the Senate has been one of those elements that I think have allowed us to make very good policy and to act in the best interest of all Virginians, because we were able to come together and we have certain sort of rules of debate. And I just want to remind the body that the Senate Bill 313 is, in fact, the contents in the entirety of 313 is contained in Senate Bill 391. So for those that may be very interested in the content of Senate Bill 313, I will refer them to Senate Bill 391, which this body did pass in a bipartisan fashion. So I do hope we honor the motion from the senator of Alexandria. Thank you.
The question is, shall Senate Bill 313 be stricken from the calendar? All those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 38, noes 2.
Ayes 38, noes 2. Senate Bill 313 is stricken from the calendar. And finally, Senator Reeves, the gentleman from Spotsylvania.
Thank you, Madam President. Having voted on the prevailing side in which we passed Senate Bill 391 on page 9, I ask that that vote be reconsidered. I'm sorry.
The question is, shall the vote by which it passed be reconsidered? That is Senate Bill 391 on page 9. All those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. That vote is reconsidered.
Madam President.
The senator from Rockingham County, Senator Obenshain.
Madam President, having voted on the prevailing side, I'm sorry.
You're okay. The gentleman from Alexandria, Senator Eben.
Having previously explained Senate Bill 391, I renew my motion. The bill pass.
The question is, shall Senate Bill 391 pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. The bill passes.
Returning to page, I'm sorry.
President.
The senator from Rockingham County, Senator Obenshain.
Madam President, having voted on the prevailing side by which Senate Bill 727 passed, I move that we reconsider that vote.
What page is that, sir?
On page 27.
The question is, shall the vote by which Senate Bill 727 passed be reconsidered? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The vote is reconsidered. The senior senator from Fairfax County, Senator Saslaw.
Madam President, having previously explained the bill, I again move its passage.
Question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 32, noes 8.
Ayes 32, noes 8. The bill passes.
On page 31, uncontested calendar, Senate bills on first reading.
The gentleman, the senior senator from Fairfax County, Senator Saslaw.
Madam President, I move that all Senate bills on first reading, on the uncontested calendar and regular calendars, pages 31 through 33, Senate Bill 295 through Senate Bill 775, that the rules be suspended and the first constitutional reading of the titles be dispensed with.
The question is, shall the rules be suspended and the first reading of the titles of Senate bills on the uncontested and regular calendars, pages 31 through 33, Senate bills 295 through 775, be dispensed with? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The reading of the titles is dispensed with.
You read the title. You're reading it the second time.
Sorry, I'm lost in the high grass. Senate Bill 295, Behavioral Health Dockets, Responsibilities of Local Pretrial Services Officers. It has a committee amendment.
Senator from Bath, Senator Deeds.
Madam President, I move that the amendment from the Committee on the Judiciary be agreed upon.
The question is, shall the committee amendment be agreed to? Those in favor will say aye. Those opposed, no. The amendment is agreed to. Senator Deeds.
Madam President, I move that the bill be engrossed and advanced to its third reading.
The question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 290.
Because there's only two, we're going to go all the way through.
Senator Deeds.
Madam President, I move that we dispense with the third constitutional reading and pass this bill on to its passage.
Question is, shall the bill now pass? Is that where we're at? Dispense. Shall the bill now be shall the third constitutional reading be dispensed with? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The reading of the titles, the constitutional reading is dispensed with. Again, the senator from...
Madam President, I move that the bill pass. I'd like to speak to that very briefly, please.
The senator has the floor.
Madam President, ladies and gentlemen of the Senate, this bill comes from a General District Court judge in Augusta County. He wants to make sure that more of the people he sees have a chance to be enrolled in the behavioral health docket. And with the commission, the amendment you've just agreed to it will allow judges to send every defendant in General District Court to a screening process, through a screening process. Hope you'll pass the bill.
Question is, shall the bill pass? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Senate Bill... Senate Bill 296, sentencing proceeding by jury after conviction, relevant mitigating evidence, reported from the Committee on the Judiciary with amendment.
The gentleman from Bath, Senator Deeds.
Madam President, I move that the amendment from the Committee on the Judiciary be agreed to.
Question is, shall the committee amendments be agreed to? Those in favor will say aye. Those opposed, no. The committee amendments are agreed to. Senator Deeds.
Madam President, I move that the bill be engrossed and advanced to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading. Again, Senator Deeds.
Madam President, I move that Senate Bill 296 we dispense with the constitutional reading and that it be advanced to its passage.
The question is, will we now dispense with the third reading? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The third constitutional reading is dispensed with. Senator from Bath, Senator Deeds.
Madam President, I move that the bill pass, and I'd like to speak briefly to that motion.
The senator has the floor.
Madam President, ladies and gentlemen of the Senate Bill 296 puts back into the code language we deleted when we ended capital punishment last year in Virginia. The language we're putting back in the code has to do with it's an enumeration of without limitation of mitigating evidence a sentencing jury or with the amendment a sentencing court can consider. I hope you'll pass the bill.
Question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Regular calendar Senate bills now on second reading. Senate Bill 302, permanently incapacitated persons, natural guardianship, reported for the Committee on the Judiciary with a substitute.
Gentleman from Bath, Senator Deeds.
Madam Chair, I move that we agree to the substitute from the Committee on the Judiciary.
Question is, shall the substitute be agreed to? Those in favor will say aye. Those opposed, no. The substitute is agreed to. The gentleman from Bath.
Madam President, I move that we engross and advance the bill to its third reading.
Question is, shall the bill now be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading. Senator Deeds.
Madam President, I move that we dispense with the third constitutional reading and pass the bill on to its passage.
The question is, shall the third constitutional reading now be dispensed with? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill is engrossed in advance to its third reading. Senator from Bath, Senator Deeds.
Madam President, I move that the bill pass, and I'd like to speak briefly to that motion.
Senator has the floor.
Madam President, this bill ensures that in very limited circumstances, parents can take care of children who can't make decisions for themselves that have been determined either legally or by a community service board to be in that condition. Again, I hope you'll pass the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill passes.
Senate Bill 474, appeals bond, removes requirement for indigent parties to post appeal of unlawful detainer. Reported from the Committee on the Judiciary with a substitute.
The senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. I move that we adopt the committee substitute.
Question is, shall the committee substitute be adopted? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is adopted. Senator McClellan.
Thank you. I move that we engross and advance the bill to its third reading.
Question is, shall the bill be engrossed in advance to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed in advance to its third reading. The senior senator from Richmond City.
Madam President, I move that we dispense with the third constitutional reading.
Question is, shall the third constitutional reading be dispensed with? Those in favor will say aye.
Aye.
I'm sorry, this is a recorded vote. Running right through it. This is a recorded vote. Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The third constitutional reading is dispensed with. We're on passage. The senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. I move the bill pass. And speaking of that,
the senator has the floor.
I had a rousing 30-minute speech in favor of this bill, but I actually want it to pass. So the bill will treat all indigent litigants the same by allowing a judge to waive the appeal bond for unlawful detainer. It maintains current law that the tenant would have to continue to pay rent for the pendency of the appeal, and I move its passage.
Question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 23, noes 17.
Ayes 23, no 17. The bill passes.
Senate Bill 554, will contest presumption of undue influence. Reported from the Committee on the Judiciary with a substitute.
Gentleman from Rockingham County, Senator Obenshain.
Madam President, I move that the committee substitute be agreed to.
Question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Obenshain.
Madam President, I move that we engross and advance bill to its third constitutional reading.
Question is, shall the bill now be engrossed in advance to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed in advance to its third reading. The gentleman from Rockingham.
Madam President, I move that the third constitutional reading be dispensed with.
The question is, shall the third constitutional reading be dispensed with? Those in favor will say aye. Will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The reading is dispensed with. Again, the gentleman from Rockingham County.
Madam President, I move the bill pass. And speaking to the bill.
The senator has the floor.
Madam President, members of the Senate, this bill deals with the instructions that are given to a jury in an undue influence case. This is fundamentally the same as bill that passed out of courts last year, 13-1, and out of this body, 39-1. And basically, it provides that where a presumption arises that a will was procured by undue influence, a jury shall conclude that it was procured by undue influence unless it concludes that the evidence shows otherwise. Accordingly, I move its passage.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Madam President.
The junior senator from Virginia Beach, Senator Kiggins.
Madam President, having voted on the prevailing side of which Senate Bill 474 passed, I request that we reconsider that vote.
The question is, shall the vote by which Senate Bill 474 passed be reconsidered? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The reconsideration is before us, and so is the bill. The senior senator from Richmond City.
Thank you, Madam President. I guess the senator from Virginia Beach wanted the 30-minute speech, but I've already explained it, so I move the bill pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 23, no 17.
Ayes 23, no 17. The bill passes.
Senate Bill 669, Law Enforcement Employees' Alleged Wrongdoing, reported from the Committee on the Judiciary with a substitute.
The gentleman from Eastern Fairfax County, Senator Surville.
Thank you, Madam President. I would move the committee substitute.
Question is, shall the substitute be adopted? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is adopted. Senator Surville.
Thank you, Madam President. I would move the bill be engrossed in advance to its third reading.
Question is, shall the bill now be engrossed in advance to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed in advance to its third reading. Gentleman again from Eastern Fairfax County.
Thank you, Madam President. I would move that we suspend the rules and dispense with the third reading of the bill.
Question is, shall the third constitutional reading be dispensed with? Those in favor will say aye. Will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? Clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The third reading is dispensed with. Senator Surville.
Thank you, Madam President. I move the bill pass and speak to the motion.
Senator has the floor.
Thank you, Madam President. This bill got a root canal from its original version. It's very narrowed down. But basically, it makes Virginia law consistent with what law enforcement accreditation requires when people file complaints against law enforcement officers. It basically says that if a law enforcement agency has a website, they have to put certain information on their website, that if once somebody submits a complaint about an officer, they have to get a receipt showing that their complaint has been received. Then it requires law enforcement to advise them when the process has been finalized. And then if the matter is reopened, they have to let them know that, that the investigation was reopened. But I made a lot of changes to it to make everybody happy, and the bill should be in pretty good shape now. I hope the bill would pass.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 27, noes 13.
Ayes 27, noes 13. The bill passes.
Senate Bill 715, Injunctions Reviewed by the Supreme Court of Virginia.
Thank you,
reported from the Committee on the Judiciary with a substitute.
The gentleman from Fairfax City, Senator Peterson.
Thank you, Madam President. I move the committee substitute.
Question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. The senator from Fairfax City.
Thank you, Madam President. I waived the constitutional reading, and what do we even go to?
Engross in advancement.
Engross in advance to the third reading.
The question is, shall the bill be engrossed in advance? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed in advance to its third reading. Senator Peterson.
Thank you, Madam President. I would move that we waive the constitutional reading.
Question is, shall the third reading be waived? Those in favor will say aye. Will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The third constitutional reading is waived. The gentleman again from Fairfax City.
Thank you, Madam President. This basically reinstates what had been the rule on injunctions.
The gentleman has the floor
I'm
for
sorry.
passage.
Move the bill pass and speak to the motion.
Senator has the floor.
Thank you, Madam President. This will reinstate the rule under 8.01-626 that appeals of injunctions as well as immunity rulings will go directly to the Supreme Court. These would be any sort of what we call interlocutory appeals, so they're appeals that need an immediate determination. There's already a review in place that allows that to be reviewed immediately, so you wouldn't have to go through the intervening step of the Court of Appeals, but rather would go straight to the Supreme Court. I hope we will pass the bill. Thanks.
Question is, shall the bill pass? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 4.
Ayes 36, noes 4. The bill passes.
Senate Bill 746, Minors, Prohibition of Deceptive Tactics During Custodial Interrogation. Reported from the Committee on the Judiciary with a substitute.
Senator from Eastern Fairfax County, Senator Somerville.
Thank you, Madam President. I would move the committee's substitute.
The question is, shall the committee's substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The committee's substitute is agreed to. Senator Somerville.
Thank you, Madam President. I move the bill be engrossed in advance to its third reading.
Question is, shall the bill now be engrossed in advance to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The bill is engrossed in advance to its third reading. Gentleman from Eastern Fairfax County.
Thank you, Madam President. I move that we suspend the rules and dispense with the third reading of the bill.
Question is, shall the third constitutional reading be waived? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The third constitutional reading is waived. Senator Somerville.
Thank you, Madam President. I move the bill pass and speaking to the motion.
The senator has the floor.
Thank you, Madam President. This bill actually it's a pretty significant bill. It basically prohibits law enforcement from lying to children when they are investigating a crime and interrogating them. You may have heard of the Central Park Five, which was 5 juveniles who falsely confessed to a rape they did not commit. And that kind of thing happens more than you would think. In 1969, the United States Supreme Court held that the law enforcement are allowed to lie to anybody to try to get them to confess in a case. And that's really a problem when it comes to juveniles. And so basically what the bill does, it basically says that anytime a minor is in a custodial interrogation, that means they've been stopped in a car, they're in a police station, they're in a room, they're being interrogated by a law enforcement officer after they've been seized, that a law enforcement officer cannot use false information to try and get illicit response out of them. And then if they do, if the government can still try to use the evidence if they can show that the juvenile was not coerced into making a statement, but it puts the burden on the government instead of on the juvenile. And I would just note that false confessions account for about 35% of juvenile wrongful convictions. It's really a problem. Children's brains are not fully developed. They don't have the maturity to be able to sort of evaluate what's going on and that they're actually being falsely deceived like adults. And this legislation, similar legislation, is already passed in Illinois and Oregon. There's laws pending and bills pending this session in Utah, New York, many other states, and I would hope we'd pass the bill.
The question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 26, noes 14.
Ayes 26, noes 14. The bill passes.
Senate Bill 775, Real Estate Settlement Agents, Choice of Settlement Agent. Reported from the Committee on General Laws and Technology.
The gentleman from Accomack, Senator Lewis.
Madam President, I move that the bill be engrossed and advanced on to its third reading.
Question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading. Senator Lewis.
Madam President, I move that we dispense with the third reading.
Question is, shall the third constitutional reading be dispensed with? Those in favor will say aye. No, it's a recorded vote. Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The third constitutional reading is waived. Gentleman from Accomack.
Madam President, I move the bill pass, and speaking to that motion.
The senator has the floor.
Madam President, the body will recall that Senate Bill 775 was introduced just a few days ago by unanimous consent and considered by the General Laws Committee. It results from an opinion by the Bureau of Insurance regarding what is known as split settlements in real estate settlements, and frankly stood on end to that which we have assumed to be permitted under Virginia law for many, many, many years. And what it essentially means is that the settlement agent has to do all facets of the closing, and that there can't be someone else representing the seller and preparing the seller's deed and representing the seller's interest. And so this bill is designed to re-clarify the Bureau of Insurance's understanding of the law in Virginia, and therefore I renew my motion that the bill pass.
Question is, shall the bill pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill passes.
Regular calendar, Senate Joint Resolutions on third reading. Senate Joint Resolution 1, Constitutional Amendment, Qualifications of Voters and the Right to Vote. Second reference, reported from the Committee on Privileges and Elections.
The gentlelady from Hampton, Senator Locke.
Thank you, Madam President. I move that the resolution pass. Speaking to that.
The senator has the floor.
Thank you, Madam President. Senate Joint Resolution 1, the second reference, establishes that the sole qualifications to vote in the Commonwealth are being a United States citizen, at least 18 years of age, a resident of the Commonwealth, and registered vote in accordance with the requirements set out in the Constitution of Virginia. The amendment further provides that any person who meets those qualifications has the right to vote, and that such right cannot be abridged by law. The bill lifts restrictions on qualifications to vote for those who have been convicted of a felony or adjudicated to be mentally incompetent. Madam President, I move again that Senate Joint Resolution 1 pass.
The question is, shall Senate Joint Resolution pass? Those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 24, noes 16.
Ayes 24, no 16. The resolution passes.
Senate Joint Resolution 5, Constitutional Amendment, Fundamental Right to Marry, Same-Sex Marriage Prohibition.
The senator from Alexandria, Senator Ebbett.
Thank you, Madam President. I move the resolution pass. Speaking briefly.
The senator has the floor.
This was discussed at length yesterday when we discussed the bill that placed it on the ballot. This removes Virginia's ban on same-sex couples being married and puts us in compliance with Oberfeld versus Hodges of the U.S. Supreme Court ruling. Thank you.
The question is, shall the resolution be agreed to? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 25, noes 14.
Ayes 25, noes 14. The resolution is agreed to.
Uncontested calendar, Senate Joint Resolutions on first reading. Senate Joint Resolution 33, Election Governance Structure in the Commonwealth. J. Lark to review.
Senior
from the Committee on Rules with a substitute.
The senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. I move to waive the second reading.
The question is, shall the reading be waived? Second reading be waived. Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The second reading is waived. The gentlelady again from Richmond City.
Madam President, I move that the committee substitute be agreed to.
Question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Gentlelady from Richmond City.
I move that we engross and advance the resolution to its third reading.
Question is, shall the resolution now be engrossed and advanced to its third reading? Those in favor will say aye.
Aye.
Those opposed, no. The resolution is engrossed and advanced to its third reading. Senator McClellan.
I move that we waive the third reading.
The question is, shall the third constitutional reading be waived? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote?
Oh, sorry. Okay.
The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The reading is waived. The senior senator again from Richmond City.
Thank you, Madam President. I move that the resolution be agreed to, and speaking to that.
The senator has the floor.
Thank you. This is a JLARC study of the governance structure and financing of elections in Virginia. JLARC did a study a few years ago looking solely at the Department of Elections, but our elections are governed through a system of local electoral boards, local registrars. The department gives oversight, and this bill basically looks at the entire governing structure without duplicating what JLARC has already done to make recommendations on how we can modernize and strengthen that governing structure. I move the resolution pass.
The question is, shall the resolution pass? Those in favor will record their votes. No, it's a voice vote. So, those in favor of the agreeing to passage of Senate Joint Resolution 33 will say aye. Those opposed, no. The resolution is agreed to.
Senate Joint Resolution 66, Malnutrition Awareness Week, designating it first week in October 2022 and each succeeding year thereafter. Reported from the Committee on Rules.
The gentleman from Accomack, Senator Lewis.
Madam President, I move that we engross and advance this earth-shattering piece of legislation on to its third reading.
You've jumped 3 steps, Senator. That's pretty anxious, but We have to waive the reading.
I'm sorry. I was anxious to get there, Madam President. I will move that we waive the second reading of the resolution.
Question is, shall the second reading be waived? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. The second reading is waived. The gentleman from Accomack.
President, I move that we engross and advance the bill on to its third reading.
Question is, shall the resolution be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The resolution is engrossed and advanced to its third reading. The gentleman from Accomack.
Madam President, I move that we waive the third or dispense with the third constitutional reading.
The question is, shall the third constitutional reading be waived? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The reading is waived. The gentleman again from Accomack, Senator Lewis.
Madam President, I move that we agree to the resolution.
And speaking to that, sir?
I think it's fairly self-explanatory. Malnutrition is bad, and we want a we want a week to make everybody aware of that. So.
Question is, those in favor of agreeing to this resolution will record their votes aye. We'll say aye. Those opposed, no. The resolution is agreed to.
Madam President.
The gentleman from Rockingham.
Having voted on the prevailing side by which we passed Senate Joint Resolution 33, I move that we reconsider that vote.
The question is, shall the vote by which Senate Joint Resolution 33 be reconsidered? Those in favor of that motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 1.
Ayes 39, noes 1.
Are we finished yet?
The motion is again before us. Senator McClellan.
Madam President, I move passage of the resolution.
The question is, shall the resolution pass? Those in favor will say aye. Those opposed, no? No. All right. Let us have, because I know I'm going to realize I'm uncertain because of 8 hands. Therefore, let us record this vote. And so, those in favor of agreeing to this resolution will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The resolution is agreed to.
Supplemental calendar number 1. Senate bill with governor's recommendation. Senate Bill 739.
Senator from Enrico, Senator Donovan.
Thank you, Madam President. I'm going to yield to my co-patron, Senator Peterson, and we'll go through these very quickly.
The gentleman from Fairfax City, Senator Peterson.
Thank you, Madam President. I know the hour's late, and we've talked this issue about as much as you can talk an issue, but let me just briefly explain the governor's amendments, which were the subject of some discussion with the governor and myself and the senator from Henrico. The First Amendment obviously has to do with the emergency clause, which will make it effective immediately, but that's conditioned on another portion I'm going to get to. This, by the way, is the bill that will keep schools reopened for in-person learning 5 days a week, as well as it has the parental option on student masking that was in the last paragraph. Amendment number 1 is the emergency clause after instruction. Amendment number 2 is important because it has to do with the governor's emergency powers under Title 44. If you remember that all of this stuff with COVID-19 and the governor's restrictions and the public health orders all emanated under Title 44, and specifically it's Code Section 44-146.16, which speaks to, quote, a communicable disease of public health threat, which would seem to describe COVID-19 pretty precisely, and basically just states that the governor and the executive branch maintains all of their powers to issue public health orders and to declare states of emergency, and nothing that we are doing is going to affect that in any way. So that's an enactment clause, which I thought was pretty important, and we suggested that to the governor, and he agreed. The next portion is basically just stating that the effective date is March 1, 2022. As you can probably tell from my remarks, I would like this to take effect yesterday, but that's not going to happen, and I do believe that we're going to need a transition time for some of our Northern Virginia school districts and probably elsewhere in the state, just for no other reason that they can adjust to what will be a change. And that's why we added the March 1 adjustment date. Then the emergency, of course, is again, basically the crux of the governor's amendment. And I do want to speak to an issue that I know my colleague has raised and colleagues in my caucus have raised, and that is this issue of sunset clause. I think everyone, and I speak autobiographically, understands the frustration that parents have felt over the last year where children have gone back to school, and for every single day they've been in school, they've been required to wear masks, no matter the weather, the transmission rate. There's just been masks every day, all day that they're indoors. And I think the thought has been, well, we understand the frustration, but what if circumstances require us to basically require masking again? And I think the Title 44 amendment to some extent covers that. I think it does cover that, but let me just simply say we did have a dialogue with the third floor about whether or not to put a sunset clause on. They made a determination, or the governor made a determination. He did not want to do that because he did not want to fight this battle all over again next year or the year after. And I understand that. And so I understand some people were disappointed we weren't able to get that in, but at the end of the day, I feel like I'd rather move forward with this bill than move forward with no bill. And that's where we are. So I'm happy to answer any questions about these amendments. I think they're pretty self-explanatory. And again, I appreciate your patience.
Chair recognizes Senator Eben, the gentleman from Alexandria.
Parliamentary inquiry.
The senator may state it.
Are the amendments from the governor specific and severable?
That's not a parliamentary inquiry. That needs to be a motion.
I think you may have heard. I am told that that's not a parliamentary inquiry. That needs to be a motion.
Oh, a motion. I move that we take up Amendment 2 separate from Amendment 1 and 3.
Okay.
If you want to. I just want to be able to vote on 2 differently than I vote on 1
We're going to find out in a minute.
Yeah, asking it to be severed.
All right. So what exactly are you asking, Senator?
I'm asking if we can sever the amendments.
So we're going to take each amendment at one time, in separate motions.
Yes, please.
Is that right? Okay. So the first one, which would be which one, Senator?
Amendment 1. I don't care if you take 1 and 3 in a block. I specifically want to have a separate vote on Amendment 2.
So it's 1, 3, and 4.
All right. So then 1, 3, and 4 we're going to be voting on because you want to get.
Yes.
Okay. So 1. All right. So the question is, Shall the governor's recommendations 1, 3, and 4 be adopted? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. Those amendments are adopted. And now, Senator Eben.
Speaking to Amendment 2.
The senator has the floor.
I ask that we agree to it. It preserves the governor's authority to react to future public health crises.
The question is, shall governor's recommendation number 2 be adopted? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, noes 0. The governor's recommendation number 2 is also adopted. The senior senator from Fairfax County, Senator Saslaw.
Thank you, Madam President. I would inquire of the clerk, does that complete our calendars for today?
Yes, sir.
All right, then.
That's awesome.
6:13. Is there any other business to come before the Senate? Hearing none, the clerk will now report any announcements on the desk.
Today, Tuesday, February 15th, there are no meetings tonight. No meetings. Tomorrow, Wednesday, February 16th, the Finance and Appropriations Subcommittee on Public Safety will have a work group meeting at, 7:30 a.m. in the Senate Leadership Conference Room, 6th floor, Pocahontas. Senators Lucas, Norman, Ruff, Edwards, Peterson, Marsden, and Eben. The Women's Legislative Roundtable will meet at 8:30 a.m., Tidewater Room, 4th floor, SunTrust Center. The Committee on Finance and Appropriations will not meet. This is a schedule change. Finance and Appropriations will not meet. Democratic Caucus will meet at 11 a.m., Senate Room 1, Capitol. Republican Caucus will meet at 11:30 a.m., Senate Room 2 in the Capitol. Have a great evening.
Madam President? Madam President? Over here.
The gentleman from Loudoun, Senator Bell.
Thank you, Madam President. Just wanted to announce the General Assembly Military Veterans Caucus meets at 8 a.m. tomorrow morning. It's room 2, 5th floor in the Pocahontas building.
The chair now recognizes the gentlelady from Portsmouth, Senator Lucas.
Thank you, Madam President. Madam President, I move that the Senate do now adjourn until 12 noon tomorrow.
Question is, shall the Senate adjourn until 12 o'clock noon tomorrow? All in favor will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The Senate stands adjourned until 12 o'clock noon tomorrow.